morning, everyone, and welcome. There are about 2 to 3 more people in line, and so we are going to go ahead and start, and they will join us. Thank you for joining us for the board's oversight hearing on railroad demurrage and accessorial charges. I look forward to hearing directly from our stakeholders today and tomorrow about these very important issues, including the impacts caused by carriers' reductions in so-called free time before charges begin to accrue, each carrier's process by which shippers may dispute charges, newly established congestion charges, and impacts of the board's 2014 decision in EP 707, demurrage liability. At the onset, I want to acknowledge and express my sincere appreciation for the stakeholders' participation and preparation for this hearing, shippers and railroads alike. The written comments and exhibits are extensive and illuminating, and the degree of public participation in this room and as far as the written comments that we have received underscores the importance of the issues that we are considering during this hearing. As you know, the board closely monitors trends and developments in the rail industry. During my time on the board and during my tenure as chairman, I've been particularly focused on rail service reliability. Sometimes the rail network is impacted by extreme weather conditions, sometimes by changing market conditions, and sometimes by the implementation of new operating plans. And what affects a particular railroad or railroads also affects shippers and the national network in turn. Regardless of what may be causing an impact, I believe that a continued focus on rail service is an overarching responsibility of the board. As the sole economic regulator of the U.S. rail industry, the board has oversight over competitive and commercial issues. During the last several months, I have heard from many of our stakeholders, as my colleagues have also heard from many of our stakeholders, about the Class 1 railroads' demurrage and accessorial charges. I've heard about new charges, modifications of existing charges, increased charges, and changes to enforcement practices and relief policies. Shippers, receivers, and in particular, third-party logistic providers explained that costs arising from demurrage and accessorial charges have become increasingly significant and in some instances have curtailed or even foreclosed business opportunities. Shippers have questioned the reasonableness of these charges, whether they are fair and whether they take into account reciprocity. And some are very frustrated by suddenly receiving significant bills, which they must painstakingly review for accuracy, and then in many instances devote additional resources to correcting improper or inaccurate bills. One stakeholder told me that his company resorted to hiring a forensic accountant to try to sort out the charges. Railroads, on the other hand, have assured me in meetings with CEOs and COOs and many others, and in written correspondence, that demurrage and accessorial charges are fair and reasonable and serve larger purposes related to the efficient use of assets and network fluidity. I have asked the Class 1s to disclose to the board the revenue they derive from demurrage and accessorial charges. The board is tracking that data, and it is made available to the public on the board's website. While the carriers generally argue that the revenue generated are a very small percentage of overall revenues, around 3% for some, we will also hear today from many shippers about how the sudden skyrocketing demurrage bills are impacting their small businesses. The board is mindful of the fact that issues related to demurrage and accessorial charges have come to the forefront at a time when the railroad industry as a whole is experiencing sustained and robust profitability, and many Class 1s are adopting new operating plans to enhance efficiencies, reduce costs, and improve operating ratios. The industry is in a far different place than it was at the dawn of the Staggers Act. Today and tomorrow are an opportunity to delve deeply into these issues, to clarify various aspects, and to hear whether each carrier individually expects to make any changes based on what can only be described as an outcry from customers. We will also consider actions that the board may take following this hearing. The written testimony has been particularly informative and compelling, and I appreciate that many witnesses have offered the board constructive proposals for future actions. And I will say that we have all read your testimony. It was quite an undertaking, but it was fascinating and insightful, and thank you for your effort to provide that to us. I will now turn to my board member colleagues to share their opening remarks, and upon their conclusions, I will briefly go over a few ground rules for the hearing. I'm delighted to be joined by Patrick Fuchs, our new vice chairman, he'll be chairman soon, and Marty Oberman, our new distinguished board member. And thank you so much for your interest in all of the board's work, and particularly the issues that we're considering today. Thank you.
So thank you to our chairman, Ann Begeman. I greatly appreciate all your leadership on this issue, and I'm really grateful for all of your efforts to get the data the board needs to conduct thoughtful oversight. This is our first hearing as a board of this group of three, and I think we formed a great team tackling the important issues before us. Thank you to each and every person who submitted written testimony and who has joined us here today. Your insights are essential and your time is valuable. I couldn't agree more with Ann. The written testimony was extraordinarily illuminating, and I expect our discussions in the room today will only bring more light. So as we begin today, I first want to stipulate that demurrage and other charges can be useful for maintaining an efficient rail network. Incentivizing expeditious loading and unloading can free up cars and capacity. The concept is not new. Demurrage has been explicitly codified in our statute for decades, and the history dates back over 100 years, including use to address car shortages at the turn of the 20th century and during World War I. The question is not about demurrage in concept. The question is, and has been, about implementation. And certainly, implementation has changed. And industry has changed. Since the turn of the 20th century, since World War I, since 4-hour and staggers, since last month, since yesterday. The recent changes in implementation have been significant, and the concerns raised by customers have been significant. Today, I'm eager to learn more about these concerns, which were previewed well by the chairman. And as a backdrop, I want to emphasize two things. First is the role of technology to potentially attenuate demurrage and accessorial issues on the front end, particularly the improvement of supply chain visibility so customers can have better information for planning orders, managing their operations, and ensuring charge accuracy. Second is the best practices of rail carriers. Just as it is important to hear about what is not working, it is important to hear if anything is working. Any reasonable credits and flexibility, notice, tools for real-time information, carrier response deadlines, and other practices. So, as you said, Ann, today is about constructive solutions to improve implementation and create a better rail system for everyone, including everyone in this room.
Thank you very much. Marty?
Thank you. Excuse me. Thank you, Ann. Good morning, everyone. Very, very briefly, first of all, I want to congratulate Ann on her leadership in bringing this hearing about and the entire process, as well as everything else that she's been leading us on since in the last 4 months since Patrick and I arrived, as well as what happened before. But it is a very dynamic institution, and I think that you can see by having brought you all here together that we mean to grapple with serious issues facing the board. There's really no reason for me to get into the substance, because if I'd had the patience to prepare a more formal statement, I would have said exactly what Ann and Patrick said, and so I appreciate your having done it, but I agree with them totally. And I do want to add my own personal thanks to the industry, all parts of it, for all of the hard work you've done to submit your materials to us. They have been invaluable. I view this proceeding as an opportunity for us to gather facts as well as opinions and policy ideas. And as the hearing goes on, if the questions seem pointed, don't take them personally. They're an effort for us to ferret out information and make sure we get a full understanding from everybody involved here. But I do expect that some of you may think the questions are a little too pointed, but nevertheless, we really need to get at what's going on. So with that, let's begin. Thank you.
Thank you. Now for the hearing instructions. We want to hear from everyone today and tomorrow, and to allow that to happen, we will ask the parties to stick as closely as possible to your allotted times. We recognize that this is not always going to allow you to say everything that you want to say, although we have read everything that you wrote. But again, we just want to make sure we have a chance to hear from everyone. Each witness table is equipped with lights, which will guide you regarding your allotted time. They're just not on yet. 1 minute before your allotted time expires, a yellow light will appear. When you see the red light, your time has expired. Please conclude your remarks. It's not my intent to cut any of the speakers off when the red light appears, but please try to wrap up quickly thereafter. A video archive of the entire hearing will be placed on the board's website within a few days of the close of the hearing. For the benefit of the video recording, please speak clearly into the microphone. We will keep the record open for 14 days until June 6th after the conclusion of the hearing to allow for the filing of any additional written comments. If you have slides or exhibits today that have not already been filed, please submit them promptly to the board's Office of Proceedings in the EP 754 docket. Whether or not we take a short break for lunch today will depend on how things go this morning. We have to be out of the building by 7. I'm not sure if the air conditioning shuts off at 5. That might help us finish it up quicker. But we want to hear from everyone, and so we may just have to plow through without a break. Please silence cell phones. And I also want to thank the folks at ITC, particular Bill, Terrell, Cynthia, for allowing us to use this amazing facility and for their assistance over the last days helping get us set up. Thank you, Terrell. And with that, we will start with our first panel. Thank you very much. Terry, if you'd like to start.
Absolutely. Absolutely.
Find the mic up.
There we are. Good morning, everybody. Chairman Begeman, Vice Chairman Fuchs, and Commissioner Oberman. My name is Terry McDermott, and I serve as the Director of the Rail Supply Chain at Bunge North America in St. Louis, Missouri. It is great to be here this morning. First of all, I would like to commend the board for the decision to schedule this hearing. The turnout alone, as it's already been stated, is an illustration of the importance of these issues for the shipper community. And it's going to be an informative day for all of us. So Bunge is a global agribusiness and food company and a leader in grain trading and food processing. Our operations across North America extend from southern Mexico to northern Canada, consisting of 5 canola processing facilities, 9 soybean processing facilities, 8 wheat mills, 8 corn mills, and 47 grain handling facilities. Excluding our joint ventures, Bunge moves roughly 150,000 rail cars annually, paying the railroads approximately $425 million per year. We also own and or lease over 9,000 rail cars, mainly consisting of tank cars and hoppers to move vegetable oil and meal protein products for animal feed. Our rail car leases represent an additional $60 million per year. Our facilities touch all 7 North American Class I railroads and dozens of short-line railroads. The railroads are paramount to our company's success, given the immeasurable value that they provide to us. Before I start, I would like to take a moment to recognize the Union Pacific Railroad and the Burlington Northern Santa Fe Railway for their recovery efforts during the flooding in the Midwest, which primarily occurred in March. Bunge has facilities throughout the Midwest, including several around Omaha and Kansas City. As a result, our facilities and employees were impacted by the flooding. We commend the railroads for their prompt and safe service. The response of these railroads helped minimize lost production and disruptions to our supply chains. Thank you. So I've been looking forward to this hearing for some time. Not only does this hearing give all stakeholders the opportunity to address issues in a public, transparent forum, it is also important from our standpoint that we be able to do so in the presence of our partners at the railroads. We have discussed these issues directly with them on an individual basis, and we think it would only be appropriate to do that publicly as well. The railroads are a fundamental partner to our industry. Many of our businesses, frankly, could not thrive or survive, for that matter, without them. We are fortunate in North America to be able to benefit from the most robust freight rail transportation system in the world. A transportation network that has evolved and literally been reborn since Staggers. We are also fortunate to have a network system whose players have continually reinvested capital and growth capacity and technologies. And we are also fortunate to have relationships within these organizations at all levels that extend far beyond transactional business exchanges. We do feel, however, that this relationship between shippers and railroads has been changing as of late. With the recent evolution from what we will call traditional railroading towards what is now commonly known as PSR, or one of its many monikers, call it a unified plan, clean sheeting, etc., the roads are becoming much more rigid in their service offerings and processes. And this can be stressful to that relationship. We understand that operating a lean railroad means, amongst other things, optimizing crews, optimizing power, optimizing rolling stock, people, and other resources. And when PSR works, it works. But when it fails, and the impact on shippers is exacerbated. And more often than not, shippers end up paying the price. When the roads miss, it translates to more costs for the customers, costs that can come in the form of overtime, lost production, lost sales, default penalties on contracts, and costs that can also come in the form of what brings us here today, railroad demurrage and accessorial charges. So my comments today are geared toward the lack of reciprocity in today's demurrage and accessorial tariffs, with more of a focus on the demurrage side. The reality is that these tariffs are changing frequently, and we are not convinced that they are changing correctly. Today's demurrage rules are especially disconcerting, even more for the private car shipper. While this may be an oversimplification, demurrage rules were originally put into place to protect the investment that railroads made in their rolling stock by incentivizing shippers to efficiently move these cars so the railroads could maximize the utilization of railroad-owned rolling stock assets. I think we all, railroads and shippers, as well as the rest of the players in the supply chain, we all want to maximize our asset utilization. Yet we have, in fact, seen demurrage rules change over the years, including recently, but the rules fail to reflect the changing portfolio of fleet ownership in the North American network. So recall in the 1980s, the railroads owned the majority of the North American rail fleet. Today, non-railroads now own roughly 70% of the fleet that moves freight in North America. And the governing rules for the protection of the investment made in these cars have not evolved accordingly. As a result, they no longer serve their initial purpose to protect the investment made by the car owner or lessor by encouraging the effective use and distribution of the nation's railcar fleet. The rules that exist today are not reciprocal in nature, as they protect railroad investments in rolling stock, not shipper investments in rolling stock. So to illustrate that the rules are not balanced, let's consider an example. While the railroads either charge a shipper for railroad-owned equipment that dwells excessively on shipper or receiver infrastructure, as well as shipper or receiver equipment that dwells on railroad infrastructure, there are no rules in place that reciprocate when railroad cars dwell excessively on shipper-receiver infrastructure, or when shipper-receiver cars or private cars dwell excessively on railroad infrastructure while in transit between building release and actual or constructive placement. To explain why this is significant, we took a snapshot as an example, and recall that at Bunge, we manage a fleet of roughly 9,000 private cars. So we took a snapshot on the 1st and the 15th of every month from this year leading up to May the 15th. So on the 1st and the 15th, on these random days, we had the following number of cars and the following dwell time days on the railroads between billing and placement on averages. We had, on average, 416 cars that had dwelled for at least 3 days. We had 259 cars that had dwelled for at least 4 days. 163 had dwelled for at least 5 days. 126, at least 6. 97, at least 7. 88, at least 8. 77, at least 9. And we had 67 cars on average on the 1st and the 15th of every month, January through May 15th, that were dwelling in the custody of the railroads for 10 or more days between billing or release and actual or constructive placement. So that's a clear example that the demurrage rules are in no way reciprocal. In this example, a shipper has no recourse, and as a suggestion, we think we could simply apply the rules that exist today in favor of the actual car owner or lessor. As it pertains to accessorial charges or fees charged independent of the actual freight invoices that we pay as shippers, we believe that these are unbalanced as well. I can illustrate this with some clear-cut examples, some of which the non-railroad shipper may not be aware. So the railroads and the shippers have common objectives, since for the most part, we are largely publicly traded companies. We want to create value for our shareholders, but we think the railroads may have lost sight of the affected shareholders within the value chain, and our goal as companies is to efficiently and successfully make a profit within those value chains. So some semblance of balance, however, must be present when one driving player wields an unbalanced proportion of the market control than those represented collectively by those being served. To better illustrate my point, some quick examples. In 2018, we had an individual rail car lost on a Class 1 railroad for 121 days. So a normal transit time of 7 days turned into 121 days, and we claimed that railroad for car hire relief, and it was denied. We received zero compensation, and the only comment we received is that service is not guaranteed. Another example, in a specific lane that consists of one single origin, one single destination, and a consistent rateable demand of a 25-car shipment every 2 weeks. This particular Class 1 railroad failed to place empty cars for several days and ended up placing 2 empty units within days of one another, almost back to back. This obviously caused congestion and demurrage at the destination yard, and we were told by that railroad that we were not going to be guaranteed any credit days or any compensation towards the demurrage bill that was headed our way. 0 credit days, or 0 free days, that are now being offered on loaded and unloaded cars on railroad infrastructure will invariably cause shippers to incur demurrage or private car storage costs, even when the shipper, the receiver, and the railroads perform perfectly. We have done extensive modeling with this, and we have reviewed this model with the railroads. I will just say the response from the railroads up to this point is inconclusive. The burden of proof for demurrage and accessorial charges is also on the shipper. We are regularly assessed finance charges if disputes are erroneously denied. As an example, in the case of railcar diversions, when a request is actually accepted, which requests are not always accepted, we are automatically invoiced whether the car is actually physically diverted or not. The railroads also charge us reconsignment fees. Reconsignment fees can be for any errors that need to be corrected on way bills or bills of lading, even when the railroad suffers no operational impact. However, we also receive erroneous paperwork from the railroads, and when they send us duplicate or erroneous invoices, which in our case happens several hundreds of times per year, we cannot reciprocally apply the same feedback to them that they apply to us. A couple more examples that are not necessarily demurrage or accessorial related, but I think they're worth mentioning for flavor. Upon negotiating a rate contract for a lane that has 2 Class 1 options, one of the Class 1 railroads submitted a clause in the proposed contract giving them the ability to unilaterally cancel the rate contract on 30 days' notice. When asked why this was the case, the railroad responded, "With this comes from our legal team, and we basically do it to limit risk, and also because we can." Another example, similar, negotiating a contract with another Class 1 railroad. This particular Class 1 railroad insisted on an indemnification clause that forced us to fully indemnify them, even in the case of railroad negligence. We pushed back. When we pushed back, the railroad responded by saying, "That is just the price of admission for you to be on our railroad." Last example, in 2017, after a derailment that involved several of our private cars, the railroad in question did reimburse us for the cost of the actual rail cars. but they denied the claim on the product that was in the rail cars. When we inquired about this, they stated that the claim was not valid on the product and that the mechanical group had nothing to do with the product claims group, and that the claim was not justified on the product. This matter, in all transparency, it did get resolved. It had to be escalated several levels, and it was finally resolved 18 months later. So these are just a few of the examples of the challenges that shippers encounter when working with the railroads. Quite frankly, the railroads may need a nudge, if you will, to remind them that they do have customers to serve, and in many scenarios, customers do not have another rail option. Yet, as I mentioned at the outset, we have long-term relationships with our partner railroads, and we frankly cannot exist without them. We just feel that the relationship has changed a bit as of late, and we think it is critical that they incorporate more balanced terms to the demurrage and accessorial tariff items. So our ask today, and I know you're going to hear a lot of testimony with a lot of asks, but our ask is that over the next day and a half, that the board consider testimony from all parties, railroads, shippers, and others to ensure that the rules governing rail transportation represent and protect the interests of all parties in the supply chain and their respective investments, which have changed over the past couple of decades. Specifically, we feel that the current demurrage rules that exist for railroad equipment should be applied in some way, reciprocally, to account for the shift in ownership of the North American rail car fleet from railroads to non-railroad ownership. The rules that exist today do not protect the investments made in the North American fleet. They only protect the railroad investments made in the North American fleet. And with that, I will conclude. Thank you.
Thank you, Terry. Ben?
Good morning. My name is Ben Abrams, and I serve as the President and CEO of Consolidated Scrap Resources, Incorporated. I first want to thank the board for holding this hearing on changes to railroad demurrage rules and practices. I appreciate the board's efforts to better understand the impacts of these changes and the challenges rail customers are facing. CSR is a privately held fourth-generation scrap steel, metal, paper, and plastic recycling company with 6 locations and approximately 140 employees in South Central Pennsylvania. We use rail to ship scrap raw material feedstock to steel mill customers. And due to our geographically widespread customer base, we are regular users of and highly dependent on rail service. Our Harrisburg, Pennsylvania location is on a direct rail line operated by Norfolk Southern. We ship scrap steel products to numerous mills located east of the Mississippi River, almost exclusively in private rail cars that we pay to lease. In recent years, unilateral changes by Norfolk Southern to their business practices have created unprecedented challenges and cost our company an increasing fortune each year. First, we are paying increasingly more and more money to NS, particularly for demurrage assessed on our private cars, without gaining any measurable benefit to our company. Second, we have determined in good faith that we cannot alter our operations and shipping schedules or make additional investments to accommodate these unilateral changes by NS and make them expense neutral to our company. And third, we have not been able to address our problems through commercial arrangements and cannot avoid the impacts since we are sole served by NS at our Harrisburg facility and do not have an alternative to shipping our products to the customers we supply by rail. In our case, Norfolk Southern, but really all the Class 1 railroads that are implementing their versions of precision scheduled railroading, have imposed blanket changes to tariff rules to all customers, with no legitimate consideration of the disparate effects such applications would have. We believe the board should require the railroads to establish reasonable, commercially fair, and reciprocal demurrage rules that do not unfairly penalize their customers, both financially and operationally. Moreover, these demurrage rules should take into consideration individual customers' unique circumstances and limitations. While this obviously would require considerably more work for the carriers, and more importantly, more communication with their customers, it is the least they can do if they want to collect fair and reasonable demurrage fees on large and small shippers alike. Based on their submissions for these hearings, NS and the other Class 1s would have us believe that their improved metrics are evidence of that their tactics are working and acceptable, and really their changes to the demurrage tariff are okay. But judging from the turnout by the customers at these hearings, it certainly appears that things are most definitely not okay. To be clear, we don't demonize or blame the Class 1s for trying to become more efficient operators and improve their asset management. All businesses want and should do these things, and we are happy to hear that the Class 1s are operating more efficiently, particularly this year. But changes that are happening due to PSR are not happening in a vacuum. Many customers, including us, struggle to adapt quickly to accommodate the railroad's demands. We are severely financially penalized with demurrage charges because a railroad wants to operate more rigidly and efficiently and expects shippers to simply follow along, even though that may not be possible, at least on the railroad's timeline. For many years, in general prior to 2012, when we entered into our first small lease for private railcar gondolas, we mainly used NS-owned railcar equipment to ship our products and paid a higher shipping rate to NS for that benefit. Since that time, and particularly after 2014, procuring NS rail equipment for our shipments became increasingly difficult. Often we would order cars and they would not be available. And we came to learn over time that NS was both reducing the number of system cars available in general and in particular to scrap steel shippers. Our customer account manager told me at that time that we should not look for NS to supply the same number of gondolas they previously did, as they could use what gondolas remained for more profitable products. By the latter part of 2017, rarely would we ever receive the requested railcar equipment from NS. As a result, over the years, we had to enter into additional long-term private railcar leases to replace railroad equipment that we could not rely on from NS to receive. The most difficult situation over the last 24 months, however, has been the unilateral move by NS to progressively reduce and now essentially eliminate empty private car storage credit days. Beginning in August 2017 with the announcement in NS Tariff 6004/D, NS began to gradually reduce the number of credit days for customers' private rail cars from 5 to eventually 0 for each constructive placement as of January 1st, 2019. And this was very unfortunate news for us. After years of relying on the credit days to plan for capital investments, operations, shipping strategies, and overall product marketing, NS was informing us that they were changing the rules. There was no method or system in which to discuss the challenges that we would face trying to adjust and the impacts they would have on our business. Indeed, at the time, we did not fathom the degree to which the financial burden of shipping our products in private rail cars that we paid a lease would increase. CSR's demurrage paid to NS has increased dramatically over the last several years. From 2015 through 2017, we paid Norfolk Southern, on average, between $1,500 and $2,700 per month for demurrage. In 2018, the average monthly demurrage bill for our company was over $11,000, a 560% per month increase over the average monthly cost in 2017. When I filed our written testimony with the board earlier this month, data through the first quarter of 2019 showed our average per month demurrage cost was in excess of $23,000, more than double the average monthly cost in 2018, and more than 1,000% greater than our monthly cost in 2017. And over just the last week, we received yet another demurrage invoice for approximately $68,000. With this new invoice, our year-to-date demurrage invoices from NS through the end of April 2019 have exceeded the total demurrage we paid them in all of 2018. And our 2019 monthly demurrage cost is now more than triple the average cost last year. NS serviced our Harrisburg yard 5 days a week until January 2019, when we received notice that they would service this location 7 days per week. Yet NS reduced the number of credit days over the course of 2018 and still charged us demurrage on weekends when they did not provide service. And prior to 2017, we had 5 credit days to offset those weekend day demurrage charges. Further, our operations in that plant for decades have been designed around a 5.5-day work week schedule, including Saturday mornings. Demurrage charges that result from bunching rail cars is another problem. We have often received many more cars at a given time than even NS will spot. Bunched cars cause an increased workload for our staff, and we need to encourage additional costs to clear the congestion. Otherwise, we're assessed with more demurrage charges. We have considered how we can adjust our facility and operations to avoid incurring demurrage fees, but concluded that the operational changes and additional investments are not viable. Our Harrisburg facility contains numerous fixed internal roadways and systems of large stationary processing equipment. The rail tracks inside the facility were laid decades ago and are also today fixed in their current locations. We can within the facility only up to 10 gondolas at a time. Redesigning the plant to help materially avoid demurrage charges would be cost prohibitive. Even if we could bring more cars onto our property, we still get only one spot of rail cars per day from the railroad, and additional staffing is not economic or practical. In the scrap industry, as for other commodities, revenues rise and fall depending on the demand for our products, which in addition to seasonality, impacts shipping volumes. We do not control this phenomenon. And notwithstanding the rise and fall of the price of our materials, rail costs seem to move only higher. Normally, when one pays for a service, one would expect to receive some benefit in return, and that is what is most frustrating in all this. We have not had any benefit from paying these huge cost increases from the demurrage tariff. No one from NS ever came to us and said something like, hey, look, we know we have basically pushed you into entering into long-term leases for your own gondolas and improved car turnarounds, but we want to make changes to get those cars to move off our tracks faster. What's a reasonable solution that works for you and us so that this change would be fair to both of us? And it's hard to imagine that NS considered the ramifications of how their blanket imposition of this new tariff to take credit days away, which have been in place for many years and around which businesses like ours made long-term strategic plans and commitments, would impact individual customers. They never spent the time or did the due diligence about the disparate impact their tariff imposition would have. NS simply imposed the tariff unchecked, demanding that after doing business a certain way for years, customers now have to substantially reconfigure their operations or pay huge penal charges to the railroad. Providing 0 credit days for shippers who use private rail cars is unfair and too rigid, since the railroads control when a car is constructively placed for the shipper to load. Providing shippers with some flexibility, maybe 72 hours, to request their private cars be spotted for loading once NS constructively places the cars could be a part of a reasonable accommodation to shippers. Recent data provided by NS to the board indicates that NS's 2019 annualized demurrage billings, based on first quarter numbers, are on track to exceed 2018 billings by 65%. In real dollar terms, they stand to gain more than $60 million for demurrage than they did last year. And I'll just wrap up. There are many individual companies in this country with predicaments like CSRs vis-a-vis the rail carriers. The application of these new demurrage tariff rules is having an unreasonable and disparate impact on those customers' finances and operations. We want to work with the railroads to help them become more efficient, but not at the expense of watching them rake in huge profits while shippers struggle and pay to continue to operate their businesses as they have in the past. Thank you.
Thank you. Joshua?
Good morning, Chairman Begeman, Vice Chairman Fuchs, Board Member Oberman. My name is Josh Etzel. I'm the Vice President of Operations of Kinder Morgan Terminal's Northern Area. First, I want to thank you for holding this hearing and allowing me to appear today on behalf of Kinder Morgan. We have submitted detailed written testimony describing the problems we are experiencing with respect to the railroad's demurrage collection practices, specifically to our role as receivers, which is a serious issue of growing concern. I'll attempt to summarize our key points over the next 15 minutes. Kinder Morgan's testimony focuses on the board's 2014 demurrage liability decision. The railroads are exploiting that decision in a manner that we believe was unintended by the board, alleging that decision creates a form of strict liability on receivers for demurrage. Kinder Morgan respectfully submits that this matter needs to be addressed immediately by the board through a declaratory order or other appropriate actions to reverse or clarify the 2014 decision in order to restore uniformity and equity in demurrage collection practices. Today I'd like to summarize the situation facing Kinder Morgan and discuss some recommended fixes. Kinder Morgan is a major North American terminal operator that transloads and stores essential commodities for its customers, including some of the largest shippers in North America. We have 157 terminals in the U.S. and Canada. We transload and store various liquid and bulk commodity products for more than 4,700 customers. Many of our terminals are rail-served. In 2018, Kinder Morgan handled and transloaded well over 100,000 manifest cars and 1,500 unit trains in North America. In evaluating the assessment of demurrage on terminal operators such as ourselves, it is important to understand what Kinder Morgan does and does not do. Kinder Morgan provides a very, very simple service. We provide transloading and storage services for customers, but we do not own product and we do not own rail cars. Kinder Morgan also does not initiate the shipment of loaded cars or the receipts of empty cars. The customers, who are the shippers of the commodities and are responsible for paying the transportation costs,
arrange the transportation, bill and tender the shipments, and in combination with the involved railroads, direct deliveries. Kinder Morgan has contracts and commercial relationships with these customers and shippers, but we do not have that with the railroads. Kinder Morgan generally has very limited visibility and control over shipments and timing and volume. We do not control or have visibility over billing, tender, movement, interchange, pickup, or return of empty rail cars. Also, we do not have control or visibility over shipper forecasting systems and train and rail car movement systems to monitor shipments. These matters have been and will continue to be under the exclusive control of railroad and shippers. Generally, Kinder Morgan does not have the information on the location or status of rail cars until the rail car is actually received and available at the local rail switching yards or in our open gate facilities until that car actually shows up in our terminals. We typically can only affect the movement of cars at this very late stage of the movement chain. Therefore, railroad claims that rail receivers such as CAM have full visibility and control over the volume and timing of railroad deliveries are simply unfounded. The genesis of the problem facing Kinder Morgan with railroad demurrage is the board's 2014 decision, Demurrage Liability number 707. I'm not a lawyer. It's my understanding this decision was designed to address a split in circuit court decisions on the narrow issue of whether a consignee listed in the bill of lading without consent could be held liable for demurrage charges. As we discussed in our written testimony, the railroads themselves at the time agreed the new rules were only needed to resolve this narrow conflict and were not needed to disturb the long-standing requirement that receiver liability rests on something more than just merely receiving the commodity ships. In order to address the narrow court conflict and create more certainty, the board determined that demurrage liability should rest not on the bill of lading but on pertinent conduct. While the railroads strongly supported the board's narrow approach, in practice the railroads have treated demurrage liability much differently. In fact, demurrage is now imposed upon receivers without any predicate showing a fault. Furthermore, the adoption of precision schedule railroading has exacerbated the problem. Many of the increased demurrage efforts have been brought about by precision railroading. As indicated in the railroad submissions to the board for this hearing, these new programs and increased charges have produced rapid, high-profit revenue gains for the railroad industry at low or zero cost. Kinder Morgan received virtually no demurrage invoices until after the board's 2014 decision. Since then, and increasingly in recent quarters, we have received invoices totaling over $14 million, without any material changes in our operations or rail traffic volumes. While the strategy of precision railroading to reduce costs, cut services, and boost profit may be working for the railroads, it is certainly degrading service quality and placing certain significant demands on the receivers we had not been used to seeing. In the aftermath of the 2014 decision, the railroads have revised their tariffs in various respects, with one similarity in that they are all one-sided. The demurrage tariffs lack balance and reciprocity, reasonable dispute resolution mechanisms, and any incentives for railroads to provide efficient service to meet the needs of shippers and receivers. And there are 6 different aspects to this. First, carrier tariff seeks to make receivers solely responsible for demurrage charges. An example in this is CN's optional service tariff, which now assigns demurrage strictly on receivers even when they're not at fault. Not long after issuing its new tariff, CN filed a collection action against Kinder Morgan seeking substantial demurrage charges at our Argo terminal in Chicago. That litigation is ongoing, and CN now claims that's an $8.4 million owe. Second, the carriers contend that they are not required to seek demurrage charges from anyone other than the receivers. The railroads then refuse to enter into voluntary 3-party agreements with shippers who both agree and request to be invoices and paid demurrage directly. Imposing strict liability on receivers negates any incentive for efficient operations by shippers as well. Those shippers recognize the liability will fall by the railroad's precedent solely on the receiver. For example, a shipper into our Perth Amboy terminal in New Jersey recently held out more than 60 tank cars at the local switching yard, allowing Kinder Morgan to only request in 2 cars due to the customer's preferences and its assigned tanks being full. The customer, not Kinder Morgan, tendered and shipped the rail cars with full knowledge of the likelihood that substantial demurrage assessment would follow. Nonetheless, CSX assessed demurrage solely on Kinder Morgan, amounting to over $10,000 in daily demurrage charges. Thirdly, railroads are aggressively imposing demurrage against receivers without establishing cause or fault. Railroads have eliminated long settled demurrage defenses from their tariffs. They're now assessing charges against receivers even when the cars are placed on non-working tracks, the carrier bunches rail cars, the carrier misses or improperly performs switches, they deliver the wrong cars or deliver them late, they fail to pick up cars on a timely manner, and probably most importantly, their failure to recognize that their delivery creates a ripple effect on charges that follow, causing other cars that were in the system to await delivery to incur additional demurrage charges due to the internal carrier service failure. Here's a situation where performance impacts the ability for demurrage to be collected both in the short term, but then creates more demurrage for every subsequent move. Fourth, carrier tariffs seek to impose discriminatory fees and other targeted unreasonable practices. These lead to unjust penalties against receivers while creating economic windfalls for carriers. Another example, with the CN, Tariff 9000 imposes daily demurrage charges in Chicago that are 1.5 times greater than anywhere else in the CN system. Additionally, they recently increased their common carrier tariff by more than $300 per car for ethanol shipments only into one facility, but not at the other Chicago locations. Fifth, the railroads are assessing demurrage against receivers even after implementing embargoes on traffic receipts and establishing train permit programs. For example, since September of 2018, CN has embargoed all inbound shipments of ethanol to Kinder Morgan Argo. The CSX and NS have issued similar embargoes in the Northeast and created carrier-controlled permit systems restricting inbound shipments to the New York Harbor complexes. Even with the carriers in full control of the train and car movements, through their embargo and permit, we still receive demurrage invoices. Sixth, the carriers have implemented a number of additional one-sided demurrage tariff provisions, including decreasing or eliminated free time or credits, applying railcar demurrage even on non-switching days, and imposing unreasonably high interest rates without establishing any valid basis in the underlying tariff or otherwise. These unbalanced tariff provisions further demonstrate they're designed not to create efficiency, but rather to augment revenue. Also, the carrier demurrage tariffs are not reciprocal. No relief is available where demurrage results from railcar delay is attributable to carrier performance, third parties, or other factors outside of control of the receiver. CN's submission for this hearing states, when railcar deliveries are delayed, CN personnel will review relevant information, such as contemporaneous crew reports, to determine whether demurrage charges are appropriate before charges are billed to our customers. To the contrary, CN has stated in our pending litigation that it does not review the invoices for service issues before being sent. The carrier tariffs also lack provisions to reasonably address and resolve disputes. The railroads send numerous pages of computer-generated invoices each month that fail to identify the individual shippers associated with the shipment. Reviewing each of the numerous line items for billing and car errors imposes significant costs and burdens on receivers for compliance, review, and objection. In summary, the railroads have exploited the board's 2014 demurrage liability decision through one-sided material changes in tariffs, highly aggressive demurrage assessment and collection practices, coinciding with the implementation of precision railroading. There's no reciprocity and no mechanism to address and resolve disputes reasonably. In these cases, Kinder Morgan is a true middleman who does not own commodity or control transportation, and we are unable to take our business elsewhere to avoid demurrage charges. The railroads are fully using their destination monopoly powers at the local level. The effects cascade as the railroads now allege strict liability under the board's decision, leaving Kinder Morgan with little choice but to sue our own customers, effectively doing the carrier's dirty work for them. The board's 2014 demurrage liability decision has increased disputes, incented even more imbalanced carrier practices, and created more uncertainty, exactly the opposite of what we believe was intended. So to address these things, the harsh and what we believe are unintended effects of the decision, and to restore balance and equity to this demurrage assessment system, Kinder Morgan respectfully requests that the board take actions to remedy the situation immediately by adopting specific tailored requests that we put forth in our written submission, revised rules as necessary, policy guidance, and directives. First, we ask the board to address the harsh and unintended effects of the demurrage liability decision. Kinder Morgan believes the decision should be reversed or at least clarified. At a minimum, immediate guidance should be provided to clarify that prior to assessing demurrage on a receiver, a railroad should be required to establish a legal foundation for liability, and that delays are the sole fault of the receiver are not attributable to the carrier or other factors outside the control of the receiver. Second, we ask the board immediately clarify that if requested by a shipper and a receiver, A carrier shall agree to bill the shipper directly for demurrage and not require the receiver to assume responsibility for unpaid demurrage assessments as a guarantor or condition of such agreement. This important matter has gridlocked reasonable discussion and resolution of individual disputes. This will allow receivers to use their commercial contracts as intended. Third, we ask the board should immediately incent the railroads to adopt more balanced and reciprocal tariffs. It can do so by clarifying a carrier demurrage tariff will be deemed presumptively unreasonable if it seeks to establish liability solely on a receiver, if it fails to provide for sufficient free time and credits, if it fails to provide for adequate reciprocal provisions affording the receiver for relief, including where the railroad fails to meet their performance requirements, if it includes unreasonable interest charges, and also if it fails to include reasonable dispute resolution mechanisms. And I think it's important for us to mention, we ask that the board establish a demurrage dispute resolution program, which shall, at the election of any party, establish expedited settlement conferences between railroad shippers, receivers, and ongoing disputes. Kinder Morgan will be responsible for the liabilities that we create, but we want to be part of the solution that allows us to be spread equitably across the entire supply chain and let blame fall where it should. Kinder Morgan believes that these discrete changes will help fairness and uniformity in demurrage and are responsible and necessary to address the situation. This concludes my remarks. I'm happy to respond to any follow-up questions the board may have.
Thank you. Frank?
Thank you for the opportunity to speak to you today on behalf of Olin Corporation. My name is Frank Carumble, and I am the Vice President of Global Supply Chain for Olin's chemicals businesses. Before I begin, Chairman Begeman, I want to thank you and the board for your leadership in forming the Rate Reform Task Force, which resulted in the recent STB staff report examining the need for rate reforms. Olin stands ready to support you as this work moves forward. Olin is one of the world's largest, or is the world's largest chlorine and chlorine derivatives company. You encounter our products, most notably chlorine and its co-product caustic soda, on a daily basis, as they are used in thousands of applications such as water treatment, disinfectants, pharmaceuticals, paper and aluminum manufacturing, electronics and wind energy applications, refrigerants, and many others. We lease and own a large fleet of chemical tank cars and make over 47,000 rail shipments per year. Olin has one of the best safety records when it comes to rail shipments, as exemplified by the fact that we have received the AAR's Grand Slam Award 3 years in a row. Rather than read my entire testimony, or written testimony, I would like to briefly review the most important points and answer any questions you might have. The railroads have implemented changes in demurrage and customer cost congestion charges to change customer behavior, their words, ostensibly in support of precision scheduled railroading. Regarding demurrage, all free days have been eliminated. If we don't move cars off the railroad's track on the same day the cars are placed, demurrage charges begin. Notice for the customer cost congestion has gone from 14 days to 5, meaning now we only have 5 days to address the congestion charges where the charges begin. And even if we address the congestion issue, the clock doesn't reset. The railroads can begin charging for congestion immediately if it occurs again. When you look at what causes congestion and bunching of cars, the railroads themselves are in large part to blame. Inconsistent transit times and the tendency to bunch returning empties frequently create situations where we cannot physically receive into our sites all the cars that show up in a single day. In addition to Olin, the product mix of returning cars is extremely important and critical. As I mentioned previously, we produce the co-products chlorine and caustic. The ratio of production is 1 chlorine car to 2 caustic cars. You cannot produce one without simultaneously producing the other. Last year, we experienced a situation where we had to significantly reduce rates at our largest rail shipping site due to not having the proper returning ratio of cars. When finally corrected, we had lost the equivalent of 6 full days of production during a period of high demand, which resulted in lost sales. Of course, during this time, cars were stacking up outside our plant, but it wasn't Olin's behavior that needed to change. In fact, Olin makes every effort to assist the railroads in keeping cars moving in their system. We are staffed 24/7, and we stand ready to move cars onto our sites when placed. We routinely move full and empty cars to off-site private storage yards while paying the railroad extra switching fees to do this. We pay to help them. Given the new demurrage and congestion tariffs, Olin expects to incur over $1 million in additional costs, in fees paid to the railroads, in storage costs, and in transportation costs. I emphasize this is incremental to the fees we were previously paying. In addition, Olin maintains an oversized fleet to deal with the service inconsistency and disruptions so that we can adequately serve our customers. We have been evaluating $10 million of on-site track projects at our various sites that would allow us to store more cars on site and better manage this larger than should be necessary fleet. These tariff changes just add to the pressure to implement these projects. So let me summarize. The railroads have implemented PSR. They have increased tariffs for demurrage and customer-caused congestion. Their operating ratios and profitability have improved as they desired, but Olin is seeing increased costs and the same marginal service. So what are we recommending? Regarding demurrage and free days, I need to point out, as was said earlier, that demurrage was designed to compensate the railroads for shipper use of railroad-supplied cars, not for when the shipper supplied the cars. The railroads have been charging for shipper-supplied cars and systematically reducing free days. We recommend that you restore the number of free days to 2. While there are times when even this is insufficient for shipper sites to manage bunching outside their fence lines, we feel this is a reasonable time frame for both sides. Secondly, restore the customer congestion notice period to 14 days and reset the clock each time the shipper successfully addresses the congestion issue. This span covers 2 weekends, the period when rail service is usually curtailed, and it allows shippers sufficient time to correct the problems. Third, allow shippers to move empty cars to storage without charging switching fees when this is being done to help the railroad efficiency. And finally, Olin operates in a competitive environment. The railroads do not. Olin must maintain competitive service and price to stay in business. The railroads have no such pressures. Therefore, we respectfully ask the board to exercise its authority to oversee demurrage and congestion charges and to continue its work on rate reform. This is necessary to level the playing field between shippers and railroads. Thank you again for the opportunity to speak to you today.
Thank you, all of you. What my colleagues and I are going to do is we are going to not time ourselves or to each have our own 5 minutes, but rather we're going to just ask questions and kind of round robin to try to keep things flowing and collegial, of course. So turn your microphones on. But the first question I'd like to ask is just a question really to the panel. One of the things that the board has heard about, certainly since I've come to the board, is the concept of retaliation. And so when a couple of folks overheard me saying this, when we announced the hearing, I did pause wondering whether anyone would show up besides the railroads who we asked to show up. And I'm just curious, and you all have been in your industries and your business for a number of years. I'm curious to know whether or not you were contacted by your carriers, and maybe, Joshua, you're kind of in a different situation because you're not technically the shipper. One other thing I would like to know is, well, I'll let you answer that question first, whether or not and I will say, because the last listening session that I attended, I learned later that every single participant had been contacted by the carrier in advance of the hearing to not come.
And
Potentially.
In Olin Corporation's case, that no one contacted us about specifics of this hearing.
Same.
We were not contacted either.
And Terry, I want, for some folks in the room, since I've been around a while, I've had the benefit of knowing quite a few people in this room and outside the room, and I've gotten to know Terry over the last 8 years in various different settings, and all professional, I might add. And Terry, you used to work for a railroad, and so I'm wondering if you could provide some insight as to when you were on the other side of things. I mean, demurrage and accessorial charges, they do serve a purpose, and the board has held, and the ICC, I mean, for many, many years and many proceedings, the board, the agency considers issues such as this every now and then when really necessary. And I'm just curious, for the demurrage charges and practices that were going on at the time that you were at a railroad, were things moving efficiently, or was it, we really need to raise our rates, and perhaps you weren't quite in that sphere of the charges, but I'd just like to know, are things moving differently, and shippers need a nudge?
Well, and it's already been stated, Vice Chairman Fuchs mentioned it at the outset as well. I don't think we are trying to refute the idea that demurrage serves a purpose towards increasing productivity. There are mixed opinions in this room as to whether demurrage and accessorial charges are a revenue generator, or viewed as a revenue generator, or not. I guess I would venture to say that I think that, in my experience, on the railroad side, we were very aware of the contribution that came from demurrage and accessorial charges. Now, I have been on the shipper side of things for the past 7 years, and I cannot speak on behalf of the roads or what goes on within the roads, but I can say to your question, as to my experience, yes, we were very aware of both the contribution of what demurrage and accessorial charges meant to our bottom line, and at the same time, we were very aware of what they meant for our operation in terms of asset utilization.
Thank you.
I want to kind of hone in a little bit on a couple points that were raised in terms of cars being late in transit, and as well as the overall idea of bunching, or when you order 5 and 5 cars and then 15 come on the last day. Can you maybe talk a little bit about how railroads establish kind of an estimated time of arrival, or ETA, for loaded, and then how railroads establish kind of a window of time for delivery for empties, and what your knowledge of that is?
We only really load, for the most part, we load empty cars. So, and as I said, they're all our private cars at this point. So they're all coming back to basically the origin from where they were shipped. We get some indication of, it's once they hit, I guess, the certain hump yard, when they're going to arrive at outside our plant. Sometimes they stick to that, sometimes they don't. I would say probably before 2019, when service got a little faster, the ETAs didn't necessarily mean a whole lot. Maybe they would arrive that day or the following day, or the ETA would get pushed back. But it's hard to, eventually they're going to come over outside the plant, and they're going to sit there until we can bring them in.
Right.
We're limited by the number of cars we can bring in
Sure.
on a daily basis. So it's just something we don't control, and we lease a certain number of cars, I think, to be able to give us, the ability to ship whatever we have in a given week or month. And then we probably have some cushion on top of that. So it's, if the railroads are going to move the cars faster and change them faster, it's going to really impact how many sit outside, our plant and for how long.
But, it was talked about that cars kind of arriving late. So, the implication for something arriving late is that there was a time that it was supposed to arrive and then a time it does arrive. So, what does it mean to say that a car is arriving late? What was that initial time? You know what I mean? How do you know what that initial window is that a car was supposed to arrive and empty?
Well, I'll just say first, there's usually something on, on the website that gives you an ETA.
Right.
And that, the ETA can change. So that's
When
really,
something's in movement.
right. I mean, or something doesn't move from one yard, from one railroad yard to the next railroad yard. And they'll just adjust the ETA.
So if there was a window of time or an ETA that a car or an empty was supposed to arrive, and then let's say as a hypothetical, it arrived 10 days later than you were expecting. And of course you have to be ready to load, and you have to have crew ready, and you have to have a plant ready to load. Maybe it's continuous, maybe it's on a weekend. When something arrives 10 days later than it ought to, what is the credit system that railroads give you? How do they credit you for those 10 days?
I'm not completely familiar with that component, but I think the credits work more for when you want to order cars in once they're constructively placed if they're not brought in. But I could be, there may be more to it than that.
Yeah.
I was just going to comment to the question about how do we know when something's going to be late. There's a steady flow, at least in our business. We're a 24/7 operation.
Right.
A steady flow of cars coming back, and we're continuing. We get visibility. Railroads provide visibility where those cars are, but it's really the next 2 days out that only then does it become firm. You may see a slug of cars coming back a week out, but as Ben mentioned, things change, and so it's not until the day before, couple days before, that we know really how many are coming in. And sometimes it's more than we can take based on what's going on with the outbound cars and what we're doing on the site. And I don't know that I can comment on the credit either, but I don't know that we get any credit when a car's late. I will have to get back to the people that I know the answer to that, but I'm not sure we do.
Sure.
Yeah, I would expound on that. I mean, the answer is, an attempt at the answer is that, first of all, it's not uniform across all roads, right? I would say that, so there are some exceptions to where some of the roads recently are trying to apply a credit due to a missed ETA, whether it's 2 days or 5 days. But in most cases, you don't get credit. As a private car shipper, when a car becomes empty and you are trying to plan your pipeline across your entire footprint, the teams are constantly looking at empty flows and how are they coming back to the plants. The first view that you get of that is when that car becomes empty and is either reverse routed or empty billed back to another origin. Now, from that day until the plant makes it back to the origin, that ETA can be adjusted. Now again, this is not uniform. But you can, say for a 14-day transit, if a car is going to be late, the last time you see an ETA in that car in the systems, the ETA will have been adjusted. So our teams constantly go back and say, okay, we have a new ETA on this bunch, or we have a new ETA on this car. But in terms of what credit do we get because of that late delivery, for the most part, nothing.
Okay.
That's the answer.
And so, if something is, several days later than you're expecting, or the steady flow is disrupted in some way, kind of the bunching phenomenon, generally there may be something initial, but generally nothing. And then so kind of conversely, if you all were to say, not return an empty by the time that the railroad is expected, or hold it for a number of days, are you all then charged on a per day basis?
If we ask the railroad to detain, as in this example, on an empty return, I don't know if we have that option.
I don't know.
But if you're taking longer to load and unload, you're getting charged on a daily basis.
Yes.
And so when you all are talking about reciprocity, is that what you mean by reciprocity, or part of what you mean by reciprocity, which is in that bunching phenomenon, if there are a number of cars that don't come basically in the window that you were expecting, or at the arrival time you were expecting, that those cars for each of those days won't, or will basically get credit the equivalent of if you all were to take more time to load and unload, and you get charged on a daily basis. Is that an aspect of kind of the reciprocity that you think ought to be present within demurrage charges?
I would say, Vice Chairman, it's one aspect of reciprocity where there's a dialogue between all parties to say there's a fault associated with this. How are those credits then applied?
Right.
There's also reciprocity that obviously we'd like to examine where we are experiencing as receivers of costs for things that don't show up. We have crews scheduled, cars don't show up. We have credits that are applied erroneously across different customers. We need to make sure that they're applied to the right customers. And it comes from a dialogue. So a dispute resolution process where the shipper, the receiver, and the railroad can all discuss, okay, the blame falls in one of these three buckets, we'll apply it as such, and it creates a level playing field between all the parties.
And how easy is it on your end to establish railroad fault? What's the visibility you have in terms of what, and so if you were to present kind of an evidentiary case, what's the burden that you all have in the availability of evidence?
Vice Chairman, in our case, it's very difficult to show it on a long-standing basis because we don't have visibility on cars until they're literally at the last mile. From that point, we can say, all right, the railroad missed the switch. There's secondary and tertiary effects for the subsequent cars that should be applied. But it's a complicated process, and one that involves a dialogue with a lot of information being managed. And I think what we're seeing now is demurrage charges are just essentially leveled at a receiver and saying, figure it out. Pass it to your customer. If they don't pay because they dispute, it's on you to pay. And we want that process to be one that's functional between all the parties.
There is one metric I can think of that could be used, and we have visibility on returning car transit times, and you could argue whether what's typical is acceptable, but there are typical transit times, and if those transit times are unusually long, in my mind, that would be evidence that we could show that at times when the railroads haven't performed as they normally do. And those are the situations where in our 24/7 continuous chemical process, we have to turn down our plants when the cars don't show up. So, but that would be the only thing.
Deviation from the expected transit time.
Yeah. We know that cars from that location should be here in a week. We're counting on it. We're keeping our rates up, and all of a sudden they're not there.
So I just want to ask a couple of questions about, I guess, the complexity of some of the tariff changes. As you know, the carriers provided the board with a list of some of their more recent changes, and some of them were more voluminous than others. And I'm just trying to understand, like, how does a shipper keep track if you have, Terry or Frank, I'll pick on you since you're served by more than one carrier, particularly you, Terry, you're served by all of them. And they change fairly frequently. Of course, you are given advance notice of, I believe, 20 days. But how do you keep track? And is it to a point where, is it just that suddenly there have been a lot of changes because of operational changes and updates? And I know NS has articulated real clearly that although they've had a lot of different demurrage charges, tariffs on the books, they had not been enforcing them. So much of this also is about enforcement. But are we to a point where there needs to be more uniformity, given that the whole purpose of, the statute is that demurrage and accessorial charges, or at least demurrage charges, are to promote national assets, and do we need some type of uniformity?
I think that should be considered, and I don't think that is a bad idea. It is hard to keep track. It is hard to keep track with the frequency and by road, and with in some cases, the interpretation of what the actual tariff means and when it applies. There is a certain level of ambiguity as to when and how some of these tariff items will be charged, and it could be argued that there is a certain level of subjectivity as to whether they apply or not. So yes, I would think that we'll hear lots of testimony today, but from our viewpoint, I would not be opposed to a uniform, standardized system across the network.
Yeah, I think uniformity is probably important, but I mean, we're still not addressing the bigger issue here. This is a one-way street. I mean, we're, quote, trying to be incentivized through financial penalty to do something. In many cases, we can't do any better than we already are. And so, you know, that has to be rolled into the concept of reciprocity, I think.
Actually, if I can interrupt, and I think both you and Ben, it's like, all that really seems to be happening, like, you would change if you could, but you're certainly you're constrained by your own infrastructure. And I think what your testimony said and what you also said here is that really the only impact has been you've gotten a lot of bills, but nothing has changed with respect to, I guess, your service or even your own, like, you aren't incentivized because you can't do anything about it.
I think if they came to us, like I said, and said, look, your cars are outside on our tracks and they're causing problems for us. And if we would say, okay, like, let's figure out how to deal with that. Instead of just, we've gotten these bills and what I'm supposed to pay them, and they're big dollar figures, so, you know, especially for us. And I'm not quite sure how to deal with that with them.
Yeah, this clearly is helping the railroad's performance, and we're just not, if we saw service improve, if I could shorten my transit times, and I told you I have a bigger than necessary fleet, and I can get rid of rail cars, and that's a huge cost. And so if that was a benefit I got, great, then I'd pay that, but
I think at the end of
don't
the
see
day,
it.
do they want the money, or do they want the the maximum, the maximum utilization of their tracks and the movement of cars? Which is it? Is it, because it seems like it's the money that's important versus the more precision scheduling that they're articulating.
I have a few questions. Some of this may seem a little obvious, but I would like to flesh out some of the very mundane aspects of what you've talked about, partly to make sure I understand it, partly to make sure the public understands it. So I'm going to direct this to you, Ben, but anyone can jump in if your experience is different. I'd like to understand what zero credit days actually means in your workday. And to be specific, in your case, you're talking about a fleet that you own or lease, not the railroad's cars. So zero credit days, how does that operate in real life? What does that mean?
So if a car is constructively placed, and we get notice of that constructive placement before a certain time on, today, for instance.
Typically, what does that happen any time of day?
I don't know the answer to that about what time of day it happens, but if we have a certain amount of time then to order the car in for the following day, and if it doesn't meet that cutoff, the demurrage for the next day kicks in. Previously we would have a notice of constructive placement, and we would have 5 days to order that car in before demurrage started kicking in. So now if a car arrives today, we receive notice of that constructive placement, that it's there, it's right outside of our yard, and we can order it in. If we do it in time before the cutoff for tomorrow, we would not be charged.
Well, I want to make sure I understand. So you get a notice at 3 o'clock in the afternoon that
Right.
one of your cars has been constructively placed.
Right.
You have until 11:59 to order that car?
Something
put in?
like that, I think so, or yes, or I'm
And-
not sure the exact time, but yeah.
All right, and when you order it, how quickly after you order it does the railroad put the car in your yard?
They're supposed to put it in tomorrow if I order
The
it.
next day?
Yes,
And how long, and it's your car?
right,
So once it's in your yard, you're not being charged for it?
correct.
So the demurrage charge, I'm just not clear what the zero credit days
Can I-
means.
Can I?
Can you
try to answer that?
elaborate on this?
the way I understand it is that the next time the railroad switches to constructively place cars outside the site, that car better have been pulled in. If it's still there, then you're going to get charged demurrage. So in effect, you need to move the car into your site before the railroad constructively places outside your yard again, or outside your site again.
But the railroad is moving the car into your site.
That's true.
So.
So we needed to have ordered it in, yes. and
So
brought it in.
does this demurrage charge depend on when you order it as distinguished from when it's placed? That's what I'm.
No, it's from when it's placed, not when we order it, is the way I understand it.
You can't order the car before it's placed.
Yeah,
before it's
and so,
constructively
but,
placed.
and if you order it, then you need to order it before they place again outside.
Right, but you have, I guess what confuses me is the concept of zero time. I'm trying to understand on a space-time continuum how you function with no time. You have some time to order the car.
Yes.
So what does it mean? That's what I'm trying to get you to explain to us.
It basically means whereas in the past you would get a certain number of days after constructive placement as credit days, to plan your operations and order that car in. You no longer get, they've reduced it to zero, meaning you got to order it the day it's, basically the day that it's constructively placed.
Meaning it
The-
needs-
the next day is a new day, and that's when demurrage starts.
It needs to move in the next time that the railroad switches your plant.
And so what prevents you from ordering it in immediately when you get notice that it's placed, and then you start incurring the charges?
The number of cars in the yard that we may have at the time, the day of the week that we get the notice, the time of day maybe that we get the notice. Not all notices arrive equally. Notices of constructive placement. What we have, depending on what we have going on in our yard, whether it's operational challenges or labor challenges or whatever the case may be, it just.
So it's not a question of whether you have time to pick up the phone and say, bring the car in. It's a question of whether the physical facility can handle the bringing the car in that determines whether you can order it within the less than no time that you have to order it. Is that what
I
you're
would say it could be both. For instance, if we got a notice of constructive placement at 5 o'clock and the person who in our facility who typically receives those notices isn't there, they're going to miss the window for that. For that.
Has that happened?
Yes, it's happened.
Board Member Overman, if I can jump in, I would
All right.
say that we definitely, those things apply. And in Kinder Morgan's perspective, we have the ability to call cars in a manner which meets the railroad's deadlines. The problem is there's a myriad of reasons why cars cannot come into the facility. Our customers know how many spots they have allotted. They may have made a conscious decision to send more cars just to get them there. There may be an issue with the track, which would then fall back on us. It may be that the railroad from the previous day didn't give us enough time to get the cars that are currently there moved back out. So the reason that this is critical is there's a lot of reasons why those cars may not be called in. It's not as simple as yes or no. And a discussion needs to follow with that.
Well, that's what I'm trying to grapple with as to what are the events that cause the demurrage charges to start piling up. And you're saying that in the past, Ben, I'll just direct this back to you, if you had 5 days or 2 days, it gives you time, if you can't take the car in right now, to adjust your operation or move cars off the track or get the labor force in to do it. But when you only have this short amount of time, you simply can't always be flexible enough to take that car into your site. Is that what you're saying?
Yes, that's what I'm saying.
And just to, hold on.
Go ahead, yeah.
I would just like to add, leading up to, what can cause the demurrage event, or what can cause a receiver to not be able to physically receive all of the cars that are at the serving yard. It can be for a lot of different reasons, but we've mentioned bunching on several occasions, and I mentioned in my testimony the modeling that we did. And as far as empty private returns are concerned, the random modeling shows that cars will accumulate at the serving yard to a larger extent, in larger volumes, in larger blocks, than the way that they were built out as loads. So invariably, and this is just data, is all it is, invariably, even in the situations where loaders, shippers, and receivers, and the railroads all perform perfectly with zero variability in terms of load times, unload times, and transit times, if you're looking at several different destinations from one origin with distinct transit times associated with all of those destinations, just railroading alone by itself, as those cars flow back, they will bunch, they will accumulate, and an origin plant may not be able to take all of those physically in, although they performed perfectly.
I'd like to also just sort of get our terminology clear, because you have all talked about this phenomenon that we were just discussing as incurring demurrage charges. As I have read the cases and have tried to understand the industry practice, demurrage normally has referred historically to when a system car is on your property and it isn't returned in the time it's supposed to be. You're talking about a situation that you're being charged for your cars being on the railroad's tracks, but you're not taking them in, which in some of the times is referred to as a storage charge. You talk about it as demurrage, but we're talking about the same. In your case, it really, storage is the more accurate term, is it not, than demurrage? Just
That
so
is correct. It would be referred to as private car storage.
Yeah.
Yeah, I mean, and as Norfolk Southern bills that we get refer, have both. They're called demurrage bills, but then they're referred to internally
Okay.
inside the bill.
I just wanted to get because I think this is relevant to our making sure we understand the difference between system cars and privately owned or leased cars. And just to emphasize the point there, and I know you've all dealt with it, but I want to make sure I get this very concretely. If you had a system car on your property and you didn't return it within the time required, you would be charged demurrage. When your cars, and as you say, system-wide at 70% are non-railroad owned, are in the hands of the railroad and they aren't returned, and they're on railroad property, they're not on your property in the time that you think they should be returned, you are not able to charge them storage charges or demurrage charges for holding onto your property, I take it.
That is correct.
Is there any place in the entire system where a shipper who has privately owned or leased cars is able to do that? Do any of you know?
I don't even know how we would charge the railroad for anything.
Well, we may figure out a mechanism for that. And Terry, just to be clear, when you talked about the study that you did, and you talked about 416 cars were on the system 3 days, and I couldn't write it all down. I hope you'll send us those numbers. What are you measuring that against? The days beyond the typical transit time?
No, those are days that the cars sat idle and did not move.
Oh.
So
I see what you're,
as loads or empties, to be clear.
but not just outside your yard, somewhere in the system, they're just not moving. Is that what you're saying?
That is correct.
Okay. I have, I don't want to dominate the whole morning here, but I have a couple of other questions. Let me just ask one of Joshua, and then I'll hand it back, and then maybe if there's time, I'll come back. I read your testimony carefully, read everybody's, and I was very interested in the CN litigation, and I looked at their actual pleading, and you say that CN takes the position, and I think they do, that they are required by 746 to bill you for demurrage. Is that the way you, have they told you that they believe they're required to do it?
They have told us that, and we have actually tried to enter into agreements, three-party agreements between ourselves, the shipper, and the railroad, where Kinder Morgan and the shipper both agreed, but the CN has refused to participate in an agreement where the shipper would get the bills, and then any disputes that the shipper may have are between us and them. And so the CN has absolutely refused that.
Does CN take the position that they would be in violation of the statute if they did not send you a demurrage bill? Is that what they tell you?
I can't answer that, board member, but I do know that they claim that the statute's what empowers them to do that.
Well, in the complaint, it says the statute requires that they enforce their demurrage tariff. And that sounds to me like they say, gee, we'd like to not bill you, but we have to.
I can get back to you on that answer, board member. I don't know that specifically.
Okay, I'll hand it back.
Just to, I think, picking up on something that Marty mentioned about the zero free time concept, Ben, to kind of drill down, are you saying that, and I think you said in your testimony, that if you get a delivery on a Saturday and you have zero free time, you're closed on the weekend? And so you're faced with a choice because of zero free time. You can either pay the charge or open your entire facility up for the weekends. And so given that choice, given the cost of opening your facility on the weekends, obviously you made a business decision not to do that. You just basically have to eat the charge.
Right, because I'm not gonna necessarily open this, I don't know, that doesn't always happen. So I would have to know when it's gonna happen. I gotta plan in advance for it. And if I tell the employees to, the guys or whoever's coming in,
Be ready.
be on call, they're gonna be like, I don't know about that. They're not gonna like that so much. So yeah, we eat the charge.
And, picking up on something that Terry said, given that cars are going to go to different destinations with different transit times, they're going to come back, so you could send them out at different times, 5, 5, and 5, or whatever, and they can all come back as 15, just the nature of variability in the transit time. So even if everything is running perfectly, you're going to get a bunching phenomenon. Are you suggesting that if that 15 were to say outstrip your capacity, you only had room to take 10 in a hypothetical, are you saying for that remaining 5 that if they're constructively placed at a rail yard, they should not get demurrage? So any bunch that exceeds your capacity should not get demurrage until your capacity frees up under the normal demurrage rules? Is that kind of the idea behind, or a suggestion for how the board should think about bunching?
Yes, I would think, I would say that would be accurate. I would say not necessarily physical capacity at the facility, but the operational capacity of what the facility's infrastructure allows for. Yes. What the board would have to consider in this analysis is that a lot of facilities are landlocked. The roads have replied in the past, well, these increased charges might be an incentive
For capacity.
For an expansion of yard capacity within the facility. That may or may not be physically feasible, quite honestly. So that would have to be taken into consideration.
Terry, are the NGFA, are there arbitration processes? Do they apply to, is demurrage an eligible matter to be arbitrated?
I would defer to NGFA on that.
Okay. But if so, you haven't participated, obviously.
Right.
Okay. And Frank, if you could, or whomever, but I'm going to start with you, Frank. And we'll end this shortly because we actually could just talk all day, probably just to you. Could you help me better understand the congestion charge changes and from the 14 days to 5, which of course I do understand that portion, but the congestion is applying when your cars are in a carrier's yard too long, or just walk me through how it applies.
Yeah, and I'm not sure I can give you the actual specific tenets of that, but it's generally where we've caused, or according to railroads, we've caused congestion by the number of cars on their system at any one time, in any place, generally, and
But aren't they responsible for when they ultimately agree to take the car?
That's our view of that too, although they may point out that we've shipped more cars in a certain direction than we typically do that might have caused that. And while we, in our case, have some remedies, it can't always be addressed in a short period of time. We do have to serve our customers. We can't just make it all about trying to relieve the congestion. If we have to redirect cars away from where they're going to be needed to serve our customers, then that would be an issue. 5 days just isn't enough time. And I would just argue that yes, in not all, in all cases, it's not necessarily our issue. We can't audit that really either. We have to take the railroad's word for it. So, that's kind of our view on that. We need that time. I just would add, we understand what the railroads want to do, and we will do everything we can to help, but we're paying all the money right now to help them. And that's the issue in our mind. It's not getting us anything. Our service isn't any better. We've got records of our transit times. It's not better.
Two things on the record,
Go ahead.
very quickly. First is, it's interesting. One of the compliance mechanisms you can have outside of, bringing in crew, if you have a capacity limit, is to expand capacity. And I contrast that with the time it takes to expand capacity versus the notice that you have of these changes. So if one of the mechanisms takes a long time, and it takes more time than notice, you can't comply in that time. So I wonder real quick if you could kind of say how much notice you all had for the changes, quickly, before they took effect. Before the railroad made a change on credit days or charge level, how much notice did they give you?
Are you talking about like congestion charges?
No, I'm talking about advance notice before the change took legal effect. In terms of notification to you.
Sure. For the new,
Yes.
for the new tariff?
Yes. Because the statute requires a minimum of 20 days. And of course, we know when the letters went out, but I'm talking about communication with you all. How much advance notice did you have?
I don't remember in our case, but typically it's been at least that much time. I don't recall. Yeah.
Vice Chairman, I would say it's the same. It varies obviously by the railroad and the way that they communicate the changes, but we typically get an email telling us that on date X, which is greater than 20 days, typically 60 days,
60 days or so?
it'll take effect.
And then dispute resolution. A lot's been talked about the difficulty and the evidence. I think, Terry, you mentioned in your testimony 18 months. If you were to try and dispute a charge, how much time does it typically take from the time you initially notified the railroad that their charge was not accurate compared to ultimate resolution, whether in the favor of the railroad or the shipper? How much time do you think would be typical if you were to take a median or an average?
On specific to accessorial charges, it's hard to take an average from some that are still out there. 45 days?
Could be longer. I mean, we have some still sitting out there from 2018.
I would say in the case of Kinder Morgan, the people that we're disputing charges with are typically not the decision makers, so they're rejected summarily in a lot of cases, and then we have to go to routes which take months. I mean, we're 3 years into the discussion with the CN on accessorials.
Yeah, in our case, not too many of these rise to my level because I don't know that we have disputed that many, but the ones that I know of were months.
I'd like to just, a few follow-ups, I'll try to do this quickly. Frank, on a couple of points that you just were talking about, as I have read the materials, the congestion charge is based on the concept of congestion that is not defined by the railroads. Is that the way? I mean, how do you know what congestion consists of?
The statement is it's that we the customer cause the congestion, but that is true. It's not easy to determine that we have done that.
I mean, is it just the railroad saying we're congested, so we're going to bill you, without defining what that congestion means? Or should I ask NS to tell us?
That would probably be a better way because I don't know.
Well,
the
if you don't
specifics.
know and you have to pay it, that
Yeah.
seems to me to be a concern. To follow up on what Patrick was asking about notice, and I want to just sort of compare what Ben said and what you said. You're talking about Olin considering, or I gather, spending $10 million, I assume, to increase track on your property so you can take delivery of cars and avoid these storage or demurrage charges. That's the reason for it.
Yeah, that's one of them. I mean,
Yeah.
but we have a large fleet that we've had to deal with.
And I take it you couldn't complete a $10 million track project in 60 days.
No,
And how long does that take?
it would take a year or more.
And you've got, I don't know if it was in McIntosh, I mean, we were there, you've got land out in the country to build some track, right?
Yeah, and by the way, it's not the only site we'd be looking at.
You know, I understand, that you have other sites, but Ben, when you talk about making changes, is it basically boiled down, you just don't have the real estate to put more track in to take these cars? Is that the primary problem?
Yes, that's part of it. First of all, we're in the city. We're sandwiched between State Highway and a waterway, a creek. So we have, just limited ability to move. There's already existing buildings and equipment that,
So
it's limited spots, yes.
if the storage charge was $150 a day, or $1,000 a day, or $2,000 a day, you just can't build more track to avoid them, I take it, is what you're saying.
Maybe I could build a little more track, but it's not gonna help in the bigger picture.
Well, not the numbers you're talking about, I
Right,
take.
right.
And just one question for Josh. Ann asked about retaliation in general, and I will tell you, since the short time I've been on the board, I've heard about retaliation from lots of people in this industry, other than the railroads themselves. And I always want to bring out in this hearing, it's in your statement, Josh, but you say that after you contested the CN demurrage charges in your $8 million case in my hometown of Chicago, they gave you a 21% increase in something, and they raised the demurrage charge to $300, which you say is a result of that was motivated by retaliation, and the demurrage charge is 1.5 times higher for you than for anybody else in the Chicago area.
We believe that was retaliatory.
Yeah,
board
and-
member.
And is your belief based on the sequence of events, is that,
Based on the timing and just the fact that we're in a lawsuit with charges that equate to almost exactly that $300 per car.
I'm just gonna guess that in the normal commercial activity, CN doesn't say, okay, this is what we're doing. But it was pretty clear to you that that's what they were doing.
It was clear to us that that's what they were doing.
Thank you.
Okay, just one last question for you, Josh. Are there situations, circumstances when demurrage is appropriate for an entity such as a storage that you run, demurrage for the third party, the intermediary? So it's not that in no time are you not at fault?
Chairman, we are absolutely at fault in some occasions. We just ask that that's a discussion between us and the customer. And in the past, that's how we worked it out, where they will pay it and then say, look, this is on you, Kinder Morgan. You didn't have the labor set up properly. You had an issue with your track. But our customers make conscious decisions to their supply chain to ship cars. They may want to have them in areas away during hurricanes, and they'll bake that into their costs. And they may put them in yards knowing that they're going to sit there for a while, or they may want them away from their production plants so that they have room to receive and clear production at their plants. Those are decisions they make, and obviously that's something that they willingly pay to the railroads when they're billed, but currently those bills are going to us. So there's 3 buckets. There's the shipper's responsibility, the railroad's responsibility, and the terminal's responsibility. We will not shy away from paying our responsibility, but we want that relationship to be with the people we have our commercial discussions and contracts with, which is our customers, not with the railroads.
So you're saying you would reimburse the shipper, but you're not going to pay directly to the...
That is correct.
how-
That's the way our commercial contracts are set up per the ruling with the customers. They're responsible for demurrage, and we will then work with them on a case-by-case basis to give them credits for the things that we caused. And in the cases where the railroads caused them, they would dispute those to the railroads, and then the railroads, because they have the commercial relationship with our customers, they would generally accept that in the past.
Frank, in your statement, and I don't know if it relates directly to demurrage or not, but you said it, so I'd like to give you a chance to tell us what you mean from Olin's perspective. You said that you fear that PSR will make the railroads less resilient. I think I know what that means, but I'd really like you to explain it from your point of view. What do you mean less resilient?
Yeah, there are situations where the events that not in the railroad's control could create situations that disrupt their service. Weather is one in particular. And part of the precision scheduled railroading is for them to lower costs, basically do more with less. And our concern would be in those situations, they don't have a SWAT team, for instance, to be able to respond to a weather situation and restore service quickly. don't know that, but the concept of doing more with less usually means you have to follow a rigid schedule. You cannot deal with things that are out of the ordinary as well. And
And
that's a concern.
And the less is people?
Yeah, it could be people or how they do.
Locomotives?
I don't know for a fact they're reducing locomotives, but I do know they've talked about longer trains, so I would assume that would be less locomotives, fewer crews, and how they've managed their switch yards or hump yards as well. So,
That's what I assumed you meant, but I think it's
Yeah.
very good. Thank you.
All right, thank you very much, really appreciate your testimony.
Thank you.
We will now call up the second panel. And I believe during this changeover, there are going to be additional chairs brought into the room for our standing room only viewers. I hope that's true, otherwise take the chairs of the railroads that just emptied them. If anyone doesn't have a seat after the additional chairs were added, there is an overflow room outside of this door. It's in courtroom A, and there is a screen set up so you still will be able to observe and have a seat as well. Thank you. So we will start with our second panel of various railroad representatives. Thank you very much. We have, lost my list. We have CSX, NS, and Union Pacific, and we will start with CSX.
Thank you, Chairman Bigelow.
John.
Chairman, Vice Chairman Fuchs, Commissioner Oberman, good morning. My name is John Patelli, Head of Regulatory and Federal Affairs at CSX. It is my pleasure to introduce my colleague, Arthur Adams, Vice President of Sales and Customer Engagement for CSX, who is uniquely qualified to address today's subject as he personally oversees Accessorial and Demurrage for CSX as part of his responsibilities. Arthur?
Thank you, John. Chairman Begeman, Vice Chairman Fuchs, Commissioner Oberman. As my colleague John Patelli mentioned, I'm personally responsible for managing the customer experience at CSX. In fact, I or a member of my team have worked directly with many of the CSX customers represented at this hearing. So it's my pleasure to speak to you and answer any questions that you may have. Today I will address 4 principal areas. First, the purpose of these tariffs is to further the efficient management of assets and promote a fluid transportation pipeline. Second, customer engagement is a critical part of CSX's application of its tariff items. Third, CSX addresses disputes in a commercially fair manner. And lastly, customers are benefiting from the best operating performance in CSX's history. Demurrage and accessorials have a long history within the rail industry. You'll also see them in other transportation sectors, including trucking, port terminals, and shipping. In all cases, their underlying purpose is to promote a fluid transportation network, primarily for the benefit of customers. These tariffs have long been recognized to incentivize efficient customer operations and account for costs associated with the use of rail assets. Those costs include car hire for the use of other carriers' rail cars, additional car handling and switching of stored cars, capital and infrastructure expenses, and opportunity costs caused by congestion in the network. By way of context, prior to 2017, we did not consistently update or enforce these tariff items. We were frankly remiss in not paying sufficient attention to our tariffs and, crucially, to their attendant effect on our operations. Our service was poor. Our lack of consistent enforcement only compounded our effect on our operations. Our serving yards were more congested than they should have been, and our rail cars languished and were underutilized. By not holding origin and destination locations accountable for turning the assets, CSX was absorbing those inefficiencies. This served as a disincentive for customers to invest more in the plant capacity and appropriately manage their inventory. That is no longer the case. Our tariff changes in 2017 and 2018 properly incentivized customers to manage their pipelines more efficiently and turn cars faster. Slide 3 provides an example of what I mean. Here, customer A only has room for 3 cars, but orders 9, 6 of which sit in the CSX yard. Customer A likes this arrangement because it has 6 extra cars nearby whenever they're needed. Customer B runs an efficient operation, ordering only what is needed and turning the cars back quickly. What happens when customer B has an uptick in business and needs more cars, but there aren't enough to fill demand because of customer A's backlog? Customer B suffers as a result of customer A's inefficient car management. Demurrage incentivizes customer A to only order what is needed, when it is needed, and turn empty cars back faster so that customer B and other customers can get the service they deserve. Here's another example in the context of private cars. Receiver A receives more cars than it can hold at destination, causing excessive private cars to dwell in CSX's serving yard. We now have less yard space available for our operations or other customers' cars. We have additional handling and switching in the yard to work around the congestion, and our local service to receivers B, C, and D respectively languishes. Private car storage incentivizes receiver A to strengthen communications with his shippers, better plan his shipments, make the necessary plant capacity improvements, or find alternative storage locations. In other words, to manage its business in a way that won't detrimentally impact other customers and the broader CSX network. It is important to point out that we ultimately want these charges to diminish. We believe that over time, as our customers grow more comfortable with the consistency and reliability of our service product, and as they continue to enhance their inventory management, we'll see a decline. The customer is not alone in this process. My team takes great pride in working alongside our customers to actively manage their pipelines, which leads me to the second key point of my remarks, customer engagement. Prior to 2017, we did not invest heavily enough in this area. We've now re-energized our focus on the customer experience and have built an organization entirely focused on customer engagement. We've consolidated these functions in the sales and marketing department under a single leader. All of our customers now have connectivity into the organization through some level of my customer solutions team. We know we're on the right track. Among other indicators, our quarterly customer survey has shown sequential improvement in the overall perception of CSX for the last 5 quarters. We spend significant time asking customers how we can help better meet their needs. Our merchandise customers consistently tell us that their top priority is supply chain visibility, including visibility as to demurrage charges. In that regard, our online customer service tools allow customers to proactively manage their pipelines to reduce charges, track and evaluate applied charges, and dispute charges when necessary. Our shipped CSX tools are recognized as best in class, and we are investing to make them even better. We are partnering with customers to make sure they have a voice in the development process. To that end, we recently held a customer workshop to introduce a new Ship CSX platform with expanded capabilities to gather customers' feedback on the new tools. We've also developed a scheduled service plan that is shared with customers monthly. It provides advance notice of scheduled maintenance across the network and potential service impacts. We are committed to communicating service changes to customers at the local level as quickly as possible and before they occur to the maximum extent possible. Commercial fairness is the third key item, and let me be clear, we strive always to act in a commercially fair manner, and we have every incentive to do so. From the top to the bottom of our organization, we are driving to mend more of our customers' business. Today, with our high-performing service product, we are better positioned than ever to do so. Our goal of growth would not be possible if we were treating our customers unfairly. Essentially, all of our customers represented here today are merchandise customers. Importantly, over the last 3 quarters, CSX has incrementally increased our merchandise volume by an average of 4% year over year. It has been said by some participants that our policy changes have made demurrage bills unavoidable. The truth is, for the full year 2018, roughly half of our customers paid no demurrage. Of those who did receive a bill, over 50% paid less than $1,000 per month on average. We work hard to give those customers who do receive bills an opportunity to raise concerns and contest charges they believe are inappropriate. For an example, if demurrage was caused by CSX missing a switch or bunching traffic en route to destination, we apply credits and adjust the invoices accordingly. We frequently involve other internal departments, including sales and marketing, car management, and operations, to assist with customer pipeline management. I believe the service consistency, customer support, and online tools we make available to give our customers the ability to manage their inventory and reduce their exposure to demurrage charges. My final point is that customers are benefiting from the strongest operating performance in the company's history. Our current policies have helped spur improvements in safety, operational performance, network fluidity, and capacity. Today, our customer service is hitting historic highs, as evidenced by record-setting velocity and dwell metrics for the first quarter 2019. These improvements, along with others, have translated into a superior service product for our customers. My colleagues and I at CSX regard scheduled railroading as both an operating model and a shared commitment to excellence. We believe that our fair and standardized policies, including those related to demurrage and accessorial items, are producing the intended results, contributing not only to our success, but the success of our customers. Customers have learned that we are able to handle more freight with fewer assets, leaving them with less inventory in motion. And if the customer owns their cars, it's even better. They save precious capital as they no longer need as many cars in the fleet cycling to supply their supply chain partners. Those efficiency gains and the enhanced level of service have combined to create what might well be termed a virtuous cycle. A picture is worth 1,000 words, but in short, service and efficiency are closely correlated. In the last 2 years, every key service metric and efficiency metric has been improving to the benefit of all of our customers. In closing, I wish to thank you for the opportunity to speak on this important topic. I appreciate your attention and look forward to answering any questions you may have.
Thank you. NS?
Good morning. I'm Alan Shaw, Norfolk Southern's EVP and Chief Marketing Officer, and I thank you for the opportunity to be here with you today. I'm joined by my colleague, Ed Elkins, our Vice President of Industrial Products. We both want to take some time and speak to you about our accessorial program, which is aligned with the mutual goals of Norfolk Southern and our customers for a more efficient and reliable service product that provides our customers with a platform for growth. The recent modifications to our accessorial programs are designed to complement and reinforce changes in our operating plan to improve our service product, which we are delivering. Let me be clear. Norfolk Southern's accessorial program is not intended to increase revenues. That is not our intent. It is there to improve the efficiency and the reliability of our service product and turn our assets and our customers' assets more frequently. At Norfolk Southern, we are successfully implementing our own version of precision scheduled railroad. Our approach includes implementing changes at a measured pace so as to mitigate the potential for network disruption. We're collaborating with our customers to re-engineer work and to deliver a more efficient and reliable service solution. And it shows in the metrics. And we are removing the work before we remove the assets, again, to mitigate the potential for network disruption. We have a balanced plan, and it's balanced between efficiency and growth. As we re-engineer our network and create surplus assets, we can reapply those assets to support our customers' growth, in effect, a capacity dividend. We are investing 16 to 18% of our revenue back into our network annually in the form of our capital budget in an effort to develop an efficient and reliable product that provides a platform for growth. We're investing in technology to improve the transparency and the visibility of our customer supply chains and provide a best-in-class, consumer-oriented customer experience. We are developing web-based tools and mobile applications to allow our customers to manage their supply chains more efficiently. And we've changed our leadership, and we've changed our operations to improve service. We're collaborating with our customers at the local level to improve the consistency of local service. The number of customers who are switched 6 or 7 days a week has more than quadrupled, as we're actually increasing the frequency of service. And right now, approximately 85% of our industrial products volume is switched 6 or 7 days a week. We're collaborating with our customers. Just yesterday in St. Louis, Ed Elkins and I were at a town hall with our customers and our employees alike, discussing operating plan changes. And one is being held as we speak today in Decatur. In conjunction with these changes, we have modified our accessorial program to better align it with the mutual goals of Norfolk Southern and our customers. At Norfolk Southern, demurrage and storage is an activity-based charge that serves two purposes. It encourages the efficient use of our assets to the benefit of all of our customers, and it compensates Norfolk Southern for the use of our assets. As I've said publicly, our recent changes are designed to improve the efficiency through better asset utilization and increase network fluidity and velocity. NS is not counting on additional revenue from these changes. Recognizing the impact of these changes, we provided our customers with 3 months advance notice. And importantly, we've balanced these changes through the application of service credits. When Norfolk Southern does not perform to the original ETA, customers can apply these service credits to offset potential demurrage charges. As said, we're seeing the positive impacts of all of these changes to our network. We have dramatically improved the service product that we're delivering to our customers. Train speeds are up 23%. Terminal dwell is down 36% and is at the lowest level in over 16 years. And the number of cars online is down 13%. Just as importantly, in our customer-facing metrics, i.e. shared KPIs with our customers, we're well on target to hit a 40% improvement in our customer service in 2019 relative to 2018. Customers have faith and we're building credibility with our customers. They're gaining confidence in our ability to perform. So they're turning back leased equipment while growing with Norfolk Southern, a financial benefit to our customers. I thank you for your time, and I look forward to answering your questions and continuing our ongoing dialogue with the board and our customers.
Thank you. Kenny?
Good morning. Good morning, Chairman Begeman, Vice Chairman Fuchs, Commissioner Oberman, and board staff. I'm Kenny Rocker, Executive Vice President, Marketing and Sales at Union Pacific Railroad, and I want to thank you for allowing me to speak on behalf of Union Pacific with regard to our demurrage and accessorial charges. The board has specifically asked me to address the following topics today: our recent experience with demurrage and accessorial charges, our perspectives on fairness of our accessorial tariffs during the past 3 years, and lastly, the impact of our customers following the recent changes to accessorial tariffs. But before I jump into those topics, it is important that I explicitly tell you how we think about accessorial and demurrage charges at Union Pacific and what we've done to work with customers through the recent changes. Our top priority is to provide safe and reliable service to all of our customers. The objective of our accessorial and demurrage program is to align customer behavior in a way that promotes network fluidity for the entire supply chain. All customers benefit with improved service reliability and reduced cycle times when all assets are utilized to their fullest. As we've made changes to our transportation plan in 2018, we began to put more focus on moving cars rather than trains. This was a fundamental change that we needed to make in order to improve our service product and make it more reliable for all of our customers. Likewise, we made changes to our demurrage and accessorial program to align it with the overall objective to keep the network fluid, which benefits all of our customers and the entire supply chain. More importantly, here's what we did to help customers navigate through the changes. First, we've taken a proactive posture at every turn with our customers, notifying them of changes well in advance. Second, we've utilized technology to hold Union Pacific accountable and provide our customers visibility to manage their inventory levels. And I'll provide you more details on this in a minute, but before doing so, I want to emphasize this next point. Third, in preparation of this hearing, we read our customers' comments and listened to their concerns. In fact, we made the following recent changes to our accessorial tariffs as a direct result of the board's hearing today. We changed our not prepared for service tariff to bill on a per occurrence versus a per car basis. We further changed the not prepared for service tariff to issue billing to only those customers who have 3 or more occurrences in a calendar month. And I stress that since we implemented the not prepared for service tariff in January, we have not and will not bill customers for multiple accessorials at the same time. So, for example, we do not assess demurrage for cars that are subject to the not prepared for service tariff. We changed the tariff language to bring it into conformity with our actual practice. Thank you for allowing me to take the time to provide this relevant background. I'll now move on to the recent experience in accessorials for Union Pacific. So as it relates to recent experience, over the past 2 years, we've worked to standardize and simplify the tariffs for accessorials to make them easier for our customers to navigate and understand. For example, we reduced the number of pages in our accessorial tariff document by 45%. We eliminated 47 different items that were duplicative and antiquated. We inserted technology and tools to provide superior visibility to help our customers better manage their inventory pipelines. For example, we're leveraging GPS data from our locomotives to provide customers with more real-time arrival data for their shipments, and we've applied artificial intelligence to that GPS data to improve the ETAs for delivery times. We have an online shipment management tool to provide inventory management solutions to customers so they can see the number of rail cars en route, the number of rail cars in their serving area waiting to be delivered, and the number of rail cars at their facility. 98% of our crews report their daily work events using our mobile work order devices. This gives us more accurate and timely data on customer deliveries and pickups. We have been proactive and have proactive notifications like "You Are Next" and "Local Service Today" to alert customers to prepare for the arrival of our crews. In January 2019, we implemented our bulk train tariff items to improve the utilization of critical resources like locomotives and crews in order to provide a more reliable service to all of our customers. And during the same period of time, we rolled out a number of tools to help customers navigate through the changes. As you can see, Union Pacific has implemented a balanced mix of customer incentives and tools to help individual customers align their supply chain with our network, thus promoting a more reliable and consistent service system-wide to benefit all of our customers. As it relates to your second topic regarding accessorial tariffs and fairness, over the past 3 years, the total average annual charges for accessorials and demurrage have been only 1% of our total operating revenue. This is not a revenue-generating initiative for us, and although these charges have increased in the first quarter of 2019, we hope that increase is temporary because the intention is to improve service, not drive cost increases to our customers. The next area of concern you asked me to address was the fairness of our billing processes. But first, let me be clear that our intent is not to assess any demurrage or accessorial charges that are a result of UP call service delays or items outside of the customer's control, like weather or plant outages. For demurrage, I mentioned in my submitted remarks on May the 8th in various ways we issue the credits, so I won't list them again. The bottom line is that we issue credits to allow for every car, both railroad and privately owned cars, to unload in 24 hours. To compensate the customer if UP fails to deliver a rail car when the customer has capacity to take a car. And for private equipment to allow charges to accrue only when the private cars are stored on UP property. We believe it is fair to base billing on the customer's ability to keep their capacity levels fluid during the course of a full month. This approach aligns with customer behavior in a way that promotes network fluidity and improves service for all of our customers. But our approach to reciprocity and fairness goes beyond simply adding credits to a demurrage bill. For all of our accessorial and demurrage billing, we listen to our customers and assess the facts with data to make fair judgment about the validity of the charges. Our billing accuracy is 95%. We know we aren't perfect, as our billing data is subject to human error from crew reporting. But we are making progress on improving the accuracy of their inputs. We also have made it easy for customers to dispute accessorial charges using our online billing and receivable systems. We research each disputed claim by tracing the railcar shipment, even if it begins on another railroad. If the facts show the charges were the result of any railroad disrupting the customer supply chain, then we cancel the charges. However, if we determine that the cause of the accessorial was within the customer's control, then to be fair to our other customers, we assess the charge to help align the particular customer's behavior with the network fluidity. All customers benefit when assets, both the customers and ours, move faster on the network. Furthermore, Union Pacific understands the board's commitment to evidence-based decision-making. We agree with that approach. We believe the facts and data of each particular case must be looked at in order to know what's really going on in any case. UP encourages the board to take the same approach here. General, broad statements really don't shed much light on what's actually happening in a particular case. We suggest that after going through our billing dispute resolution process, which we believe is fair and a reasonable process designed to confirm validity or correct errors, if a customer still feels they have been charged unfairly or unreasonably, there are tools available to bring their concerns back to the board's attention, including the complaint process as well as the informal complaints through OPACAT. As a reminder, Union Pacific has signed up for the board's informal mediation process, and we will be open to using that process to give customers streamlined access to the board's assistance. Finally, you asked me to address how our changes to demurrage and accessorial charges have impacted our customers. We have taken the customer's feedback into consideration and listened to each unique scenario. We have also taken measures to make the transition to our changes as seamless as possible. For example, back in November 2018, we gave 60-day advance notice to our customers of our intent to change accessorials and demurrage tariffs. Within that 60-day window, we developed material to help our customers, service and sales teams explain the what, the why, and how to customers. Our customer service and sales teams call all of our customers who were identified to be at greater risk of experiencing accessorial and demurrage charges. We work with customers who were impacted by situations outside of their reasonable control, such as city ordinances that prevented night loading and unloading, to give them more flexibility. We provided bulk tariff summary billing scenarios based on actual November and December data so customers would understand how the rules and charges under the new tariff would apply to their operations. We delayed our billing for the bulk tariff. We also suppressed not prepared for service billing associated with third-party switchers where UP did not yet have a system solution in place to help them prepare for pickups. The results of partnering with our 9,000 customers to help them use our network more effectively have been impressive. We are beginning to see customers turn assets, both theirs and ours, faster. In the third quarter of 2018, only 55% of our bulk train customers loaded and unloaded their rail cars within 24 hours. Today, this number is at 65%. Our service is improving, and our network is more fluid. Compared to a year ago, our current 7-day terminal dwell has dropped by 13%. And our on-time delivery rates are the best they've been in over 2 years. Again, I want to iterate that our top priority here is to provide safe and reliable service to all of our customers. As the supply chain becomes more consistent, I'm confident the changes we've made will result into a win-win for all of our stakeholders. Further, I want to emphasize the following actions that we took making the changes to our accessorial charge program. We proactively worked with our customers in advance of any change to be transparent and help customers navigate through the potential impact to them. We inserted technology and tools to give customers better visibility to their pipeline and help them manage their shipments more effectively. And furthermore, we listened to our customers and already have made improvements to the program based on their early feedback. Each customer has a unique supply chain, and we will continue to listen and work with them. We remain committed to make sure we are fair in how we execute our accessorial program. In closing, these 3 steps are improving asset utilization, and we're seeing our operating metrics get better. Union Pacific remains dedicated to working with our customers to provide them with a safe and reliable service product, while also maintaining their ability to remain competitive in their own markets. Thank you, Chairman Begeman, Vice Chairman Fuchs, and Commissioner Oberman for allowing me to speak this morning. I stand ready to address any questions that you may have.
Thank you all. I'm going to kick off with a few questions. And this first question is for each of the railroads, but I'd like to get a specific answer from each railroad. And I'll start with you, Mr. Adams. You understand that the concept of a demurrage charge is to provide partly for compensation to the railroad for a shipper holding on to the railroad's rolling stock, and partly to provide a penalty to the shipper to incentivize them to not do that. Do you agree that that's the way demurrage is set out in the law?
I believe that's what it was intended to accomplish, yes.
So my question for you is, if you take a demurrage charge, typically $150 a day, would that be a good example?
It varies by car type.
Well,
It's,
what would be typical?
well, for a private car, it would be $65 per day.
Or a system car?
For a system car, it would be $100 a day,
All right,
roughly.
so let's take $100 a day. How much of that $100 a day charge is compensation to CSX, and how much is penalty?
I don't know the answer and the breakdown of that. I'd have to get back to you.
Who does?
Commissioner Overman, I would just add that, we wouldn't want to get in any way of breaking down our particular rate, given the sensitivity, the competitive sensitivity of questions like that. I don't think, I think largely, the question is associated with incentives, right? Absolutely, just as we've said in our written testimony, the charge is designed to take into account compensation, right? And be aligned with cost, take into account cost, and that cost can vary. Direct costs associated with switching at yards, costs associated, railroad has related to car hire, costs associated with opportunity costs caused by congestion, the ability to not get to other customers as easily as we would like to get to because of congestion caused by cars in, for example, CSX yards. There's a variety of different costs associated with demurrage. I don't think anyone would pretend it's some sort of exact science, right?
Well, I wasn't suggesting there were no costs, but Patrick had a question, and then I'll come back to this.
So, John, you mentioned the incentive effect. I guess I'm wondering, before you made a change, did you forecast what the effect would be of that incentive? So in other words, before you made a change in 18, did you project what it would do for, say, to use one of Kenny's stats, how many customers were to unload within 24 days? Did you project what kind of effect the incentive would have?
Yeah, I would say I don't know that we thought about it in that context. I would take a different approach. I think the goal and objective was to improve the overall service. Right? And what we recognized early on during the transformation of scheduled railroading was that there was a series of inefficiencies, some which were a function of our operating protocol, some was a function of our customer and their approach with us. So the goal at the end of the day for us was to improve the underlying service product. So we did not project or forecast per se what the effects of the merge would be from a financial perspective. I don't know if that's where the...
No, I mean in terms of what you care about in terms of service. So if the incentive and the changes, whether it's a change in credit days or a change in the level, is designed to change shipper behavior, customer behavior, to increase the speed of loading and unloading, you had to make a determination about what the level is and the number of credit days. And you all made different determinations. I'm not asking you to compare against each other.
Right.
I'm only asking you for your individual determinations. Did you project or think about what the actual incentive effect would be on service?
Correct. So as an example, specifically it's related to free days.
Yeah.
So prior to July 2018, we offered 2 free days.
Right.
Today we offer 1 free day.
And you're expecting what kind of effect that to have? You know what I mean?
So we're expecting a couple things, and it's reflected in our performance results.
Yeah.
One of which is a reduction in dwell.
Right.
So on average, we're 8 hours of dwell across the entire network. Another consequence, of course, would be velocity. So improving the overall network fluidity would be another example of what we anticipated as a result of those changes.
And then on the revenue side, did you all, when you were changing kind of your demurrage structure, did you all project how much more revenue you would get because of it?
No, we did not, because that would imply that our intent was to bolster revenue. And that wasn't the intent. The intent was to improve the overall efficiency of the service product, and we've done that.
Okay.
I'd like to just follow up on this subject. I thought that was very helpful. Just to be clear, last year your demurrage billings were $246 million. So you can't tell us as you sit here today how much of that $246 was calculated as compensation for the various costs that Mr. Patelli just outlined, and how much was penalty.
Yes, that is correct.
Mr. Patelli, I realize you say this is sensitive, but as I read the case, nobody suggests there may not be costs of the kinds that you enumerated. But as I read the case law, I assume I'm going to direct this to you because you're sitting there as counsel in addition to, so I think it's fair. There is a difference between requiring a shipper under past case law to pay a cost that's a compensation and a penalty unless you can show fault. Do you agree with that?
Yeah, Commissioner, I think it's a good question. I think there are cases, a recent example was fuel surcharge, right? There are cases where...
I'm talking about, let's stick with demurrage.
Right, but there are certain charges that the railroad is holding itself out to be representative of costs, right? Demurrage, in my view, has never been traditionally just about costs, as you've said. It's about both. And I don't think as far as I know in the case law, there's been no railroad to say that it's just one or the other, but that it's always been really
It's both.
Consideration of both. That's
Right, but don't you recognize that in the past, both the ICC and the courts have separated out and have held that railroads cannot collect a penalty unless it is shown, we'll get to who has to show it, that the shipper is at fault as distinguished from collecting the compensation portion of the demurrage charge. Don't you recognize that's what the courts have done?
I do recognize that in some of the case law that I've seen, I can't say that we've done an exhaustive analysis of all the case law, but I do agree that usually the case law comes up in the unreasonable practice context. And as part of the analysis of unreasonable practice, one of the considerations, to your point, is who was at fault, right? Was the demurrage bill itself caused by railroad fault? I do think that's part of that analysis, yes.
Well, we have done an exhaustive analysis in preparation for this hearing, and let me ask if you agree with this statement. Quote, when demurrage charges penalize a shipper who is powerless to avoid or abate the detention. Penalize is the key word here. A shipper who is powerless to avoid or abate the detention of cars because of circumstances beyond its control, they do not accomplish their purpose. Do you agree with that holding from one of the prior cases?
I do agree.
So-
I do not think it's reasonable to hold a shipper accountable when they're powerless.
Well, so the question is, if you can't separate out the compensation from the penalty portion of the $100 a day charge or the $246 million that you billed last year, then how is it that the shipper can determine whether it's required to pay all of the charge or just the portion that's compensation, at least if it can be shown that the shipper's not at fault? How do you separate it out? And how does the shipper separate it out?
Well, in terms of shipper empowerment or shipper being powerless, I would go back to the intent of what we're trying to accomplish here, which is to run a safe and efficient operations. So if a car is dwelling longer than the time that it would take for a shipper to release the product back to us place the car to them, there is a impact to our ability to operate our network in the most efficient manner possible. As you've heard in the first panel, we all have constraints, physical plant constraints, whether it's a serving yard, a hump yard, whether it's a physical plant capacity that a receiver has or an origin for a producer. Our goal and our intent is to incentivize the assets to move as fluidly as possible when in our possession.
Well, let's follow up on that, because you say when they hold it longer than they need. So in lowering the free time from 48 to 24 hours, did you go through all your customers and assess which ones, if any, could unload their cars within 24 hours, physically able to do it?
Our approach was to provide advance notification on the intent of the changes that we were looking to implement, and then also discuss the rationale as to why, and then the underlying benefit, which our customers experience today, which is an improved service product. Did we speak to each of our 5,000 customers? Absolutely not. Were they all notified? Absolutely yes.
Well, you've heard, and I'm sure you've seen, the testimony from all of the shippers who are here today, and many say they physically can't comply with these new time frames. The prior panel explained how not so much on unloading, but accepting cars when you're ready to deliver them. You didn't attempt to measure whether 24 hours was realistic for each of your customers?
I think what we've attempted to do, Member Oberman, is in instances where customers have shared with us their concerns relative to the changes that we've made, we have elected to work with them individually to develop a solution that works both for ourselves and for the customer. As we have embarked upon the changes and the transformation of scheduled
Excuse me,
railroading.
so how many customers have reached out to you to try to establish some additional changes? How many, I mean,
To my knowledge specifically, it happens probably not as frequently. I would say that we have
CSX customers, start calling.
we,
Mr. Adams.
specifically, so there's roughly around 40 customers that have we've reached out to help reduce their overall capacity based on improved service performance. So just a few more sound bites there. Of the 40 customers that we've had conversations with around optimizing their overall network with us, we've seen roughly about a third of those customers have had significant reduction in their overall fleet size as a result of improved cycle times. There are also instances where we've had conversations with customers that did not elect to reduce their fleet size, knowing full well that there would be demurrage associated with their existing supply chains. So I will go on the record as saying we're open and we want to have those conversations with customers if there are instances where customers feel as if there's an opportunity to improve their overall performance and partnership with us.
So if a customer came to you and showed you that they could not meet your 24-hour deadline, would you give them a 48-hour deadline? Or is it your way or the highway?
No, I think it's a conversation that we'd be willing to have. It would be my
Have you
response.
increased the free time for any customer to 48 hours since you've reduced it to 24?
There are examples of customers that we've made exceptions for, and we do that on an individual basis based on contracts.
Exceptions on that point, a 48-hour free time?
Exceptions on our demurrage policies in general. I can't specifically give you an example of the 48 hours, no.
Well, are there any that have gotten an extended free time since you went to 24?
There are customers, when we look across our demurrage and accessorial policies, where we have made exceptions to the policies as published.
Well, but the specific question I'm asking is about 48 hours versus 24. Have you made exception to that policy? Or that rule?
I will follow up with you, Member Overman, and give you.
And if so, I'd like to
specific
know
examples.
how many.
Well, to get back to a question that I'm just kind of wondering, because, one of the things I said in the opening is that, demurrage has useful purposes. It incentivizes faster loading and unloading, and in doing so, you get, your cars free up quicker, you get more capacity, and, I think it reflects in terminal dwell and other service measures. And so I'm just trying to think about, you all had to draw the line somewhere, and the board had, and the concept of reasonableness has to think about where to draw the line. You made decisions on the number of credits for certain railroad error, you made decisions on how much free time to give, and you made decisions on what level of charge. And one of the things I appreciate about Mr. Rocker's testimony is he talks directly about how many people, what percentage of folks unloaded and loaded within 24 hours. And you all had to make the decisions. And so if what we care about is incentivizing changes in behavior, I haven't heard how you all think about drawing the line, because you all drew the line differently. And if that's what you're after, I just would like a little bit more clarity into your thinking in terms of where you drew the line on all three of those margins: the credits, the free time, and the level.
I'm not sure if I can respond to Commissioner Overman's question. First of all, I just want to say at a high level, yes, we were very deliberate and thoughtful in how we came up with the charges. And I will tell you that the eye was towards network fluidity. That's what the focus was. Because of where we are with our peers and because I'm at the table with our peers, I really don't feel comfortable going into the details. But I can tell you that we're more than willing to be transparent with the board and sitting down with you confidentially at another time and walking you through how we came up with those charges.
Can you all speak to what you expect the percentage, without maybe, what you expect the percentage of customers that will increase their loading and unloading speed by measurable difference? But the 24-hour measure, for example, you've given some point estimates based on recent experience. If we were to look at the end of 2019, when all of these demurrages truly take effect and people are changing behavior, and they've settled in for a little bit, what does that measure look like at the end of the year?
So look, I'll do this pretty quickly. So Vice Chairman Fuchs, I'll tell you what we did. Our vision for sharing the scenarios was really to just be proactive with the customers and allow us the opportunity to sit down with them and work with them on actually getting the bills to zero.
Right.
We have no interest in having
Right.
any of our customers have any of these bills. So that was the impetus for us taking that proactive posture, not to go out and just forecast, how much we thought the additional amount would be.
Could I just sort of follow up on where we were, Kenny, as long as you were talking, and we'll come to NS. Can you answer the question of what portion of your daily demurrage charge is compensation for cost and what portion is penalty? And can you tell me how much of the 149 million you billed for last year is compensation, how much is penalty? Do you have, does the data
Commissioner
exist?
Overman, I was trying to address that earlier, and basically what I'm saying is that we feel comfortable being transparent with the board. We just don't feel comfortable while we're sitting with our peers talking about it. But
You realize that if you were litigating a case with some shipper trying to collect it, you'd have to tell the court or this board publicly what the portions were in order to collect it.
understood.
So do you have the data? Does it exist?
Yeah, we can share that data with you, yes.
All right. On this point that Patrick was asking about, I noted a couple of points you've addressed here and in your written testimony. When you talk about it had been 55% of your bulk trains unloading in 24 hours, and now was 62 at the time, now you're saying it's up to 65. Bulk train, is that the same as a unit train, or what does that mean?
Correct, yes.
And so two questions. The 35% of your customers who are not unloading in 24 hours, why is that? Are they physically able to do it, in your view?
In some cases, we do not know if they are physically able. And so in every case, we are providing them with an alternative service solution. So
Such
they
as?
aren't a manifest product. So we do work with our customers to do that if that's a choice that they don't believe they can unload in the 24 hours.
I'm curious of why you did not include in your submission what percentage of your manifest customers are unloading in 24 hours. Do you know that answer?
Directionally, I tell you the majority of them could.
And I think
Well, I don't know, is that 51%? I mean, what does that mean?
I don't have a specific answer for
You know, one of the questions here that I think is following up on Patrick that has struck me about just the volume of response we've got to these hearings is that if you have a system in which a significant percentage of the people aren't complying, and I doubt they're not complying because they're lazy or indolent. It could be, there are some out there, but I'd be surprised. Whether it's 35% or 49% or 50%, it's a high percentage of people who are not, as you said, the intent is to have no demurrage charges. In theory, if it worked perfectly, there would be none. Half the population or a third can't do that. On its face, that tells me there's something wrong someplace. And I think it would be very important to know what percentage of your other non-unit train customers are having this problem. Let me shift to NS for a minute.
Marty, if I could quickly
Go
mention
ahead.
why I think that
Go ahead.
matters. You know, what I think that the question in terms of what you expect matters is that if you are continually increasing and continually reducing free time, and you're not observing a change in customer behavior, you wonder whether or not it's having an incentive effect, which is why I think that the projections are important. We think demurrage as a concept and improving network fluidity is in everybody's interest. The question is whether it's truly having an incentive effect and changing behavior such that we can improve network fluidity, or whether or not something else is going on. And that's what we're trying to get to. So, you know, the fact that I'm not hearing concrete information about what you all believe to be the incentive effect going forward, and I would like to have more confidence in when you're making changes, you know, what is expected, so we know that those changes are considered and that we're all kind of moving together and thinking about network fluidity. So I think that's why it matters, and that's the purpose of the question.
So, Vice Chairman Fuchs, to answer your question more pointedly, in terms of what are we looking at to define success?
Yes.
Okay.
That's a good way to describe it.
So we measure dwell across all individual car types. And what we're seeing sequentially quarter over quarter, as we started, as you can imagine, the percentages were dramatic. And now we've seen continued incremental improvement in reduced cycle times across all of our car types, both our scheduled network, our manifest network, as Kenny alluded to, UP, and for our bulk train customers alike. I think the other component of your question that you're pulling on is, what does the future hold in terms of the effects of demurrage and accessorials on improving the overall performance of the network. Over the last 18 months, I think the changes that we've made and the pace at which we've made those changes have delivered the desired outcomes. And what I mean by that is, what are customers buying from us? They're buying a service product that fundamentally is 35% faster and more reliable than it was when we started this journey 18 months ago. Mm-hmm. So that's the evidence of where we stand today. In terms of what we intend to do on a go-forward basis, I think what we'd like to continue to do is continue to monitor the overall effects of service performance relative to demurrage. But in terms of drawing a line in the sand in terms of what success looks like, I don't have an answer for you today, but we'd love to continue to have dialogue about how we get there together.
So aren't you going to
Customers
need
play
to
a role in that.
drill down more than a one-size-fits-all approach to demurrage and 24 hours and the ability for a customer to load or unload? I mean, on the one chart, you'd said demurrage incentivizes customer A to order fewer cars, but it doesn't sound like, well, you do have metrics, dwell, it's a number of things that you have improved upon, and you should be proud of where you've come after self-imploding to get there a while ago, but it seems that you're going to have to drill down. There are customers such as Ben. Ben was talking about NS, but there are customers that will probably never be able to be incentivized and not be able to pay the price that you are charging them because they just don't have the ability to avoid the demurrage costs. And so at some point, there needs to be drilling down on a per customer basis to determine whether or not changes need to occur besides a one-size-fits-all approach. And one of the questions I have is, Kenny, thank you for making it real clear that you have read your customer's testimony. You have actually taken some actions UP has with respect to what the testimony indicated to you. I'm curious, have you NS and CSX? Did you read the testimony? Did you listen to the first panel?
Yes, ma'am.
Things aren't all rosy.
No, ma'am. I'll speak for Norfolk Southern and try to address some of the issues that have already come up, or the questions that have already come up. We started down the road to improving our service knowing a couple of things. Number one was our service was not where our customers needed it to be. Our network was not as fluid as it needed to be, nor as stable and resilient. We heard that word earlier. At the same time, we knew a component of that lack of service standard that we wanted to pursue. We had a lot of cars online, both private and system cars. And our fluidity, like I said, was not where we wanted it to be. So we started our journey on PSR with the idea that we want to provide service to our customer, number one. First thing, manage our assets and control our cost. That does not mean lower your cost, control your cost. So when you think about reciprocity, we knew one of the first things we had to do if we want our customers to load and unload faster and produce more product at a higher rate, we needed to do the same thing. And so therefore, we increased the level of service to our customers dramatically on a daily basis. And I think you heard Alan say earlier that we've quadrupled the amount of customers.
For those customers, though, that cannot go to a 6 or 7 day a week switch, and yet now they're being charged demurrage.
Well, I would say we did not think it was reasonable for us to have an expectation of the customer to work more often if we didn't work more often ourselves. And so that was our first piece of it.
But not everyone can be open 7 days a week or work 24/7.
Well,
we can.
Yeah, I would.
And we do.
And I think many companies make economic decisions based on how often they're going to work and what days they're going to work. And there's an economic price if they decide not to.
I do want to say something quickly. I have bashed CSX a few times publicly about history, recent history. And I have been pressuring UP and NS and KCS and anybody else that wants to change their operating plans to do it slowly, methodically. Do not reduce your head count for your customer service operations. I'm not saying I support your operating plan changes, but I commend you for having customer service representatives, for going slow, for not going with the caving to the Wall Street pressure of rip off the Band-Aid. You can do that, but just know we're here.
Well, we understand, and
And I'm not going through that again.
All right.
And neither are customers. So thank you.
You've heard our strategy, and to the Vice Chairman's question about the targets for this, we were very clear that we would improve our customer-facing metrics by 40% this year, which we are on target to do. We're also very clear that we would reduce the number of cars online, which we're going to hit that target as well. That has a causal impact on service, and also service has an impact on number of cars online. And it's not, so I want to make it clear that it's not just the accessorial program that's driving these. There are a lot of independent variables that go into this, including changes that we've made. We were doing things that made it very inefficient and provided a poor service product for customers. We had to change that. We changed that in conjunction with our accessorial programs. Our customers this time last year were telling us we needed to make changes to our service product. We've done that, and we are delivering those results.
I'd like to just follow up here and continue on a couple of lines of questioning. So for NS, can you answer the question of how much of your typical demurrage charge is calculated as compensation and how much is penalty? And not only on a daily basis, but how much of the $243,000 you billed for last year was penalty? How much was compensation? Can you answer that?
I do not feel comfortable talking about how we calibrate rates in a public forum.
Well, is some portion of it penalty? Without telling me how much?
So for us, demurrage is designed for two things. To encourage more efficient use of we have over 5,000 customers. It's designed to encourage more efficient use of our assets, including track space.
Well, I understand what it's designed for. I'm trying to figure out how it's calculated. So let me ask all three of these railroads. I'm going to ask all the rest of the railroads over the next 2 days. I'd like to know what portion of your charges are calculated as compensation and what are calculated as penalty. And I'd like to know what the answer to that question was yesterday before I raised the issue. Because if you haven't thought about it until today, I'd like you to be candid and tell us that. And if you don't have an answer, I'd like to know that too. I think it's quite important based on what I understand the law to be on your right to bill and collect these charges. I think it's crucial. And it's crucial to educating us on how we go forward, particularly on this question of fault and proximate cause, which comes up all the time. I'm going to get specifically with regard to NS, follow up on what Patrick was getting, but I want to get a little more granular about it. And I'm just going to talk about the prior panel. So you heard, I'm sure you read, Consolidated Scrap, I'm going to say it wrong, CSR. Yes, Consolidated Scrap's account, which I've not only heard here, but I've heard before. So is it NS's position that the purpose of your new demurrage or storage charge, whichever you want to call it, that is being paid by CSR, is to incentivize them to hire staff and to be open 7 days a week? Is that what you're trying to incentivize?
Sir, we're trying to incentivize them to manage their pipeline. And if they elect to use our track to store their cars, then there's an economic cost for that.
Yes, but I'm trying to find out, I think we're all trying to find out, what can they do if let me go back. Do we all agree with Kenny's statement that in an ideal world, nobody would pay demurrage because the system would function perfectly? That's the goal we're trying to get to. Do you agree?
It's Norfolk Southern's goal.
Pardon?
That is Norfolk Southern's goal.
All right, so if that's the goal, what are you trying to incentivize? And I use CSR because I don't think they're unique, but they were here and we have their specific facts. And then I'm going to talk about Olin. So what is it that you want to incentivize CSR to do? Do you want them to move their yard to a place where they have enough acreage to build more track? Do you want them to hire staff to operate 24/7? Are they lazy? What is the problem? And what are you trying to get them to do?
We are trying to incentivize them to manage their pipeline and their
But that's
fleet.
I want to know specifically, what can they do? Manage it doesn't answer my question.
Well, there are a number of things they could do. They could expand their facility.
Where?
Or add another facility somewhere else.
So they could buy
I
real
think Ben said
estate.
no one ever has talked to them.
Yeah, they did, they said you never came around, but now you're talking to them here. So A, they could go out and buy real estate. That's one thing they could do.
They could.
And then they'd have to have cars delivered to other real estate. Do you know what a scrap processing plant looks like and the kind of equipment you have to put in there to process scrap?
Yes.
So are you incentivizing them to go out and spend millions of dollars on new shredders and other things in another location that has more track? Is that what you're trying? I'm just trying to figure out how this is supposed to work.
Well, we're trying to incentivize them, or at least reflect the decisions that they're making by not being able to take all the cars in that come to them.
I understand that, but I'm trying to figure out whether this makes any sense for each shipper. This is a shipper that doesn't have real estate to add track, doesn't operate 7 days a week. So to accommodate you, who wants to deliver 7 days a week and give them no free time, they have to buy real estate, build track, buy shredders, or hire more personnel. Those are the things you're trying to incentivize, yes or no?
Well, we are having to build track if they don't, to store their cars.
Well, I'm just trying to get at who's building the track and who's going to pay the money for it. So,
But you aren't currently having to add infrastructure for
Well,
CSR. I mean,
they're consuming infrastructure that is available to the network.
but they weren't where they, and why didn't the previous 48-hour system work?
Our service metrics weren't where they needed to be. Our customers told us we need to improve our
So
service
if
product.
CSR comes to you and says, look, I can't meet the no free time and avoid the demurrage, and you heard the numbers that they gave us, 67,000, I think, just in the last month. If they tell you, I physically can't do it, so I want more free time, because they were not incurred these charges when they had more free time. Is your answer, take it or leave it? If you want our service, you will operate with no free time? Is that the answer?
I would say, to be honest, I need to find out a lot more about their particular situation, but I would say this in general. We keep referring to free time. That's free time to the customer or the receiver, but it's not free time for us.
Whatever you want to call it, is the answer, this is how we're offering our service. If you don't like it, ship your scrap some other way. Is that the answer?
Well, I think the answer is there must be an economic benefit for you to store your cars on our railroad if you're not going to do something else with them.
I understand your rationale. I'm trying to figure out what CSR's options are here.
We don't know enough about CSR sitting right here, right now, in order to.
I'll come back to Olin.
I think Marty's touching on a really important issue, because what I'm hearing from y'all is that when you're making these changes, you talked about an economic benefit, and I thought that Mr. Adams' presentation tried to lay out what that benefit was, because it was not just for you all, but it might be for another customer that can take advantage of that capacity or free up some yard space or what have you, and then things move fluidly. And I'm tracking, but I think what we're trying to think about here is there may be a benefit to you, but there may be a cost to someone else. So you might get a benefit, and one of the customers might get a benefit, and then another one of the customers might get a cost. And so I think one of the frameworks that we're kind of thinking about is, okay, so if customer A gets a huge cost, has to buy a new plant, really has to expand capacity, and customer B and your yard has some capacity. You don't have to build more track. You know, there might be some service issue, or like, you know, there might be some a performance issue, you know, just by using more capacity. But, you know, is the right framework to think about how much, what the burden is on that particular customer A relative to what you gain? Is that the framework that we should be thinking about?
I think the framework, and it is very complex because it is a network.
Right.
And there's hundreds and thousands of inputs
Right.
and outputs along the way. But our goal is to move our customers' freight from origin to destination as quickly as we possibly can. And frankly, handling cars around other cars that are sitting
I
there
hear you.
is inherently
But
inefficient
we're
and
operating,
slower.
I hear you, but we're kind of operating, you know, you all are saying, I want better performance, but, you know, and there's a benefit to it. And then you have, on this customer saying, you know, we're at a threshold right now where I can't change my behavior and I'm gonna incur a huge cost. And so, you know, if the board is thinking about what is reasonable in any one of these cases, should it be looking at, wow, this person would take $5 million to build a new plant, as you all were suggesting, or at least contemplating, and really, you know, the yard capacity is really not that much, and therefore that's not reasonable because the cost to this customer are so much larger than what you all gain. Is that how we should be thinking about it?
May I add a comment here, Vice Chairman Boots? So I think there's two sides to this equation that we need to think about. First and foremost, there are unintended consequences when our service deteriorates. So in other words, in the example that you just outlined, if our service was inferior and we were congested, many of our customers would have to find additional relief valves to move the existing traffic that they move today. Okay? So our goal is at the 5,000 customer level. Many of our customers do not pay demurrage. As I stated in my comment, 50% don't pay demurrage. And so when we look at the other 50% of the customers that do pay demurrage, what we're thinking about is how do we help customers, both upstream and downstream, so whether it's the Olins of the world who are the receivers or whether it's the shippers, how do we help them think through solutions that make sense in order to do business with the railroad? So, you know, as we think about a framework, my only concern would be, I think we have to think about both sides of the equation.
But it's at some point you got, you know, something stopped you all from raising per day charges to 500, okay? And, you know, something stopped some of you all from having zero free time. And I guess I'm wondering what the framework is the board should be thinking about for when something becomes unreasonable. Something stopped you.
Well, just to pick up on that, because we have a specific example here this morning, and I have to believe you folks from NS are familiar with Olin, because I'm sure it's one of your biggest customers. We're familiar with Olin because we were just there. Olin says to avoid your charges, they're going to have to invest $10 million in infrastructure. Are you trying to incentivize them to go out and spend $10 million? Is that how you would defend your charges to Olin?
Sir, I would say we're trying to make sure that Olin is able to make reasonable economic decisions about what they're going to do in the future.
No. Is that reasonable? In your view, you'd say that if that's 10 million, that's
I
what's
don't have
reasonable?
visibility into their business decisions and their business processes to make a judgment on that.
Yeah, but to follow on Patrick's question, you're asking them to spend $10 million.
We're not necessarily asking them to spend.
Sure you are. He just said that's the only way he can avoid it. You're not saying that he doesn't know what it's going to cost him to avoid your charges, are you? Is there some reason we should doubt Olin when they tell us it's going to cost them $10 million to avoid your charges?
No, I'm not suggesting that at all. I told you,
Well-
we do not have visibility into their potential solutions.
When Patrick asked you, how do you evaluate the cost benefit here and how should we figure out, okay, this is a good idea. Olin has to spend $10 million and NS can make these charges. That's okay. That's the way the system should work. I mean, we're supposed to just look up at a rock or something and say, yeah, that's a good way to do it? I mean, there has to be some somebody said here they want to make evidence-based decisions. Was that Kenny? Somebody? Yeah. I assume you all would endorse that concept here. So I'm trying to, what I'm struggling with is what appears to just be some arbitrariness to these numbers. And I just don't have an explanation. You know, Miller Coors, which won't come on until after you're here, but has a complaint says that you raised their demurrage from 100 to 150 a day, they say in retaliation for the fight over the Manhattan distributors. You're familiar with, you read their testimony,
Yes.
I'm sure. So was there a problem with Miller Coors that you had to give them an extra $50 because they weren't moving cars fast enough? Was there some evidence of that?
No, in the case of Miller Coors, it's about the equipment type, and what we try to do is reflect the demand for that particular equipment type across our system.
Did demand go up 50%?
Demand went up, yes, sir.
50%?
I'm not sure. I don't know. If it's
So
50%.
just so overall question here about, all of you tell us, so when you're trying to defend these things, that it benefits all the customers. Am I hearing that prior to the skyrocketing increase in demurrage charges that began in the last couple of years, and the numbers are astronomical in my view in terms of percentage increase, do I hear that your customer bases were coming to you and clamoring for you to increase everybody's demurrage charges so their service would be better? Is that what generated this?
Customers were coming to us and clamoring for us to improve our service product and turn equipment faster.
And
Boxcars were one equipment type and we were short. And you, the board, heard yourself from customers who had to use other forms of transportation when we didn't have boxcars available. So we needed to make a change to our operating plan. We needed to make a change to our accessorials so that we could turn the equipment faster and satisfy the needs of over 5,500 customers.
NS and UP has heard from the board over the last year and a half. I mean, frankly, when CSX did their new operating plan, a lot of that traffic went to NS, and you ended up sort of in a place where you couldn't really dig out, and you were under a lot of pressure. You've done a lot of phone calls with our board staff as UP, whether it was the hurricanes from last summer, just there were a lot of different steps to take. In fact, about a year ago in March, I wrote a letter to all of the carriers saying, so what do you expect for the rest of the year? I will say, no one said we plan to implement precision scheduled railroading. CSX, you already had been doing that. So a lot, things change sort of on a dime, even in the railroad industry, it seems. But what, I want to acknowledge that, yes, you have been having service issues. You are not where, I guess, your customers, where your board, where the nation's economy needed you to be. And so thank you for your efforts. Having said that, you get to a point where some things become sort of beyond the pale from what we are hearing. And I do hope that, if you haven't read testimony, read it. I'd like to know, Kenny, thank you for saying that you read the testimony, you've actually made some changes based on it. I'm curious to know if either of the other carriers have also thought about additional changes based on that feedback. The other railroad witnesses will be asked the same question. Feel free to come up with changes tonight that you can announce. I say that tongue in cheek, but not really. I mean, clearly, there's some constructive input based on all of this testimony.
Just real quick, Chairman Beckerman, we're going to continue to assess and reevaluate the charges we have in place. I can tell you that right now we've got some thoughtful, deliberate discussions on making another concession here. We just want to make sure we get it right, but we do appreciate the venue and the feedback from the customers.
Let me say, we are constantly evaluating our programs for their reasonableness and the effectiveness in terms of the outcomes.
Do you talk to your customers in that effort?
Yes.
A great deal. You're looking at the two most pro-shipper people in this room.
Hey, I don't know about that.
I'm going to introduce you to Ben Abrams when the meeting's over here.
You mentioned, that's what I'm trying to get at is, help us out in terms of how we should be thinking about reasonableness, because we've got hundreds of pages of people saying that y'all are not being reasonable, and shippers are saying ways that it can be more reasonable. You know, elements of reciprocity and other things that we were exploring in the first panel. And I'm not hearing from you all how we should be thinking about what is reasonable. You say you evaluate for reasonableness. What are your criteria?
Our criteria are based off the interactions we have with our customers every day, and we do have those every single day.
But what does that mean? I mean, you know, it's what, you know, there's going to be, I think there hopefully will be some network benefit to some of these changes, but you didn't do $500 a day. Does the benefit trail off? You know, I'm trying to get at, you know, why would maybe a one-way as a thought experiment would be, you know, some of you didn't do zero free time, okay, and some of you, all of you, don't have $500 a day. I'm not asking you to compare to each other, but for your individual decisions, are there things that you wanted to do that you thought would have a benefit for network velocity that you just thought, you know, they weren't reasonable? And if so, why? Specific criteria.
Specific criteria, and I'll attempt this, is we believed when we assessed our programs more than a year and a half ago that 5 free days was not reasonable. Based on the effect it was having on our network and on the rest of our customers. So we began to gradually draw that down, and the end state, of course, was 0. We urgently need to deliver value to our customers through service. And it's a very dynamic interplay between the accessorial programs and the service we deliver. I mentioned earlier that we increase frequency for our customers on a daily basis, quadrupled it. And that is not a cost-cutting measure. That's
Right.
That's putting more people in the field and more boots on the ground, so to speak.
But that doesn't help everybody. Some people are hurt by your increased frequency.
It does not. It does not help everybody, but we.
It helps the entire network, and it overall, it's to the benefit of our 5,500 customers.
So some customers have to pay for others. That's what you're saying.
There are
That's what you're saying.
inefficiencies out there, and the customers who more efficiently utilize the equipment will benefit.
But you're implying that a customer has an ability to respond, and that's what we're trying to get at.
Mm-hmm.
So physically, your system-wide change means that some customers are subsidizing you and are subsidizing other customers.
And if
I don't know how you get away from the simple arithmetic, but I'm not good at arithmetic.
Well, let's look at, so the $500 hypothetical, right? You know, you increase the dollar amount of an incentive, you would expect that you would get a certain change in behavior, right?
Yes,
Okay. Y'all didn't go to that level.
correct.
And I guess I'm just trying to, because we're trying to think about reasonableness here. And this is before you get to credit days and reciprocity of credit days and all that sort of thing. But I think, you know, generally speaking, the framework can be applied in different contexts. So, you know, okay, you guys stared at an incentive that you thought would improve network velocity, and you didn't do it. So that leads me to believe that either you thought that any dollar above what you're currently charging or any reduction in free time would not have an effect on network velocity, or for whatever reason you decided that whatever benefit to network velocity was not worth what you would be imposing on other customers. And I'm trying to understand why, or how you came to that decision.
Well, I would say this. I'm uncomfortable talking about the way we set prices or incentives with my colleagues here. Would be really glad to discuss this in private with you and talk about the methodology that we applied.
Okay. We'll all take you up on that. If you all could just explain to us what's a reasonable charge and what's an unreasonable charge. And if you think that it leads to specific issues, competitive issues, then we can have individual discussions. I do tend to think that you can maybe speak in, you know, I think the criteria for assessing reasonableness maybe doesn't get into the competitive issue, but if you think that the specific about how you apply that criteria to your business, then I'll take you up on having individual discussions.
Thank you.
Do any of you care to comment on some of the earlier testimony, such about the change in ownership of the fleet, and how it seems that the private owners are not being fairly, I guess, compensated, or they're it seems to be an imbalance of the changes, given what Demurrage's original purpose was for, to move assets owned by the carriers. I take that as a no.
Well,
Could-
if I may.
Yeah.
We are continuing to reinvest in our fleet. And we, over the past couple of years, we've reinvested in coil cars, we've reinvested in coal cars, we've reinvested.
But certainly that
There
it's
has been
changed
a
quite a bit,
shift.
yes,
Right, from.
a large one.
Have any of you ever considered compensating any of the private car owners that were here today when you delay in returning their cars? Have you ever considered it? I'll take that as a no. Okay.
I actually would like to talk a bit about your dispute resolution process for when a customer wants to, I guess, dispute a demurrage or accessorial charge. Some of the things that we hear is that the invoices are automatically processed and dispensed to the customer. I'm curious to know if you have what your deadlines are for when a customer has to basically say, hey, I want to challenge this. I think, Kenny, you lay it out in your testimony, but do railroads, what is your process? And also, do you have a time frame for when you must respond to your customer? And ideally, how quickly does a situation get resolved?
So, just real quick, Chairman Begeman, just to talk about some of the tools we have. We actually have real-time dispute tools during the month, which means that a customer can literally go into the system and see where their charges are on the 10th of the month, the 18th of the month. So there is not a surprise. There isn't at the end of the month the customer is saying, hey, this was something that I wasn't aware of. I heard the back and forth earlier about the number of days and disputes that were out there for months, and I can tell you that we respond on average in 10 days, but I want to differentiate a response from resolution. So on average, we respond in about 10 days. I'm sure there are customers here that would say, well, it took us longer to resolve. But we are going in, digging into the data, looking at the facts, and again, I just want to emphasize something. If it's something that the customer did or didn't do with their supply chain, then we do feel like they're accountable. If it's something that Union Pacific has done, then we cancel those bills. Even if, and I heard this a little bit earlier, even if it starts off on a different railroad out in the east, we're literally going in, looking at the way bills and reconciling whether or not we believe the bunching has occurred. So it's real time, so I want to take real time, but then we're also quick to respond, the 10 days, and the last piece is that we're looking in and getting all the facts.
Just one quick follow-up on that, Kenny. Do you do that investigation before you send the demurrage bill, or only if somebody challenges it?
On the disputes.
So you may send a demurrage bill where you're totally responsible for it, and you may send it anyway, and it only arises to the level of you're figuring out whether you're responsible if the customer disputes it. Is that the way the system works?
Roughly 95% of our bills are accurate, so
What's the basis of that?
we get that from the disputes also. There are sometimes reporting areas where
Well, you don't know how many people are getting bills that aren't accurate that aren't bothering to dispute it, do you?
about 8% usually dispute.
Yes, but there could be other people out there who get it's a small bill or it costs them too much to dispute it, so they just pay it. You have no way of telling us that.
Yeah, I don't have a way of telling you that, but I also don't have a way of saying that that's happening.
Okay, I'm sorry.
I have a completely separate question. But
Okay, well then I'll continue somewhat. UP, I've been here for longer than my colleagues, and I did remember in 2013 when UP was and remains the only carrier to sort of opt into the board's arbitration program, and you announced certain matters that you would be willing to arbitrate with your customers. I believe it was demurrage, accessorial charges, and misrouting or mishandling of rail cars with caps of $200,000. So one, thank you for that. I will say no one has taken you up on that gesture. I hope perhaps at this point, time goes on, maybe some shippers have forgotten your willingness to do that. I'm going to ask the other panelists whether or not you would consider participating in board-sponsored mediation, and the other future panelists I will ask as well.
Yes, ma'am. If we were approached, we would consider it.
Okay, so if the customer came to you, then you would kind of jointly come to the board?
We would consider it and see where we went. Yes, ma'am.
I just want to finish on dispute resolution then, Patrick. There's a couple of questions I had for NS. A number of people have focused, and you currently are unique among the railroads, on your $500 charge for the privilege of disputing a demurrage bill. What is the justification for that?
Well, our demurrage dispute process is robust, and we actually enhanced it as we made these changes. And the way our demurrage dispute process works today is our customers can go online using our online tools each day and see where they stand in terms of credits and debits. They can dispute any charge at any time during the month. It's a monthly bill, and they can dispute any charge up to 5 days after the end of the month for the previous month.
For no charge?
For no charge, and our commitment is a 2-hour turnaround on any dispute made online. So we take that process very seriously. Once you leave that period of time where
5 days.
the 5 days after the end of the month, then if we review the dispute and determine that the bill is correct, that is where the $500 charge comes in.
And if you determine that the bill is not correct, you pay them $500?
No, sir, but we do not charge them.
Wow.
And have you made some evidence-based determination that most shippers can figure out whether it is worth challenging a demurrage bill within 5 days, given the complexity of the system?
For our shippers, we've invested a lot of money in online tools and continue to enhance them. The honest truth is this: it's in our very best interest to have robust visibility for all of our rail users in our system. We want them to manage their pipelines. We don't want to manage the pipeline for them, for their product. So we try to make it as simple as possible. And I think we can show you some evidence. I don't have it today, but I can show you some evidence that we've made substantial investments to improve that process for our customers.
So your tariffs provide that if you litigate with a customer over demurrage and you win, the customer must pay your attorney's fees and costs going to court. You're aware of that?
Yes, sir.
You're also aware that the same tariff does not provide that if you lose in court or in front of this board, you pay their attorney's fees.
Yes, sir.
Have you ever heard of the concept in the contract law of a lack of mutuality? I know you're not a lawyer, or you don't say you are.
No, sir, I'm not.
You never heard that concept?
No, sir.
Can you figure out what it means?
I sure can.
Yeah.
It's
Do
okay
you
if
think
you're
that's
not a
fair?
lawyer.
Do you think that's fair?
Sir, our tariff is designed to reflect an activity-based system so that our customers the network can be efficient. And in the case of disputes, I really can't comment any further.
Well, but when you're wrong, if a customer has to take you to court and they win, first of all, listen, I've been in a lot of fee-shifting cases. There's a high deterrent for litigating if you're going to lose and you have to pay somebody's attorney's fees. So the fact that that's in there, I don't need any evidence to tell you, is a deterrent to many people from even challenging you, because they may not only lose the demurrage case, they may pay a fortune in attorney's fees. But I can tell you that if there was at least the opportunity to collect their fees, if they win, that would level that playing field. Do you see that?
I see what you're saying, sir, yes.
And you all talked about efforts to reduce errors and improve the system. Can you maybe talk us through some of the errors that you saw that you were working to improve? What are the most common causes of erroneous demurrage bills?
The examples that come to mind
Yeah.
are usually around the human interaction in the process, where our crews are giving a reason code for activity out in
Yeah.
the field, and either that's incomplete or in some cases missing, and we really take a strong stance toward trying to police that data and enhance it.
And to say interactivity code, now I saw in some of your testimony that crews are having more handheld devices and all that sort of stuff, and I kind of think supplying more evidence, to verify when something actually happened.
Mm-hmm.
And so, what specifically is being done to improve what you just described?
We have changed our operating procedures and requiring our crews to more timely input the information into the system after the switch is completed. And then the hopes is that our customers will be able to go to our online suite of tools and look at the individual activity relatively quickly while the information is still fresh in everyone's heads.
And do you audit it and enforce against crew error? I mean, just trying to think about what gives meat to the improvement.
We do. We have a process, particularly in any case where a code is missing or entered that would show that a customer action caused a charge. We have a manager that goes in and audits every one of those.
And maybe it's
Right.
I want to change away from dispute resolution, if y'all. If I can kind of get into another area, one of the things that kind of stuck out to me in your testimony and in the move to PSR generally is the whole idea of car trip plans and measuring yourself up against car trip plan compliance, which intuitively makes good sense. And I understand, the way a car trip is measured is sometime from when the customer releases it to placement. And there might be some margin in between, but generally, either actual or constructive placement. And so I guess I'm wondering, what is, just as a starting point, what is your current car trip plan compliance?
I'll take that.
Yeah.
I'll tell you what it used to be and what it is.
That'd be great.
It used to be 24 hours plus or minus of a day. So if we said it'd be there Wednesday, 24 hours, it might get there Tuesday or Thursday, we counted it on time. Today it's within 8 hours. So car trip plan is within 8 hours of whenever they said.
The original ETA.
Correct.
Okay.
Ours is plus or minus 24 hours to the original ETA.
We actually measure to the hour, so within the scheduled crew shift, so 8 hours.
And what percent?
I take it that no one uses the Metra 6 minutes on time.
And what percentage of car trips meet their original ETA?
For us, before the floods, it was at 73%.
On time or early for us is now above 90%.
Trip plan compliance for us is in the high 70 percentile range.
Okay, so for let's say before the 27%, if something is late from the original ETA, talk us through whether or not they get credits and whether or not they incur demurrage. So can you all say that every single shipment, every single car that does not meet its car trip plan on its original ETA, so therefore whatever expectation the customer had was somehow changed during transit in some way? And I know it's not getting into the last mile issue, by the way. Do all of those shipments get some sort of break on demurrage if they arrive later than what was projected to the customer?
Every load on Norfolk Southern gets a service credit. In fact, we doubled those last year.
Yeah, I saw that.
So every loaded shipment gets a service credit if it falls early or late versus that 24-hour window.
Okay.
Yeah, but just quickly, if it's not delivered in the serving yard, if it's in the serving yard and it's not delivered on time, then yeah, there's a credit.
If it's in the serving yard, but what about the original, if it doesn't meet its original ETA that was established when the car was originally released?
That's when we're looking at it and going back and looking at when the cars were way built.
Okay.
Yeah, so very similarly, once it hits the local serving yard, if for whatever reason it's a delay based on railroad service, we will automatically issue a credit to the customer. In terms of the overall service product, trip plan compliance and visibility and issuing a credit en route, we haven't gotten to that level of sophistication yet, but it is something that we're looking at.
And you all would agree that, going earlier in the supply chain would allow customers greater time to shift their operations and manage demurrage charges if in fact there was kind of, I hate to say reciprocal, but there was some sort of credit for lateness and some sort of burden kind of imposed upon them relative to their initial expectations. You all kind of, acknowledge that if you could get to that technological capability, it's something that certainly would be helpful to customers.
I would say there's a couple things that we're doing, whether it's dispute resolution or leveraging technology. We give customers end-to-end visibility from the time that car is actually released to the time it arrives at the local serving yard. So a customer has the ability to adjust, their opportunity, if you will, real time, especially if it's a 4 or 5 or 6 day transit. There's also instances whereby they have an opportunity to work with the local crew. If they're, let's say for example, it's a customer that's only getting 5-day-a-week service, and they have a car that comes into the yard and they have a relationship with the local crew and they want to pull that car in early, they have the ability to do that. And the same works in reverse.
And I'm just to be absolutely clear, when we talk about car trip plan compliance, we're talking about loaded release to placement, correct? And not empties. But a lot of the problems we were hearing were on empties. So, I saw some nods and such that, people thought generally it's a good practice if you miss your ETA that you give some credit if your technological capabilities are there. And first of all, let anyone jump in if someone thinks that's not a good practice.
Well, I just want to clarify. So when we talk about trip plans, we're talking about trip plans for all of our cars.
Right.
Right. So not
First
just
of all, on the empty side too.
Correct.
But do your empties get an ETA as well, or do your empties get a window whereby you have a window and then you have an order fulfillment rate?
Yeah. So there's kind of two pieces to that question. One is the system car. So in instances where customers are using our cars, we give customers a 10-day window to order in, and so at the third day they didn't have visibility to the arrival time.
So when you'll get an arrival time on that third day.
And as a general rule, we allow ourselves 7 days to be able to get the car released and then appropriately place it en route to a customer that wants to use a system car.
So you have a plus or minus 7 on the empty side. Am I hearing that correctly?
Correct. In terms of their ability to order the car, give us advance notification or sufficient lead time to move that car. It's a 10-day cycle, right? Because on average, it takes us 7 days to move that empty to the location where the customer needs to utilize it.
And one of the things I'm kind of beginning to appreciate is the difficulty with interline moves. Because you all might have an ETA for your segment and someone else might have an ETA for a different segment, and there might be a third-party logistics person, but their third party might be historical data and not your actual operational data. And so there's this kind of a big web where you either can have multiple platforms that aren't talking to each other, or you can have one platform that's maybe not as perfect as the railroad platform, or as good as the railroad platform. So from a visibility standpoint, the customer is in a difficult spot, I think, on a more difficult spot on an interline move than, of course, a single carrier move, and I think that's obvious. A couple of things on the interline. First is when one carrier gets to an interchange and offers up traffic for another carrier, and let's say that second carrier isn't ready, does that second carrier pay the first carrier? In interchange. So there's an interchange, and something was released to the other carrier. Is there some sort of car hire maybe?
Car hire.
Well, yeah.
Car hire.
So you're using one of the railroad's tracks, and there's a car delay. Talk me through why car hire is the only charge there, and you're not charging the other railroad demurrage. When you offer something up an interchange and another railroad's not ready to pick it up, it's using your car, it's using your track. Why doesn't that railroad get demurrage?
Because they won't pay it.
I'm just kind of, you know what I mean? It's the same concept, right? It's about network fluidity and incentives.
My understanding is car hire is the governing structure that we use economically. So I think that's the way we've structured.
But the car hire doesn't have the penalty component that demurrage does, right? Demurrage rates are significantly higher than car hire charges. So if the customer is using your track and car, you want to the whole purpose of demurrage is to incentivize the customer to change behavior. I guess I'm wondering why you wouldn't want to adopt the same incentive structure for the railroad that's delayed in picking something up an interchange to change behavior.
Well, I can speak for our railroad as a net receiver, and I'm certain Norfolk Southern can appreciate this. We are a net receiver of cars. So I can tell you car hire for us is a very big deal. And on an annual basis, it is significantly more than demurrage. So we have every incentive to partner with our interline partners to move cars as quickly across our network as we possibly can. And I think if, as an industry, we want to explore a different structure, I think that's a conversation that we should have.
And I guess I'm wondering, and I don't mean to be too, because I know the car, and the way you guys interchange is extremely complex, and it's developed over years, and I don't mean to say disruptive, but I'm trying, it's again trying another way to get at that incentive effect. So Mr. Adams, you said that the car hire charge on a rate basis was sufficient to motivate you. But then there's a judgment call made for the shipper that car hire charge, which is much lower than the demurrage, isn't sufficient to motivate the shipper. Do you know what I mean? And it's for the same thing using a railroad's track and car. And so it's like the shipper needs a higher incentive than the railroad, or talk me through that.
Are you saying on a monetary basis?
Yeah.
But I can tell you for us, car hire is substantial. So it's
But not on a rate basis, on an instance basis. So if you're using a Western carrier's track and car, you are paying a lower rate than a shipper that's using a Western carrier's track and car. Is that? I mean, it's a fair statement. Car hire and demurrage are different things, but it's a fair statement, right?
I think in the interest of accuracy and transparency, I'd rather get more information to respond.
Okay.
Okay, I'll try to be relatively quick. I want to give CSX a chance to respond to my question about board-sponsored arbitration. I know you nodded and gave me a thumbs up, but that may not translate.
Chairman Bagman, just to respond on the arbitration, I think you would recognize that we have time and time again utilized the board's resources on whether it be OPAGAP and Lucy Marvin's team that do such a good job serving in that mediation role from time to time, or whether it be even in rate cases where, again, CSX on more than one occasion has utilized the board's good resources on mediation, taken advantage of those, and then brought about a mutually agreed upon solution with the customer. And then here, too, we are always open to alternative dispute resolution, always. And so if a shipper were to bring to us a dispute on arbitration, we would highly consider it.
Great answer. My second question is just would any of you care to comment or respond to the testimony from Kinder Morgan and the other intermediaries that we're going to hear from later on, the third-party folks? Any comments you have based on what they have said as far as?
So when we think about customers, we think about all customers very similarly, right? So whether it's a shipper or a third-party logistics provider or a receiver very similar to Kinder Morgan. And our goal is to actively engage them very similarly to the way that we engage our shippers. My observations of our receiver community is that there are many instances where our warehouse partners and our receivers are being very successful using the scheduled railroading principles around efficiency and supply chain optimization. My recommendation would be that the third parties play an active role in managing both upstream and downstream in order to ensure that they're able to effectively manage their inventories as they come inbound, and more importantly, on the outbound side, I would also respond to Kinder Morgan in particular in terms of how we view the interaction with the receivers. Every customer that's a party to the waybill has access to the information in Ship CSX. So under no conditions is there a receiver or a warehouser that's flying blind relative to inbound inventories that are coming in.
But they can't necessarily control it. It's more the shipper saying, no, I don't want it yet.
Well, I think
Right.
I think it's incumbent upon the receiver to have active dialogue with the shipper to ensure that they don't create congestion, both in the yard and also congestion for that particular receiver. To suggest that somehow that's the sole responsibility of the shipper and the railroad, I don't think that's appropriate, because there are three parties involved that should be communicating to ensure the most optimal outcome.
Just on this point, though, but you understand Kinder Morgan to say that the way the billing works, where the bill is imposed on intermediary on a quote no-fault basis, they have no leverage to work out anything with the shipper, because the way you, the railroads, are billing them in general, I assume all of you are. Did you understand that part of the problem? So how do they solve that?
I understand it. I don't disagree with it based on my experience dealing with receivers. Again, I think that if there are congestion issues that are being caused upstream, I think the receivers have a couple different options. They can always build back whatever those incremental demurrage charges that they are receiving. They can build those back in some accessorial form to their shipper. They can work with their shipper to develop a more optimal supply chain so that they aren't creating congestion in our yard, nor for themselves at the last mile, are the solutions that I would offer up.
You know, all I can tell you is that we're working with all the folks in the supply chain. So if it is the receiver, we are giving them tools to manage, and we are taking that all the way throughout the supply chain at the origin points and working with them to ensure that they aren't sending too many cars. So that's an active discussion. It's not a situation where we just have or just inserting the technology. We're actually working with those receivers.
And at Norfolk Southern, we believe everyone in the supply chain has a responsibility to the network. Certainly Norfolk Southern has a responsibility to supply a stable, reliable environment for our customers to succeed. And our customers, receivers, shippers, consignees have a responsibility to promote a fluid network.
A couple more isolated points to tie up a few things that we've talked about. On the question of your congestion charge, this is to the NS folks. Everything I've read said there's no definition of congestion. How does the shipper know when they're going to be socked for a congestion charge?
As I said earlier, we're always evaluating our programs to make sure that they are reasonable and effective. The tariff, and it's in our May 1 submission. It's really the definition of 2 days of inventory for that customer based on their recent switching activity in terms of how many cars they can take in or out. So it's 2 days is a sort of a threshold, but we really try very, very deliberately to tailor that to local conditions, if that makes sense.
Well, you know, Mr. Chirimboli, I'm not sure I pronounced that correctly, says he doesn't know how you compute it and therefore can't avoid it. That's the essence of what I heard. You heard him this morning.
Did.
So how could that happen if you've defined it for him?
We do define it for him, and we work diligently to try to work inventory down before we impose any charge.
I think maybe I should introduce you to him too when the
Yes, sir.
hearing's over. Mr. Patelli, you're unfortunately the only lawyer identified on here, so I'll direct this question to you. Others can answer it. Do you share CN's view that under Section 746 you are mandated to bill people for demurrage? You don't have an option?
Yeah, Commissioner, I think it's helpful to go back to that language. 10746, rail carriers shall compute demurrage charges and establish rules related to those charged in a way that fulfills the national needs related to freight car use and distribution, and 2, maintenance of an adequate supply of freight cars. So I do think that Congress, the intent of Congress there is very direct, right? I think that language makes it very clear how important it was for railroads to use demurrage, to help control network flows on their network, right? And it's reflective of the fact demurrage has been around for a very, very long time. I think in some respect, probably when Congress put that language in, it was an assumption, right? That it's here today, it's going to be here forever. And it's also an acknowledgement and recognition that it is a very important tool for controlling network.
But Congress doesn't tell you how to set the demurrage rates. You think you'd be in violation of the statute if you reduce the free time if you increased it from 24 back to 48 hours? I mean,
No. I do think that actually inherent in that language too is flexibility and discretion on the part of the rail carrier.
Well, that's
I
sort
think
of what I was getting at. CN doesn't seem to take that point of view, and I wanted to see
Well,
if you did.
I do think there's a directive there. Shall compute demurrage charges. I do think there's a directive there, and I think, I'm trying to get, I
So
haven't looked at the
well,
legislative language.
The shall is the way I read it is the computing, not the sending the bill.
Yeah, I do think, some of this is probably an open question, but if you thought about it all the way through, like if you had a hypothetical where a rail carrier just didn't have demurrage, right, in their published tariff, for example, and let's say their service was highly inadequate, would the other customers on the line who are efficiently managing their assets have some sort of complaint towards that railroad for not doing what this statute says very clearly, shall compute demurrage charges? I think it's a question. I don't pretend to have the answer right now, but it is clear.
Well, and it's something that we see
To be
in
sued for not.
it's something that we see in history too, in terms of, as I mentioned in the 1906 car shortages, right? And then the establishment of the Uniform Code, and then there was big increases in demurrage, during World War I. And, when we see that, to your point, there are some aspects where, demurrage does provide an incentive effect that is recognized by statute. And I think the situation we're dealing with is the other way on the reasonableness then of those practices.
Yeah, well, and that leads into sort of my final area. All of you have talked about trying to modify your systems over the last 2 or 3 years, and it's a work in progress to get from here to there. So we've heard witnesses, and I'm sure they're not unique, but just take the ones we heard this morning. So Olin says they're considering, I gather, investing $10 million in order to have more, I guess, storage or space to put cars on, to avoid your charges. So if you understand that the change in the system is something that will cause shippers to change their behavior over time, one of the things I'm struggling with is that you didn't give them time, particularly where it's a long term. Mr. Giramboli says it'll take a year for them to build this new infrastructure. In the meantime, you slap these demurrage charges on them. So if one of these shippers comes to, and any of you could answer it, but the example was NS, and says, look, we're willing to spend $10 million to avoid these new charges, but it's going to take us a year. So don't bill us during the year because now we're paying twice. Are you open to that?
Sir, we're always glad to talk to our customers. We do it every day, and we will continue to do that.
Has anything like that happened in the 2 or 3 years since you've embarked on this program? Any of you?
I would rather not answer that in an open forum.
Well, you don't have to name the customer. I'm just talking conceptually. Is it something that has happened, and are you willing, and have you actually done it in a way that shows us you're willing to do it?
I can answer that for UP. We have made exceptions. Every case is unique. Every customer is unique, so there are exceptions out there. The other thing is,
do they center around this concept that it will take the customer some months or a year to get their shop in shape to meet your requirements?
Directionally, yes. The other thing, though, and I've said this before, and I'd be remiss if I didn't say it again, is that we were deliberate in how we looked at assessing the charges, and we do have, we are aware of which customers and how much can support the 24 hours. My response was the majority. I don't feel comfortable going into the details there, but I can tell you that at every turn we have worked to ensure that we minimize, and we want to be at zero. So,
CSX?
Yes, sir, Member Oberman. So to answer your question pointedly, the answer is yes. I personally have been involved with a number of different customer-specific issues whereby customers have requested lead time in order to build infrastructure or to fully optimize their supply chain to minimize their exposure to demurrage. And that's a conversation that we will continue to have with our customers.
And when they do that, do you then say, fine, we won't charge you the demurrage while you're making those expenses?
There are instances where we've done that, yes.
Well, that will conclude panel 2 at 1:20. Thank you all very much. I want to just say something before it gets loud. We're going to make one quick change in order. Rebecca Dye from the FMC is going to go next, and then the next panel will follow her. And I also would like to acknowledge another important person in this room, Mr. Ron Patori from the FRA. Thank you for attending. Someone should get him a seat.
Likewise,
Thank you.
Yeah, thank you for attending, Administrator.
And really, thank all of you for your testimony. I appreciate it.
Thank you all.
Our next witness is Commissioner Rebecca Dye from the FMC. Thank you, and thank you for sitting through most of this hearing so far.
I learned a lot. Thank you.
Thank you.
My compliments on a good hearing. Thank you very much. And I'm pleased that you would allow me to appear before you today to discuss the recommendations of the Memphis Supply Chain Innovation Team. Federal Maritime Commission has employed a new approach to seaport congestion called Supply Chain Innovation Teams to develop commercial solutions to freight delivery underlying operational problems. The Memphis team arose out of the Commission's current investigation of ocean carrier and marine terminal demurrage and detention charges. And as I said, we've gotten lots of good ideas today. And thank you for the opportunity to come over and talk to you about our approaches. And I look very much forward to our continued collaboration on our mutual concerns. The team in Memphis had a lot of experience in delivering international ocean freight, and I originally was awfully concerned about going and leading that team, but then I talked to my lawyers, and they said, sure, these are ocean freight moves through the rail ramp in Memphis. And then I came over and talked to you, and off we went. In our first meeting last May, the team agreed that the most critical need for improvement in freight velocity and fluidity in and out of the rail ramp in Memphis was for a single, inoperable gray pool of chassis. How chassis are made available has become a critical element of American international supply chain productivity. The Memphis team concluded that the essential qualities of this high-performing gray pool are, number one, an adequate supply of interoperable chassis. Number two, safe and good quality chassis. Number three, reasonable access to choices. Choice on merchant shipping when the shipper or the trucker has responsibility for delivery. And finally, most important, a pool manager with authority and accountability for chassis quality and supply. Strong support for the gray chassis pool was expressed in this December meeting in Memphis, included 4 Class 1 railroads, BNSF, UP, CNN, and CSX, and from our Ocean Carrier Association, OCEMA. And I also want to ensure the board that the 2 major chassis providers were also at the meeting and represented at last December's meeting. Major importers and exporters shared their stories of millions of dollars in inventory held up in congestion in Memphis, resulting, they believe, from lack of chassis. American cotton and paper exporters shared the loss of export sales, millions of dollars in additional air freight costs to prevent mills from shutting down overseas. The impact of these service disruptions from the past 2 years has drastically affected cotton and other agricultural competitiveness and reputation in the market. In summary, the Memphis team concluded that current chassis provisioning is not keeping up with intermodal demand, and change is necessary. In the first FMC supply chains geared to port congestion, seaport congestion. In 26 and 2017, we observed that where in our supply chain there are direct customer relationships, there is at least a vehicle for commercial problems to get resolved. But when no customer relationship exists between a provider of equipment service and the user of the equipment or service, operational problems are magnified. In our inland rail locations where most containers are mounted on chassis, there is no customer relationship between truckers and chassis providers, or even involvement in chassis provisioning decisions that are made by others. For this reason, I support greater provider choice for motor carriers. The Memphis team has prepared a white paper. We believe that this initiative would alleviate a lot of underlying problems, and I ask that the white paper and my full statement be included in your hearing record. Thank you. I look forward to our greater collaboration. I much appreciate this opportunity today to discuss their findings. Next steps for them is to get a little more visibility for their findings. This is the first time that this chassis pool issue has ever been completely considered. And it is a problem in the seaports. Since 2009, and ocean carriers began to divest their chassis equipment. Thank you. I'll be glad to answer your questions, or for the record if you prefer.
Thank you very much for joining us, and thank you for the various meetings we've had over the years. Working more collaboratively is something we certainly enjoy doing. It's a great opportunity, and one of the things I think that is terrific, which I'm going to try to emulate, is the fact that the FMC can assign a project so important as the project that you undertook to another colleague, and I think that is something I could certainly trust my colleagues with as well. So thank you for that, because there's plenty of work to go around. So
Yes.
Thank you. We will save questions, but
Yes,
thank you
it's a
for
great
the
regulatory
flexibility.
tool.
Thank
And
you.
likewise, Commissioner Dye, thank you for everything you've done for supply chain innovation teams and for leading these solutions. Thank you.
Thank you. Thank you again. Good day.
Thank you.
We will now go to the third panel. Please join us. And I know that at least one person unfortunately had to leave with Herman's group, and I know Brad needs to catch a plane momentarily. So if anyone wants to swap orders, please do so.
Thank you. So I'll kick off this panel. Some familiar faces for our stack and RETAC and other forums. So thank you all for being here, and we'll start with Matt.
Good afternoon. Am I heard? Good afternoon, Chairman Begeman, Vice Chairman Fuchs, and Member Oberman. My name is Matt Brainerd. I am owner and chairman of Brainerd Chemical Company, a chemical distributor based in Tulsa, Oklahoma. My remarks will also express the concerns of many members of the National Association of Chemical Distributors. Brainerd is a major supplier of chemicals for over 3,000 customers across the country. Among these locations, we have 7,000 feet of rail spur with capacity for 82 cars. Brainerd receives an average of 11 million pounds of bulk product each month via rail. Dependable rail service is essential for Brainerd in servicing our customers. A substantial percentage of NACD members receive products by rail and depend on timely shipments in order to meet customer demand. Brainerd's ongoing concerns about demurrage charges have become worse in recent years with the Class 1 railroads' reduction in the amount of time allowed for us to accept rail cars from 48 hours to 24 hours. This means that if the railroad arrives with a car at 11 p.m. on a Friday, we must take the car by 11 p.m. on Saturday in order to avoid demurrage charges. If the switch of the rail car to our plant does not take place, we must request a shipment problem resolution through the railroad's website. This is a frustrating and time-consuming experience. There is little opportunity to negotiate delivery terms with customer service as the process is all online. I have a recent example of how this process can break down, resulting in demurrage charges for Brainerd and excessive company staff time working to resolve the problem that was created by the railroad provider. This incident took place in our Danville, Illinois plant that is served solely by CSX. On February 19th, my staff ordered a switch of 2 rail cars. These cars that were sitting outside our gate should have arrived Wednesday, February 20th, but were not delivered until Friday, March 1st, 9 days after their requested date. CSX informed us that the cars were not delivered due to a system issue on their side. Then they told us the cars had been placed when they had not. During this time, we received daily demurrage charge summaries with 0 balances. In mid-March, we received an invoice for $1,500, despite the fact that the delays were initiated by CSX. My staff emailed the CSX contact on the invoice and was told to go through the dispute process on the CSX website. Since then, members of our accounting and operations teams have worked to escalate the problem with CSX. Just this week, I received a statement from CSX with a 0 demurrage balance. There was no additional communication from the railroad, even though the wrongful charge was corrected. There is no way to recapture my staff's extensive time and effort in resolving the dispute. Of Brainerd's 3 facilities with rail capacity, Danville is the only one served by just a single Class 1 railroad. Our other facilities with rail are both in Oklahoma and are served by much more responsive short line railroads. Recent changes in railroad demurrage policy have had a negative impact on Brainerd and other NACD members. I commend you, Chairman Begeman, for recently writing to the Class 1 railroads expressing your concern about their changes to demurrage charges. Demurrage is intended to serve the public interest by facilitating the flow of commerce through the prompt loading and unloading of cargo. These fees were meant to improve efficiency, not generate 9-figure revenue lines for Class 1 railroads. This already challenging situation for rail customers has become even more so with the Class 1's adoption of precision scheduled railroading. PSR has created enormous delays for rail customers like Brainerd while also imposing more restrictive service conditions. For example, the reduction in the amount of time allowed for us to accept rail cars from 48 hours to 24 hours means that Brainerd must have employees on call more frequently to receive rail cars or pay demurrage. To provide incentives for both customers and railroads to move product and rail cars more efficiently, Brainerd and NACD support the establishment of reciprocal demurrage. Under this system, when a railroad fails to pick up or deliver cars, the shipper or receiver would charge the same demurrage rate per day to the railroad. Reciprocal demurrage would provide railroads with a reason to move product more efficiently and help Brainerd and other rail customers to recover lost costs due to delays. Brainerd and other NACD members need reliable, efficient, and affordable rail service to operate our businesses and serve our customers. We commend the board for investigating unreasonable demurrage fees and look forward to working on proposals to create a more favorable rail service environment. Thank you.
Thank you. Brad?
Good afternoon, Chairman Begeman, Vice Chairman Fuchs, and Member Oberman. My name is Brad Hildebrand. I'm the Vice President and Global Rail and Barge Lead for Cargill, Inc., based in Minneapolis, Minnesota. Cargill's purpose is to nourish the world in a safe, responsible, and sustainable way. Cargill is a major grain trading and ag processing company with over 200 locations that are rail served here in North America. We operate in 70 countries and employ 150,000 people around the globe. As the global rail and barge lead for Cargill, I work closely with all the Class 1 railroads to secure competitive rates and service to deliver our grains and products to customers throughout North America. I also help oversee the 19,800 private rail cars that we use to transport these goods. I appreciate the opportunity to share my views and recommendations on what should be done to curb the growing cost of demurrage and accessorial charges. I've often referred to accessorial charges as death by 1,000 cuts. Death by 1,000 cuts. Individually, each charge is $200 to $500 per infraction. When multiplied over the months and year, they add up to significant dollars. Cargill spends millions of dollars each year on these charges. Over the past few years, we have invested in more track space at our facilities in an effort to reduce our demurrage cost. Despite making these investments, our demurrage cost last year was about the same as it was in 2017. I find it interesting that the railroads will tell you that demurrage and accessorials are really a small part of their overall revenue. Many will say that they would rather not collect these charges if they can avoid them. If it was such a small part of their revenue and something they really do not want to collect, then why would the Norfolk Southern dedicate an entire team of individuals in defending these charges when you call to dispute them? They call this team the Revenue Defense Group. I see they're here to defend that. Demurrage and accessorial charges are one-sided and also difficult to dispute. Get reduced or eliminated. As way of example, the NS has a tariff that states that they can charge you $500 if you dispute a charge and they find out that they were right. We just got hit with one of these about a week ago. The latest round of demurrage and accessorial charges that have been announced are increasingly punitive and costly to shippers. Take, for example, the Union Pacific's charge for taking power off unit trains. If we cannot turn a unit train around in 24 hours, we have to declare this when the train arrives. The UP then charges us $3,200 to remove the locomotives. Then they charge you another $3,200 when you call them out to pick up the loaded train. We currently see these charges with our ethanol trains. Typically, we do not have a loaded train of cars waiting for the empty train to arrive. With this change, the UP is now collecting another $6,400 on every train of ethanol that we ship. Imagine yourself walking into a McDonald's restaurant and being confronted with a list of charges, like things like taking too long to order a meal, sitting too long to eat, or trying to dispense ketchup out of one of those pump containers. While this might seem like a far-fetched extension of demurrage and accessorial charges, I have to ask you one question. Where could you get away with imposing these charges in any business today and still retain your customers? The answer is the railroad industry. The railroads seemingly have the unchecked power to extract these types of charges. So, what can the STB do to step in and protect shippers from these ever-increasing charges? I offer the following recommendations for your consideration. Let's start with demurrage. Currently, we are paying $100 to as much as $200 per day for railroad cars that are on demurrage. A covered hopper costs $80,000 today. If you apply $150 per day demurrage rate for a railroad-owned car that sits for a year, that comes to $54,750. $80,000 for the car, 1 year's worth of demurrage, $54,700 That's a 68% return per year. As a comparison, credit card companies charge you 15% per year on outstanding balances. Now, let's take the barge industry. They charge demurrage like the railroad industry, however, they are a competitive marketplace. They have a demurrage schedule for covered barges that gives you three days to load the barge. After that, they charge you $300 per day for the first 10 days and then $400 per day thereafter. A new barge costs $600,000. A barge is 7.5 times more expensive than a hopper car. Applying this factor to the $300 per day barge demurrage rate gives you a rail cost equivalent rate of $40 a day, not the $150 that many carriers currently are charging us. Another idea the commissioners might want to consider is setting a maximum demurrage rate using the weighted average cost of capital that is currently being calculated by the STB each year. This rate could be applied to the weighted average value of the carrier's car on their books to come up with a daily demurrage rate. My first recommendation is for the STB to make a rule that states or sets the demurrage rate basis a competitive marketplace like the barge industry, or sets a rate that is in line with their weighted average cost of capital for railroads. Next, I'll turn your attention to private car demurrage charges. The Class 1s charge anywhere from $75 per day to $150 per day for private car demurrage. These rates are typically close to the railroad-owned car demurrage charges as discussed earlier. The big difference is that shippers are paying for these cars. Companies that have track space to store cars in the United States charge anywhere from $3 a day to as much as $25 a day. Compare this to the $75 to $150 per day that the Class 1s charge us for private cars. My second recommendation is for the STB to make a rule that sets the charges for private car demurrage at the national average rate for storing cars in the United States. This is a market-driven cost calculation that is something akin to the national average highway diesel price that the STB okayed as a cost proxy for setting fuel surcharges. Moving on to accessorials. I would recommend that the board review the types of accessorial charges that are being imposed on shippers today, looking for reasonableness within these charges. You will find charges for diversions, reconsignments, extra switching, weighing, moving cars to pull, release cars, etc. There are also charges for incorrect bills of lading, disputing demurrage charges, as I just mentioned, and refunding us money when we've overpaid a freight bill. This last category of charges should be prohibited and thrown out as unreasonable. The railroads make errors and mistakes just like we do. They should not be allowed to charge us for these petty things just because they can. We currently have no way of charging them for our time to research and dispute erroneous charges, as Matthew just mentioned. The NS does not allow us to charge them $500 when we dispute a demurrage charge and we prevail. The railroads are more profitable today than they've ever been. They're buying back billions of dollars of their stock each year. While we have no issue with the railroads making money, these demurrage and accessorial charges are getting out of hand. What I'm recommending is that the board establish some rules and guidelines that add some competitive market-based costs to what can be charged for demurrage, private car storage, and accessorial charges. Each category of charges should be examined for reasonableness. Let's put some fairness and balance into a system that is totally one-sided. I hope that you will give my recommendations some considerations. Thank you for your time and your support in this effort. This concludes my comments.
Thank you, Brad. Jean?
Good afternoon, Chairman Beckman. Good afternoon, Chairman Beckman, Vice Chairman Fuchs, Commissioner Overman. I'm Jean Sebring from International Paper. Thank you for the opportunity to testify today and for holding this hearing on a very important issue impacting rail shippers. International Paper is a leading global producer of renewable fiber-based packaging, pulp, and paper products headquartered in Memphis, Tennessee. In the U.S., we employ 33,000 colleagues across 26 manufacturing mills, nearly 200 converting plants, and a network of 16 recycling facilities, as well as several corporate locations. The size and scope of these operations put IP among leaders of movement of freight domestically and from U.S. ports. More to the point of today's hearing, however, IP is the largest boxcar shipper moving on U.S. railroads, shipping more than 135,000 carloads annually. We are served by every Class 1 railroad and many short lines. Our mills rely heavily on rail for inbound raw materials such as chips, recovered fiber, and chemicals, and for outbound production that ships predominantly in boxcars. Because we are highly integrated, often our mill production ships to our many converting and distribution facilities in addition to the traditional external customers. This integration increases our exposure to rail service failures when they occur because we often experience the repercussions on one or both sides. Over the past 2 years, many of our rail partners have taken us on their journey toward PSR. Over this time, IP has had to contend with reduced service and unmet carrier commitments, increased rates, and a dramatic growth in demurrage and accessorial fees that are increasingly unavoidable the way they are constructed. These supplemental fees are an apparent and growing revenue opportunity for carriers, while it places a heavy burden on shippers' costs, labor, and administrative overhead. The equation completely lacks commensurate shipper-side value. Consider, too, that these burdens are occurring on top of ongoing operational volatility and rising carload rates. This is the impetus for our testimony today. Carriers will tell you that demurrage and accessorial charges are not only compensatory, but that it incentivizes good shipper behavior for promptly turning cars at the dock. However, it fails to recognize the operational realities contributed by carriers and now the near unavoidability of penalties under the new demurrage and accessorial provisions. Some examples being reduced switch frequency, which has often led to last mile service issues. Longer and fewer trains have created higher stakes when failures occur, leading to more bunching and more volatile end-to-end transit times. And of course, changes to local serving yards have also heightened risks for service failures. These are just some of all the things that can affect flow into a facility and our ability to planningfully turn cars without incurring one penalty or another. As a result, since the adoption of PSR, IP has seen demurrage more than double to over $7 million when comparing our most recent full quarter, quarter one of this year, to the same quarter in 2017, which would be before PSR. Note that I said over $7 million in quarter one. These are actual costs paid by IP after the validation or dispute process has taken place. In 2018, we successfully disputed over $2 million in fees by allocating 2 people nearly full-time to focus on demurrage tracking for just 2 of our facilities. Given my time allotment for testimony, I would like to walk you through just a few key examples. I'm happy to provide more information or additional examples to the board separately upon request. First, I'll speak to our experience with CSX, given our footprint with them and the head start they had in PSR over the more recent implementations by NS, UP, and KCS. Toward the end of 2017, CSX notified us of tariff changes that would take effect at the start of 2018, failing to recognize that their operational changes and service delivery were important components to a customer's ability to turn equipment and thus avoid supplemental charging. In that same time frame, CSX also expanded their weekly car fulfillment window from 7 to 14 days to fill our weekly car orders. At the same time, the shipper had to pay $300 per car for any cancellations or reductions done after 3 days from the date of the order or if within 7 days of the order week. Essentially, what they did was they loosened their obligation window and tightened ours, with a financial penalty imposed only on one side. But it also increased the potential for bunching empty cars into a facility, thus triggering penalties and further downstream impacts at our receiving locations as well. No consideration exists for the customer disruption that uneven supply could cause to our operations or even potential lost business, except for the heavy and uncertain burden of dispute resolution that is limited only to what shows up on the carrier's bill. At one of our mill complexes in the southeast, that is CSX captive, Changes in CSX's demurrage and accessorial charges have worked in tandem with reduced service execution to drive increased cost to IP. At this complex, we face numerous challenges, among them unreliable and inconsistent car supply, where less than 43% of weekly car orders in the last 12-month period were met at a 95% target fill rate or better. Poor last-mile execution, where the mill orders in very specific cars to support very specific planned production, and CSX just brings in different cars. Bunching of rail cars, where despite suppliers originating our rail cars on different days, CSX has frequently brought them to the mill on the same day. Naturally, this reduces our ability to unload and turn the cars in the allowed free time. And of course, volatility in transit times, where CSX's inconsistent performance reduces our planning and predictability and impacts how and when we can turn cars when they do not arrive as expected. As a result, this particular complex had a 39-fold year-over-year increase in demurrage fees compared to our most recent full quarter comparing our most recent full quarter to the same quarter in 2018. In fact, hearing about the trend line might help when you compare the demurrage paid in Q1 in each of the last 3 years. $910 in 2017, again pre-PSR, followed by $9,600 last year, and now $376,000 in the current year. Fee acceleration of this magnitude cannot be absorbed by manufacturers competing in domestic and global markets. Reciprocity is also lacking here. When carriers fail, and they often do, shippers do not have the same ability to charge their carriers for the operational harm that is done to their business. I'll quickly share one other example that just typifies the worsening administrative burden on shippers. This one concerns events from just this January of this year at another one of our mills in the Southeast, and it stems from reduced cooperative boxcar pooling by carriers, something that we saw as an offshoot of PSR. This dual-serve mill was surprised by $14,000 in adverse loading fees from CSX that, upon copious research, discovered it was for NS's delivery of 7 empty cars to fulfill an NS car order. IP subsequently loaded out these cars back to NS routes, and by all appearances, it looked like we did all the right things. The investigation showed, however, that the cars were actually owned by CSX, but NS supplied the cars to the mill. Unfortunately, once IP or any shipper receives a bill like this, the burden falls to us to make the case. We either become embroiled in sorting out the situation, or we accept the charges. These are often really very labor-intensive cases that require pulling and reviewing detailed communications, IP and rail move records, dates, circumstances, times, all in support of a dispute, which in this case, ironically, stems from issues between the two serving carriers. Dedicating the effort needed to research and dispute supplemental charges requires will, countless hours, and extra overhead to drive resolution. Demurrage issues can be especially complicated due to the possibility of upstream causes like service disruptions. The burden is on the shipper to verify and dispute billing issues that may arise from the carrier's operations, sometimes their process changes, or sometimes simply imperfect or missing data. While I'm not saying that these invoices are released without due diligence, I am saying that the customer bears the brunt of disputing these invoices, even in the event the charges are dubious. The toll on our company's productivity is sizable, especially now that these types of charges are rising. This is time that could be better spent working with customers or driving other supply chain improvements. So in closing, I want to just say the implementation of PSR across many of the Class 1s has led to significant operational issues and rising costs for U.S. manufacturers. Railroads continue to add new fees, like NS's congestion fee, that are still so new that we cannot speak to impact yet. But these fees look highly subjective in nature and raise further concerns about the financial burden and as well as the time and effort required to dispute the reasonableness of the application. The focus on PSR and the use of supplemental fees as part of it only grows more cumbersome, expensive, and without commensurate gain in shipper-side value. Left unchecked, it will continue to impact shippers and, by extension, the broader economy. International Paper greatly appreciates the efforts of the board in holding today's hearing. We value our partnerships with the railroads and will continue to do our part to be a strategic customer. However, without continued board oversight, these added fees will undoubtedly continue, and we look forward to your engagement. Thank you.
Thank you, Jean. David, you're next on the schedule, but if you aren't ready, Ross, if you want to go, you are ready, but
That's fine.
you can arm wrestle, whoever wants to do it.
Go ahead.
Thank you, Ross.
Yeah, absolutely. Absolutely. Good afternoon and thank you. My name is Ross Corthell. I am Vice President of Transportation for Packaging Corporation of America, also known as PCA. I also serve as Rail Committee Chairman for the board and a Board Director for the National Industrial Transportation League, as well as a Board Director for the National Freight Transportation Association. I have 26 years of experience in transportation and supply chain management. PCA is the third largest producer of container board in the United States and the third largest producer of uncoated free sheet in North America, all based on production capacity. PCA's white paper business operates under the trade name Boise Paper, a division of Packaging Corporation of America. PCA is headquartered in Lake Forest, Illinois, and has approximately 15,000 employees and operates primarily in the United States. PCA has 6 brown paper mills and 2 white paper mills, and all of our mills are served via rail. Rail transportation is utilized by PCA's brown paper mills to transport large paper rolls from the mills to the converting facilities, also known as box plants. PCA's white paper business utilizes rail transportation for shipment of palletized and rolled paper product from PCA mills to distribution centers. These shipments are moved primarily by rail. PCA also has 95 converting facilities, aka box plants, most of which are served by rail. In addition to paper mills and box plants, PCA operates a commercial trucking division with over 600 dry van trailers and a short line railroad with over 1,800 rail cars. In this context, I would say PCA understands very well the value of maximizing asset utilization within the supply chain. PCA thanks the Surface Transportation Board for holding this hearing and collecting data from the nation's railroads on their demurrage and accessorial charges. PCA has serious concerns about the changes the nation's Class 1 railroads have announced and or have implemented in their demurrage and related tariffs and the effect of those changes on our operations and cost. In its notice announcing this hearing, the board noted that railroads are required to establish reasonable rules and practices for demurrage and related charges. PCA agrees with the board that when analyzing the railroad's demurrage practices, it is appropriate to evaluate reciprocity and commercial fairness. The issue of reciprocity and fairness is particularly important in situations where railroads are asking for compensation when their own conduct often causes these delays and inefficiencies. By comparison, PCA would never be able to devise a pricing mechanism that charges our customers in the event one of our machines fails and we stock that customer out, only to flood them with product later. In the interest of time, I'm not going to go repeat my written testimony here today. I do draw the board's attention and encourage the board to review the data that PCA has provided on railroad local service variability as well as line haul transit variability. The data PCA provided in one example is a 2-month sample where Class 1 switching times ranged from 12:21 a.m. to 11:53 p.m. at the same site. In other words, the railroad showed up in a nearly 24-hour window without any specific communication. Needless to say, this significantly impacts PCA's ability to resource plan and therefore load and unload and turn assets efficiently. In short, precision scheduled railroading is not exactly precise at origin and destination. PCA has also provided data on rail transit variability and the significant impact on our efficiency. In just one of the many examples we provided, and one origin and destination pair had a mean transit of 15 days, but a standard deviation of 4 days. As we all learned in our statistics classes, the mean plus or minus 2 standard deviations allows us to predict an outcome with 95% confidence. In other words, in this example, we would predict transit at 95% confidence in this real world to be between 7 days and 23 days. Needless to say, this variation makes it nearly impossible to optimally plan resources to load and unload. Rather, we must react to what the railroads give us. One of the consequences of the erratic transit is the bunching of cars in transit, as has been mentioned before. PCA has provided data on one origin-destination pair and demonstrated this factually. Referencing the data we supplied, on a single line haul, we shipped 68 cars over 26 ship days, and the railroad constructively placed 63 cars over 11 CP dates. In other words, we shipped 2.6 cars per ship day, and the railroad CP'd 5.7 cars per receipt day in that particular example. Now, we've provided months worth of data so that this is not, you can see this is not an anomaly. Our data shows the pattern repeats itself over many months and many origin destination pairings, and is particularly potent in interchange service, as has been noted in previous testimony. Needless to say, this bunching significantly impacts our ability to efficiently unload and avoid substantial demurrage. None of the Class 1s today, in our opinion, do a good job of accounting for bunching in their demurrage invoices. And this burden is placed squarely on the shoulders of receivers who must use their own data to dispute erroneous invoices. This is especially true in lanes involving multiple railroads interchanging traffic to each other. In our written testimony, PCA did not call out individual Class 1 railroads, as we currently do not see substantial differences between them in how they manage demurrage. Even where tariffs reference service credits, it has been PCA's experience that their systems don't adequately capture these service issues, resulting in erroneous demurrage invoicing that we must then dispute through a long and broken process. In closing, PCA believes the board should take action to ensure the railroad demurrage practices are commercially fair and reasonable, and we support the recommendations made by the National Industrial Transportation League and the American Forest and Paper Association as outlined in our written testimony. Thank you again for your time and the seriousness in which you have demonstrated reviewing these issues. And that was the conclusion of my comments, but if I could, since the light is still green, I'd like to provide some clarity from the first panel around constructive placement and zero time. So if you could think about day 0 being constructive placement, then the demurrage clock starts at 12:01 a.m. on day 1. So day 0 is when a car is constructively placed and the customer is notified that the car is available. Day 1 begins at 12:01 a.m. the following day. That is the extent of the free time. If the customer does not unload that car by day 1 and release it as an empty, then that becomes a chargeable event. And I will tell you that there's, as I mentioned, in these 24-hour windows that they switch you, that could come before or after a cutoff time for your service to be requested for the following day. So you may incur what they would say is precise service. You did get your switch that day, but it was after the cutoff, which precluded your ability to release those cars for the following day and avoid the demurrage. So I hope that helps you understand and provide some clarity around what is zero, what is the impact of zero quote-unquote free or credit days. Thank you very much.
Thank you. David?
Good afternoon. My name is David Burchett, and I'm here today to give testimony on behalf of Miller Coors. I'm responsible for the procurement of over $700 million in transportation services covering multiple modes of transportation, including rail. First, I'd like to thank the board for hearing my testimony today. I think that you will see from what I present that at least one of the railroads' blatant disregard for the regulations that have been put in place to prevent unfair and anti-competitive practices is having a material impact on Miller Coors. And we as a company respectfully ask that the board address these actions. I'd like to take a minute to tell you a little bit about Miller Coors and how we utilize rail transportation. Miller Coors is the second largest beer brewer in the United States, with beer brands that include Coors Light, Miller Lite, Coors Banquet, Blue Moon, and many more. Miller Coors operates 7 major breweries and multiple warehouse operations across the U.S. that utilize rail services, and we utilize both rail-owned and leased cars. How beer is different is how we get it out to our consumer. In the United States, beer is sold through a 3-tier system. Brewers like Miller Coors sell their products to independent distributors, who in turn sell the products to retailers, who in turn sell the products to consumers. This 3-tier system is mandated by state and federal law. And importantly, Miller Coors distributors have exclusive territories, and therefore Miller Coors is completely dependent on one distributor to distribute products in that territory. So to put that in context, if you go to your local Walmart to pick up your favorite detergent, if it's not there, you can probably go down the street to a Target and find it. If our product does not get to that specific distributor, you're not going to find it in Walmart, in Target, in any grocery store, in any convenience store in that region. That's important for some of my testimony later. Rail transportation is an integral part of Miller Coors' logistics plan, which it relies on to move items to destinations all across the country. Shipping by rail is ideal for Miller Coors on both inbound and outbound where possible because of the characteristics of the product we're shipping. Inbound bulk agricultural products to our breweries that are used in the brewing process, and heavy finished beverage products out to our distributors. Because of the heavy finished product that we ship and the current weight restrictions for interstate trucking, the ability to utilize rail as much as possible for the shipping of our finished product to our distributors is both environmentally friendly and safer by taking thousands of truckloads off of already congested interstate system. Miller Coors is captive to single rail carriers at all but one of our breweries and at numerous origins and destinations. As a result, we do not have any bargaining leverage with the serving rail carrier in these situations regarding rates and service. You've heard today and will continue to hear about the unfair changes that the railroads have made to their demurrage rules. Miller Coors agrees that these changes by the railroads are not warranted to improve productivity, but that they are purely a way to increase revenues. I've heard a number of times that if I don't like how the railroads operate, I can move to their competition, trucking companies. In my opinion, I don't really consider them competition. They have very different cost factors. These are completely different modes of transportation, so they're not true competition. Truckload carriers also have accessorial charges similar to the railroads when drivers are delayed or when equipment is held for too long. But without those charges, trucking companies would not be profitable at all. Most trucking companies have operating ratios above 90%, while the railroads are bragging to Wall Street that they are having record profits every quarter, with operating ratios in the low 60s and pushing to get them below 60%. Also, when truckload carriers are late for their deliveries, most of the accessorial charges regarding detention of drivers or equipment do not apply. Railroads consistently do not meet agreed upon transit times on shipments at no fault of the shipper, leading to bunching of cars at destinations. But instead of disqualifying charges for these shipments, this actually works in the railroad's favor because they can charge more demurrage when consignees cannot unload the carriers in time, or the cars in time. Again, demurrage charges have not been made because shippers are taking advantage of the railroads, but as a way to increase margins and lower operating ratios. As far as our private cars go, we've actually had to hire a company to track our empty cars because they get held by the railroads, and that company then calls the railroads to tell them to get moving. We don't get any compensation back from the railroads for those. Because of the demurrage dispute in early 2018, NS imposed an embargo at its New York suffering yard and refused to deliver Miller Coors products to our distributor, Manhattan Beer Distributors. As stated earlier, Manhattan is Miller Coors' sole and exclusive route to market to service the critical New York City market. As you would expect, the greater New York City market is one of the most important sales regions for Miller Coors. As we understood the situation, NS was in a dispute with Manhattan over demurrage. As a result, it imposed an embargo on and was not delivering Miller cars to Manhattan. Miller Coors, not Manhattan, was NS's customer in this situation. We advised NS that the cars they were holding hostage contained perishable product. Miller Coors also advised NS that these cars had left its brewery before the rail carrier imposed its embargo on Manhattan. Miller Coors was given no warning of the embargo and was only told about the situation when its rail cars of beer arrived at the suffering yard outside of New York City. Miller Coors also explained to NS that Manhattan was the only beer distributor it could use for distribution purposes in New York City. The bottom line was NS had no dispute with Miller Coors, and there was no rational reason for NS not to deliver the cars. But even after being advised of these unacceptable and financially damaging circumstances, NS employees refused to move these rail cars to Manhattan. Miller Coors escalated the situation to a higher level executive at NS who reasonably had the first set of cars delivered to Manhattan. However, NS refused to move the second set of cars filled with beer to Manhattan. Miller Coors begged NS to move the set of cars to no avail. As a result, some of the product went out of date and some of it had to be transloaded to truck at a very expensive rate to get the beer to Manhattan. The cost to transload and switch some of these loads to truck was in the hundreds of thousands of dollars, but the impact to Miller Coors was much greater, easily in the millions of dollars. We make our product based on orders from our distributors, a product that takes roughly 21 days to brew and package. One of those breweries is 1,800 miles away from New York City, so you have the transit time that goes along with that as well. And when a disruption of our supply chain like this happens, it sets off a domino effect of moving product around to satisfy orders until the new product can be produced. Miller Coors was astounded by its treatment by NS. In an even more brazen response, at the beginning of 2019, NS increased its rates with Miller Coors to the New York destinations by an average of 21%, in what Miller Coors believes was retaliation for the demurrage issues between NS and Manhattan Beer. In another example of a railroad extinguishing any semblance of competition in its business, Miller Coors decided to get competing rates from two railroads at the one brewery that Miller Coors has that is dual served. Miller Coors informed a railroad that they would be losing a significant inbound lane to that brewery based on their pricing. The representative asked where they needed to be on the rate to keep the business. In a partnership effort to give the incumbent carrier the opportunity to keep the business, Miller Coors gave them the rate that they would need to be at to keep the business. Instead of changing the rate or responding to Miller Coors that they could not meet the rate, the railroad responded that if Miller Coors moved the business to the other railroad, that they would increase rates to a captive brewery in an effort to prevent competition. Based upon this response, Miller Coors was forced to keep the business with NS because of the rate captive lane impact. Railroad negotiations have become more one-way in recent years because of the trucking rate data that's available for purchase. With that data, the railroads are able to price just under what the equivalent truckload cost would be, and their negotiation response is, if that's too much, you can move it by truck. Many shippers choose to do that because of the value of shorter transit times and less damage to their product. In closing, I'd like to give you a quote from James Squires, the Norfolk Southern Chairman, President, and CEO at their most recent earnings report. We set company records for many financial measures in the first quarter. Well, one of those was their demurrage revenues. These demurrage changes are not being implemented because operations are being impacted by shippers and receivers. They are a revenue stream, and when you challenge them, as one of our customers did, your freight is embargoed. I feel the issues are deeper than just demurrage as well with the pricing practices that the railroads have instituted. Miller Coors appreciates the rate review announcement that just came out, and we ask that the board continue to look at both unreasonable pricing practices as well as demurrage as we go forward with this testimony. Thank you for your time and attention today.
Thank you. And finally, Herman, and I know that you have your board of directors with you. I'm sorry that because we're running a little late, one of your folks had to leave who represents Pepsi, but we certainly know they were here.
Thank you very much for the opportunity to be here today, and thank you for that opening. We've had meetings in the past, and it's been very important to the board that we bring out shippers so that they can hear real situations. For the sake of time, we're not going to have all of our shippers speak here today, but we want to take a minute of the board's time to introduce the folks that were here. First of all, the chairman of the board, which is, by the way, the Private Railcar Food and Beverage Shippers Association, which we call PERFBA. The chairman of that board is Patrice Laguerre. He is with Bondwell. Thank you. Rob McCrae, the Pepsi guy, is the vice chairman, unfortunately had to leave. Mark Swenson, board member. I believe Mark's here. Yep, Mark Swenson, board member. His real job is with Kraft Heinz. Barb Cattaneo, real job is MHW Group, secretary of the board for PERFBA. Rick Rentner on the board, his real job is McCain. Thanks, Rick. And Mike Bodie is here today to represent the McDonald's restaurant system. He's a distributor for McDonald's restaurants and a member. Dave Burchett, who just spoke, is also a member of PERFBA. And finally, Marvin Weiner, Real Job MHW Group, and also PERFBA. So as a group, we're not going to take all the time today to obviously speak, and I almost feel like we don't need to speak because it sounds like it's been a replay today over and over again. So I apologize. You guys are having lunch in your chair to hear the same thing time and time again, but if you don't mind, I'm going to go ahead and read our testimony anyway, and this is from us as a group. So first of all, thanks, and also I want to take a couple of moments to say thank you very much for that rate reform release of the task force report recently. We strongly support your work in that area, as do we continue to appreciate your assistance in the demurrage and detention issues. Before I move on to the detailed testimony, I want to clarify that we believe that the railroads in North America represent the most important transportation infrastructure this country has. Every week, the railroads move the equivalent of about 2 million truckloads of freight. That's 2 million trucks that aren't on our highways, they're not on our bridges, they're not on the infrastructure that's already worn out. Rail is better for the environment, it's 4 times more fuel efficient, and it's more effective from a labor perspective. We at PERFBA want the railroads to be open for business. We want the railroads to grow capacity, and we want them to accept more freight at rates, including accessorials, that customers and shippers can afford. We at PERFBA want the railroads to understand that we have a social accountability mindset at PERFBA. We want to choose the right sustainable form of transportation, not only for our business needs, but also for the environment. The railroads were created with federal funding to open this country to commerce over 150 years ago, but that role seems to have changed. Since the 1950s, railroad tonnage hauled has remained relatively flat, while the trucking industry has more than quadrupled the amount of tonnage that they haul to market. Today, Wall Street and the railroads decide what freight moves by rail. The decision process made by the railroads and their investors is pushing freight to other modes, mostly truckloads. The railroads are always very open about saying we have a choice, as Mr. Burchett pointed out, but the choice they push us to, primarily truck, puts all this excessive wear and tear on infrastructure, an environment that's already critical. So let's talk about infrastructure for a minute. How can we pass an infrastructure bill in this country without including some kind of accountability, incentive, directive to the rails to help out? By help out, I mean increase the tonnage to take more increase the tonnage they move to take more trucks off the road. How can we justify asking taxpayers to pay more for a gallon of fuel at the pumps for repairing the worn out roads and bridges, while the railroads, for the sake of increasing profits, push more freight to truck? Trucks that have a much greater impact on the infrastructure wear and tear than the person driving the car that's being asked to pay the extra tax at the pump. We need the STB to help bring our nation's railroad back to serving commerce across this country, not lining the pockets of investors. PERFBA would like to bring to your attention today the impact of the accessorial charge that's, I'll say, hits home mostly for them, which is everybody in our organization owns private railcar assets. The charges we specifically want to talk about today are private car detention, private car storage, private empty car storage, or whatever other railroad term can be applied. To clarify, privately owned or leased rail cars that are not spotted immediately upon arrival to a shipper or receiver's tracks for loading or unloading can be assessed a daily charge, as we've heard many times today. Even though these are private assets which have absolutely no cost basis to the handling railroad other than the tiny bit of track they take up. All of the U.S. Class I railroads have tariff provisions that provide storage charges, and those storage charges, at least in our industry, range anywhere from $60 to $150 a day. Some have 0 credit days. The most generous railroad gives us 1. Again, I stress, these are charges on assets that are not owned or have a cost basis with a handling railroad. The railroads believe that they have the right to charge for storage of these assets when those assets are on their tracks. They claim it is done to keep the railroads fluid. However, shippers strongly believe that these fees, which are inconsistently assessed on private cars, are solely used by the railroads to earn revenue, but I believe also gain leverage. Without a shipper's investment in these private rail cars, this freight in most cases would not move by rail. It seems counterintuitive to me to penalize shippers that bring valuable assets, in turn bringing significant revenues to the railroad. PERFA agrees that there should be some reasonable arrangement between the railroads and the shippers or receivers for the use of railroad track and to keep the shippers focused on moving cars. Under normal circumstances in a normal industry, two reasonable business partners would get together and work that out to make transportation accommodations for whatever delivery works best for either party. Unfortunately, in the rail world, private rail cars begin to accrue charges as soon as they're available for delivery to a receiving warehouse, regardless of the receiving warehouse's hours of operation. That you've heard several times again today, it's if the railroad wants 7 days a week, of course we should work 7 days a week. I wonder if they've shared that message with Chick-fil-A. Anyway, they have no interest in their ordering patterns, their infrastructure, or any other important factors that might be at the shipper or the receiver. Most receiving warehouses are limited in track space. As we've heard again today, most of them have limited hours of operation. Typically, a transportation provider would take that into consideration. In the railroad world, the railroad alone decides when it will spot cars, when it will make cars available for placement, how many cars it will place at any given time, and finally, they get to decide if they'll charge us for the cars they leave behind in their rail yard. The issue has been significantly impacted by precision scheduled railroading. In an attempt for the railroads to become more efficient, they are seeking longer, heavier trains. The net impact of this new service model is that rail cars get bunched in routes. And I've heard that term many times today, so I do want to help everybody here today. I was straightened out in the past few months by a senior railroad executive who says, we don't call it bunching anymore. Under PSR, this is now called train building. So we have to sort of change our mindset. It's train building. It sounds much better. It does. Undoubtedly, it is more efficient for the railroad to take more cars on fewer trains. But unfortunately, that impact of their efficiency is clearly the deficiency on the end users. All right, almost done. The hidden cost about PERFBA or for PERFBA and the end users in our case is not just these accessorial charges, but it is, and in many cases greater, the inefficient use of their assets. So in the food industry, we're using expensive, highly customized, refrigerated or insulated cars. These assets, while sitting idle, waiting for a slot to unload, while the car owners are having to continue to shoulder the daily cost of ownership for those assets. The railroads would have us believe that this is a shipper-receiver issue. It isn't. It's the changes to the railroading model that have created this issue today. The new rail process, supposedly to gain efficiency, has caused additional train building or bunching of cars. It's caused bottleneck at both shipping and receiving locations. PERFBA agrees and understands that the railroad should be efficient. We also want to be efficient, but we can't do that at the cost of our customers. What has become extremely apparent since PSR became the norm is railroad efficiency comes at a cost of their customer. That transfer of cost is shown clearly in today's Class 1 profit results. Suddenly, 60% operating ratios are the bottom of the barrel. In most industries, those kinds of margins are unachievable. The railroads continue to drive their efficiency for these profitability goals. Unfortunately, those efficiencies are being done at the cost of their customers. The same shippers who invested in railroad equipment to help the railroads handle more volume and earn more revenue are being penalized by subsequent revenue-producing policies of the railroad. PERFA respectfully asked the STB today to consider a few thoughts of solutions. First, that in the definition of reasonable, considering it's a private asset with no cost base to the railroad, we'd like to inquire as to whether the STB could completely strike down any demurrage or detention cost against private car assets. Also, we'd like the STB to consider the Class 1 railroads adopt mandatory performance-based pricing. This could be simply accomplished through a credit process where a railroad provides daily credits to private car owners when transit time exceeds published schedules. I know that question was asked earlier today. Most of the Class 1 railroads publish on their websites what the standard transit schedule is between their points. Simply taken, if they exceed that for any reason, car owners would get a credit applied to the rate on a load-by-load basis for the additional days in transit. Perhaps a simple, quick solution is maybe just to roll back tariffs to 2014, but on a broader scope, completely out of the box, and I have to throw this out today, and I apologize, but on a completely different path, with the sake of the infrastructure spending bill before everybody, I would like to suggest that we would recommend that the STB begin a scorecard. And that scorecard would collect data to show whether the railroad is actually increasing tonnage year over year or increasing the origin-destination pairs that it serves. If they do not, we should fine them. And the proceeds from those fines should go to fund the infrastructure bill. That's it. Thank you for listening. I appreciate your time, in hopes that we can all work together to implement FPR, fair precision railroading.
I'll kick things off, and we had, I think, over 2 hours of questioning to the railroads, and I think you all have identified specific concerns and specific practices. I just want to kind of take a step back and maybe just ask on a general basis, is there a carrier practice that is working well, that you all believe is fulfilling the intent of the statute and the intent of demurrage to improve network fluidity? Are there things that you can point the board towards, things that work well?
I would say there's certainly one aspect of the NS's testimony and their plan that makes sense to me from a precision scheduled railroading perspective. And that is the concept that they're trying to take the work out before they take the assets out. I think that is certainly the right way to approach precision scheduled railroading. It is not the way that predecessor companies had approached it. And so we're hopeful that that approach will alleviate some of the disasters that were created in previous implementations.
If I had just an experience that works well, it may not answer your exact question, but with our Oklahoma plants, we for 15 years have had both UP and BNSF as an originating Class 1 carrier. We can select one or the other, and then a short line delivers to us. And that system just has worked seamlessly, and the short line has, in 2 different short lines, both short lines will run across and do things for us that we can never get the Class 1s to do, and I mean a little extra service. As well as if we have a challenge with a bill, they still pick up the telephone. It's just an easier process. So that experience of ours is so much more fluid, and we have options.
I think if I can add one more. So this was a situation that happened within the last 60 days. So, and I hate to keep picking on the NS, but it is what it is. So this is an NS served location, 100% by private cars. They had not billed the customer any detention or demurrage charges over that 60 to 90 day period. They had not notified the customer of the change because the customer was actually the freight payer, who was the shipper. And the receiver, who was now going to be accountable for the bill, was not in their records because the receiver had gone through an ownership change. So for 60 to 90 days, they were sending the bills to a dead address. Thousands of dollars of detention demurrage bills were accruing because the receiver was having an issue during that ownership change receiving enough inventory. At the end of the day, the NS simply embargoed the destination, not doing the nasty stuff that they did to Miller Coors and actually hold cars for hostage. They just simply said, hey guys, we've been talking to you for a long time. You obviously have some issues, so we're not going to let your shipper ship any more cars to you until you clean up all the ones that are at the other end. They all agreed. That was a great idea. Thank you very much for putting us all together. A week after it was resolved, then they realized, oh, and by the way, there's a few thousands of dollars of detention bills that we forgot to give you because we were sending it to the wrong address. Here's your bills. The reality is they resolved the problem with their ability to embargo an origin or destination. The reason for all the charges, obviously, to some of the question points earlier, is it impacting the change? In this case, clearly it wasn't.
And can I pick up on something that we started to talk about? Oh, sorry, Brad, you were going to say?
Yeah, if I could just jump in.
Please.
There was a lot of dialogue, and it was most entertaining earlier regarding cause and effect from PSR, and things are speeding up, and look at us, aren't we great? If you look at the AAR data, the car loadings this year are down from a year ago. They're also down from historical averages because of a drop-off in coal shipments primarily, but a number of different commodities are down. They're on pace right now to just beat out 2016, which was the lowest that it's been, I think, since records were taken. So for them to say that it's PSR, baby, just look at us, relative to the fact that their volumes are down, I think is a little bit misguided. And so I think you got to look at a much bigger picture today than what they're painting as far as cause and effect because of the things that they're doing within PSR. There are fewer cars on the road today, which if I went out on your interstate around here, I'm going to get to the airport in a much faster way if there are fewer cars on the interstate than I would when things are packed.
Brad, you're referring to carload traffic.
Yep.
Are you factoring in intermodal traffic as well?
Intermodal's down as well.
But not in absolute terms.
Right.
Not from years past.
Not from years past. It's grown every year, and to the point where there are more intermodal units going out, and that's a different subject for a different day.
Right.
On the amount of time and effort intermodal takes relative to
Right.
carload traffic,
Right.
but we can argue that one at a different day.
So and then something that is a common theme, I think, in panel one and today, or in this panel, is bunching. And, Terry had said during panel one that, the variability in transit time means that you could do 5, 5, and 5 and get 15 back. And you might only have room for 10, for example. So talk us through how a reasonable program would work with respect to bunching. How, in that example that I gave where 15 come back, you have room for 10. Is it that a reasonable thing is that each of those 5 get credits for a day or what have you? Kind of describe how you would address the bunching issue.
Well, from my perspective, you not only have to consider the 5 cars that you couldn't unload optimally, but you have to consider what's in the pipeline to that facility as well. Because if those delays have a rippling effect, and somebody even used that word rippling effect, and we use that frequently in our conversations as well. But the ripple effect on your supply chain is if you're 5, 5, 5, 5, that it's not only the missed switch or the bunching that delivered 15, and now you can still only unload 5 or 10, but the ripple effect of all of those cars that then arrive into that site prior to you being able to optimize your unloading are now subject to demurrage as well. So optimally what would happen is the systems themselves would review that entire situation, and there's algorithms that can be written to do this. This isn't rocket science, but the systems themselves should analyze that situation and apply what the railroads say they apply today, which is automatic credits, and issue any kind of demurrage bill or not accurately the first time. And today the process is that they issue a demurrage bill, and then we use our own data to dispute that demurrage bill. So can you imagine a time when the electric utility would send you a bill on a monthly basis, and each individual user of electricity would have to prove how much electricity they used?
Well, I think you're Gene.
I just want to throw one more simple solution. Everything needs to be simple, right? If it's not on time, there's snow bills. period. The trucking industry works that way. If you miss your delivery appointment, those guys don't get driver detention, they don't get a rescheduled appointment, there's no accessorial charges paid. Railroads like to compare themselves as competition to the trucking business when it works for them. Here's a really good example. If you're not on time, and plus or minus 24 hours, a bit ridiculous on time, but okay, if you're not on time, plus or minus 24 hours, there's no accessorial bills. Because the missing piece, most warehouses are made out of concrete. People look at gap reports. If they see that they're gonna miss deliveries, they go call emergency trucks, they do other stuff to get supply into that building. So now when the railroad car merrily shows up a couple of days late, no big deal, better get it unloaded, the railroad said. You say, hey pal, we had to put 50 trucks on the road because we didn't want to run New York out of beer, it's important. And so we filled the warehouse up with the trucks. Well, now that your car finally got here, all of a sudden I got to change the world and expand my warehouse to take the product in that I had to replace with another mode of transportation. Bottom line, no accessorial charges on a load that's not delivered on time, period. Gene?
Yeah, the subject of accessorial charges or demurrage are just added insult on top of a bunching injury. And so, you know, we get into what's the operational harm that's being done, and I think Herman described it perfectly. I mean, if we've had to launch emergency supplies to get around whatever delays are there, then that means by the time that load actually arrives, now we are in an upset condition as to we've got to unload that or potentially find some way to deal with that inventory in what might be a location that's maybe has 3 or 5 car spot. So it does create a lot of operational upset just when we start talking about the effects of bunching. Never mind all the accessorial aspects of one penalty or another.
Excuse me, a few points I'd like to, some isolated points, and then get to the overall subject. Gene, could you just define for us adverse loading? I'm not familiar with the term.
Well, at a number of the dual served locations back closer to the advent of PSR, we had cooperative equipment pooling that the carriers would engage in to basically overcome uneven supply. So in other words, if it was a CSX and NS served point, what would happen is so long as roughly in that same month, the use of NS equipment could be used for CSX moves and CSX moves equipment could be used for NS moves, so long as it balanced out at the end of the month. And that was done through boxcar pooling agreements.
So it only applies where you've got at least served at least by 2 carriers?
Generally, yes,
yeah, okay.
yes. And so, so when the PSR, initially with CSX, started kicking in, they began disengaging from these cooperative pooling arrangements. It is not exclusive to NS and CSX. I think a lot of it had to do with what they thought of in terms of their equipment philosophies and their reinvestment strategies. And so, so what that led to was an incredible rise of adverse charges, adverse loading charges, where I think in CSX it's $2,000 per car.
So how does that work?
This is $3,000.
What causes an adverse? So can you describe what's happening there to cause the charge?
Well, and I'll take you through an example, such as if we need 10 cars from NS and 15 cars from CSX, and it's CSX doesn't bring 15 cars, and we are in a desperate situation, we may find ourselves needing to use some of those NS cars on those CSX routes. And so if you waybill any of those on the adverse route, then you get that adverse charge.
You're gonna pay more, you mean, for using the NS cars on the CSX route?
Correct.
So that's what you're
NS is
referring.
$3,000, CSX is $2,000.
And you're saying this phenomenon has been exacerbated with PSR?
Absolutely.
All right. Ross, I want to get back to what I was actually asking Ben Abrams about this morning, but it sounds like you're describing, I want to get to the 0 time. what you were describing sounded to me like you were talking about what happens with system cars, not privately owned cars, in terms of unloading. Is that right?
That's correct.
So, just to get, because everybody's talking about zero time and they're using the same language. So, what Ben was describing is that if he gets a notice of a placement at some time during the day, in order to avoid a demurrage or storage charge, he just has to tell the railroad before 12:01 tonight, deliver the car to me. Then he's off the hook if he can do that. You're talking about, you get notice of a system car is placed at, say, 2:45 in the afternoon. Are you saying that with zero time, in order to avoid a demurrage charge, you not only have to have it delivered, but unloaded and released before 12:01 tonight?
No, sir. You do have to order it in by their cutoff. So, in your example, if you receive a constructive placement notice at 2:45 p.m. and your cutoff for the next day's work is after that, that A gives you the ability to call the car in to be unloaded on the next switch, which theoretically would be the following day. The demurrage clock itself would start at 12:01 a.m. the following day. And so as long as you get your service, you order the car on the cutoff, you get your service, and you receive the car and unload it on day one, in that example, then you're not subject to any additional demurrage charges.
So if you get the notice at 2:45 and you order the car in, that might not happen till tomorrow morning.
That is correct. In fact, our data shows that it could happen anywhere from 12:01 a.m. until 11:59 p.m. the following day.
And in order to avoid demurrage, you have to release it before 11:59 or 12:01 the day after that.
Well, it's even worse than that. You must release it before your service cutoff time.
And
so in our example, if your service cutoff time was at 3 p.m. and the car actually placed after that time the following day, you will have missed your window to release that car the following day in order for them to create a work order for what would be your second switch of the week, theoretically.
So are you telling me that under this zero time, it can happen, and really more importantly, does happen, that it is impossible to avoid the charge because you get the delivery the following day after your cutoff time? So even if you unloaded the car in 5 minutes, it's too late to release it. Is that what you're saying?
No, for clarity, I'm going to say that if everything happened precisely and according to schedule, and you were able to order those before the cutoff, and they delivered it the following day, and you were able to unload and release it that following day, you would avoid demurrage for that particular car. But if you recall, what I also said was that precision scheduled railroading has been anything but precise in that transaction.
That part I understand, but I thought you said you had to release it before the next day's cutoff.
You do have to release it before the next day's cutoff. That is correct.
But
so if the cutoff is at 3 p.m. and they have spotted the car, so for example, they spotted the car at 10 a.m. and you're able to unload it in that time between 10 a.m. and 3 p.m., you can release the car in time. If they spot it after 3 p.m., you have no chance.
That's what I mean. So it's possible under this system that the railroad delivers the car to you after its own cutoff, so that you cannot meet the deadline, even if you want. If your cutoff is at 3 and they deliver it at 3:30 and you unloaded it in 5 minutes, you're still stuck.
That is absolutely true.
Is that right? Does that happen?
Yes.
And under those circumstances, can you dispute the demurrage, or do they just charge you anyway?
You certainly can dispute it. I would say the dispute process that has been testified is relatively broken, and typically the frontline folks have very little authority. They may make a decision quickly, but the decision is very seldom in the receiver or shipper's favor.
And under those circumstances, Are you saying even the railroad in theory would agree that you don't have to pay, but you still have to go through the dispute process?
Yes.
So of all of the 5 of you sitting there, what's the frequency of this particular kind of, I mean, it's one thing to give you a short amount of time, but it's another thing to make it impossible to comply physically. So what's the frequency of these occurrences that Ross is describing?
We have them as well.
I mean, is it a lot? 2%, 50%? I mean, is it a lot, a little?
It's enough to bring most of us out here today to test it.
Well, Marty, I think getting at this is Gene, you said that you successfully disputed $2 million worth of charges.
Correct.
And based on what I saw your projections, under every scenario, that's over 20% of charges.
Yes, one was system-wide,
Yeah.
and the other figure was really related to two facilities.
Okay. And
But I will say that, just to finish up
Yes,
that
please.
thought, is we have locations that are not served, but 3 days a week. And so if they're getting switched 3 times a week, you know, when the demurrage clock starts, in theory, you're already at a catch-22 on when demurrage hits. Your free time is over long before your next switch comes. So it kind of counts on a couple of things. You need to ensure that you've released it before that next switch comes, but if you haven't done the system release, you could be exposed to charges there as well. So I mean, the point is the tariff changed so that your free time kicked in the day after the switch.
So that's what I was
Right.
going to ask. So under the Ross's scenario here, if you still had 24 hours free time, under all the same facts, you got your release time on the second day was 3 o'clock. The car didn't come in until 3:15. You actually have till the following day to release it.
Right.
So you still don't have much time to unload it, depending on the nature of the commodity. But this physical impossibility of missing the cutoff couldn't happen if you actually have the 24 hours, right?
Correct, but at one point, the clock started the day after the next scheduled switch. So
it really starts at 12:01 the next. If he gets a car, I just want to go back. I mean, it's sort of like a Rubik's Cube to me. I'm really trying to grasp this. If you get a car 2:45 on Wednesday, under the no free time, and your cutoff is at 3 o'clock the next day, and they don't deliver you order it, but they don't deliver it till 3:15, as we just said, you cannot avoid demurrage. If you still had 24 hours, you would have until 3 o'clock Friday. And so you've got the car at 3:15 Thursday, you have a chance of unloading it and releasing it before 3 o'clock Friday and avoiding a demurrage charge.
I'd say you have that.
Yeah, so I mean, because I'm trying to go back to this incentive concept that's in the law. You cannot be incentivized to roll time backwards, I'm pretty sure. Okay. Brad, did you want to add something?
Yeah, just a point of clarification. So let's go back to your 2:45. The car shows up, and your cutoff time for ordering is 3 p.m. Somehow, some way, you find out that the car has actually showed up. You call it in for the next day. If they fail to bring it to you, you should, in theory, get another credit day because they failed. Now, you've got to
Fail to bring it to you by when?
By the next, whenever your next service is and your next switch. So it could be, 6 a.m., could be, sometime in the afternoon of the following day, whenever your normal scheduled switch is. If they fail to bring it to you within that 24-hour window or on your next scheduled switch, you should get 1 credit day. Now, you got to monitor all this. You got to, keep score and have somebody that followed through to make sure that indeed the car showed up. And that's part of our challenge, right? Is somebody has to watch them like a hawk, because otherwise, boom, here comes the demurrage charge.
I had a question, Brad, that I'm glad you raised, and I had actually meant to ask Kenny Rocker about it. We slipped through my notes. I'm interested in this $3,200 each way on your unit trains for removing the locomotives. So UP delivers a unit train to your facility, drops it off, unhooks the locomotives, and leaves. Every time?
In most instances in our ethanol plants, that's the way it works.
All right. And they immediately charge you $3,200 for doing that?
For the first, on the outbound.
Yeah,
So
and then
when we call to load, say now, hey, come get the train, it's now loaded.
they charge you another $3,200.
That is correct.
And when did that start?
Just this spring.
And how did it work before? Did they just leave the locomotives there?
They either left the locomotives or pulled the locomotives, but didn't charge us for that service.
And what is the stated rationale for adding this charge?
I think they're giving us that this is a locomotive asset utilization charge of some nature because they've got to, pull this locomotive out versus having it sit around for 24 hours. And it's, for them, something about locomotive utilization is the rationale that they're giving us.
You may not know the answer, which is why I wanted to ask Kenny, but he can send us a letter if he's still here. Oh, there he is.
Yep.
So they pull the locomotive out, they take it someplace. Would it be fair to infer that they're using that locomotive to make money on some other haul?
I'm not a railroader, but I think it would be fair to infer that.
So they're getting paid for that and they're also charging you?
Yeah, I mean, you got to believe that the reason why they're pulling it is they've got some use for that locomotive in another part of their business.
Okay, is it okay for?
Yeah, we'll let him.
All right.
We'll let him answer.
Thank you, Kenny, because I was going to ask you to explain this system.
Yeah, we feel like we have a good relationship with Cargill, and
Well, you
I
do.
know,
Until now.
well, and I have confidence that we share more than it was just a locomotive utilization issue. We have our crews, and we have to get our crews. Sometimes they may be locally, sometimes we may have to pull them from somewhere else. So there is a justification there for us to get the crews to go pick up that locomotive. And then we do want to utilize that locomotive somewhere because we don't know when the customer or Cargill may want to use or need the locomotive again. And then we'll have to go back and then get more crews to bring the locomotive back. So yes, there is a justification there. I don't want to make it seem like it's just a locomotive utilization charge. There's a direct,
And it's accessorial, not demurrage?
yes, correct.
It's an accessorial
It's
charge,
accessorial, not demurrage.
but Kenny, what you just described to me is what a railroader does, right?
I mean,
You schedule crews, you schedule locomotives to come pick up our train. And then you take that train to the final destination and we pay you for that. It should be all part of the fee. Now you're tacking on one new fee on top of something that you should have built into your rates.
So,
Yeah,
that's sort of, I'm sorry, go
I
ahead.
just want to say this, and I really do appreciate that perspective. And I'll tell you, we do have customers, Brian, you know this, because you're one of them. We have customers that do unload and load in 15 hours, and quite a few that do it in less than 24 hours. And for those, they don't have any of those charges. But we also have some customers that will utilize our locomotives for a few days, maybe 3 or 4 days, and we could be utilizing that $3.5 million or $3.5 million asset somewhere else. But I want to make it clear that there really is a cost there to go out, get those crews, cost of those crews to go get that locomotive and then get the crews to get it back.
Well, to Brad's point about how it should be part of the rate, it kind of sounds to me like the person who's staying in a $500 a night hotel room and then they charge them $250 for a complimentary cup of coffee. But let me ask this question. Are you saying that you only apply the $3,200 if the unit train user can't turn the train back within 24 hours?
That's correct.
And how do you know that when you deliver the train? They tell you we won't be done in 24 hours?
That's correct.
If they tell you we will be, you leave the locomotives there?
That is correct.
So the only other question I have, and I'd asked this of other railroads about the whole advent of PSR. Why now? I mean, you've been in the railroad for, I don't know, close to 200 years, and
Maybe not.
in my view, everything I've always heard is UP is a well-run railroad. Nobody figured this out until 2 months ago? I mean, what prompts this kind of a fairly dramatic change?
Yeah, the impetus for us is we have to get our car trip plan compliance to be more reliable. As I've stated, it's the most reliable that it has been in the last 2 years because of these changes. So that's our impetus. We want to grow with our customers. We want to win with our customers, and we can do that if we have a more reliable railroad and we do what we say we're going to do.
Kenny, can you just add in the fact that I know that you're taking as many locomotives off the system as you can, so it's not that you don't have any that could stay with Brad's train, but just it's kind of hard to see the fuller picture that they need to stay in storage rather than with the train. I understand the crew aspect, don't get me wrong on that, but.
Yeah, I mean, it really boils down to the fact that we would rather have our assets, highly valued assets, more in use than just stored at a facility, whether it's on the origin or the destination end for several days.
Prior to this plan, did you have a limit of how long a unit train owner could keep the locomotives there without being charged? A different limit than 24 hours?
No, we didn't. We did differentiate the customers. There are some customers that can do it in less than 24 hours, and there are customers who would fall under a scenario that Brad is talking about where it's an unscheduled unit train network, and we're not sure how long it will take for them to load or unload. I will say this, on those customers where there are unscheduled work, where they don't know how long they're going to have the locomotives, I can tell you our commercial team has worked with them to provide a manifest alternative. So maybe this scenario isn't the best service product for the customer. And I'm not talking about Brad and Cargill here, but I want to make it clear that we have optionality here, and that optionality is that manifest network if you can't load and unload in the 24 hours.
But the manifest network costs a lot more than a unit train, right?
I don't want to disclose any, strategy here, but that is not a factual comment in every case. I can tell you that. I feel comfortable saying that. In every case, that is not the truth in every case, and I know every part of our rate structure, so that is not true in every case.
And are we talking about it when you say it's unscheduled? The reason for the inability to unload in 24 hours is because the shipper didn't know they were getting the train? What's unscheduled about it?
Each customer has a unique scenario. In some cases, the customer may not have the infrastructure at one end. They may have it at the origin end, but they may not have it at the destination end. So each scenario, each case is different.
So
What would happen to the
if I
crew
may,
when
just
they?
about this unscheduled, if I may. Partly, Marty, it's about how much we process on a given day. We've got a plant that kicks out 25 cars a day. Here comes a train of 100, or let's call it 100 cars. So it's a 4-day load, essentially. Now, we probably have cars that are already there that are being loaded that are waiting for the next train to come in of empties, and then it'll take us maybe 3 days. But our production rates are fairly constant. Now, they change a little bit over time, and we have peaks and valleys and things, but generally speaking, we're producing about the same. And we tell this to the railroad, whether it be UP or anybody else. They see what our production schedule is. We plan this out and give them the heads up. So to say that it's unscheduled, I think, is a little bit of a misnomer.
Well, so you're saying from Cargill's point of view, your need for the train and the locomotives is predictable.
That's correct.
Yeah.
And yet, but you're saying you can't schedule your locomotives to just leave them there, even though you know it's going to be predictable.
I'm saying that it is not as predictable always, and that there is also other options out there in terms of manifest option.
All right, well, I don't want to beat this any further, but that's very enlightening, because I couldn't for the life of me figure out what was going on here. This is very helpful.
And Kenny, thank you for rejoining.
Yeah, thank you.
And other railroads may need to rejoin us later on, too.
You get extra,
But,
we'll tell them you get extra credit and overtime pay.
Yeah. The day is getting away from us, but I don't want you to think of the lack of additional robust questioning by me means anything. I do want to quickly ask, though, can any of you comment on the congestion, I guess, I was going to say pricing, but I don't mean it that way, the new congestion fee and how that is or have you been charged yet based on the NS's judgment that you've caused the congestion? Anyone?
We have not, so I don't have
Okay.
a comment on that.
We haven't been charged, just embargoed.
Sorry.
Nor have we.
Nor have we.
NS, keep it up. Joking. Okay, you both have a few things.
Yeah,
Go ahead.
just cognizant of time as well. But there were, I think, various solutions set in this panel that were a little bit different than those in the first panel. So I just wanted to kind of hone in on those, make sure I fully understand. Brad, you had talked about kind of either a weighted cost of capital or kind of looking to barge rates, kind of as a competitive market and basically having a demurrage rate cap, if I understand correctly. Is there, would you agree that kind of demurrage includes a compensatory effect and an incentive effect?
Yeah, I think it's what's grown up on the barge side at least.
Right.
That the marketplace over time has moved towards stricter and stricter demurrage terms.
Right.
As the value and the demand for barges over time has gone up. So this
Right.
has shifted around in the last, I think this has been out there for about 5 years is my understanding, at least 5 years. And it's what the market itself has gravitated towards as being, reasonable and competitive, and that everybody's gone to this.
But is there something within the rail network, both in terms of kind of the cost of the infrastructure itself, and maybe something about time value for different transportation, for different commodities, that would lead you to believe that maybe for rail it ought to be higher than the barge rate for those reasons?
I mean, you could go and make that kind of a decision. Then you're going to have to say, okay, well, what is that? And the amazing thing to me, as I stated in my speech, is that those people that are willing to lease you space on their network are charging fractions of dollars relative to what the railroad is wanting to charge us.
So it kind of gets
so it kind of, if you look at that and say they've got assets, they've got maintenance,
Right.
things like that, and yet they're willing to charge us a much smaller fee that's supposedly competitive and is competitive in the marketplace.
And to kind of get into you mentioned the kind of the national average for storage, and I think some of that, is there something about the storage track that is less valuable than the track that's being used when something's put in constructive placement, for example, such that stored in constructive placement, such that you would expect a higher rate in the railroad storage versus that, and that might not be the best measure. Is there some truth to that?
I think that's a fair comment to say that a working yard that is utilized for interchanging traffic and things like that has more utility than, say, somebody else who just has a bunch of tracks that are collecting dust, so to speak, that are just available at any one point in time.
Right.
I think it's not. I think that's a fair comment.
And then Herman, you were talking about at private car, there should be no charge if it's a private car, basically. And do I understand that correctly? Now, if a private car is in constructive placement, are you separating the cost of using the capacity from a railroad compared to the cost of using the car? Or are you saying that when a private car is in constructive placement, there should be no charge whatsoever?
I'm challenging or suggesting that a very easy solution would be that there should be no cost of demurrage, detention, or storage on a private car, because
Yeah.
It's as much likely that the railroad held up your car and they cost you because those extra days transit versus the few times that you're going to cost them for taking up a little bit of their track space. So rather than doing all that tracking and tracing and arguing and auditing, maybe you could just have a no charge for private cars. Just a thought.
Do you think that that would create a disincentive at all for private car owners not to?
Absolutely not.
You
The
don't
cost
think so?
of a refrigerated car per day loaded costs the lessee about $150 a day. Quite frankly, even though that I guess it's the NS is the lowest charge at $80 a day or $60 a day for a private car. I mean, their own cost of ownership on a loaded refrigerated car is 3 times that of their charge. So, no, I think the motivation to the private car owner is to move his darn assets. He doesn't need the railroad throwing tariffs at him.
But for example, there are some private car owners that actually choose to purchase car storage because maybe they don't store it on in their plants, or they just need storage capacity, right? And if there was no charge for a private car owner from using a railroad asset in CP, why would anyone pay for car storage when they could just leave it in a railroad yard for free?
So the railroad could come back and suggest that they're using tracks as storage that they shouldn't be, and if they continue to do it, they'll embargo them.
I'd like to sort of pose a broad question, but only if somebody can deal with it briefly, because we're going to run out of time. But I'm sitting up here listening to the railroads come in and put all these numbers up on the screen about how everything is moving fast or faster. And then I'm listening to the 6 of you tell us how it's going in the opposite direction. Can somebody put these two concepts together? Because the numbers are the numbers, but you're not feeling it or you're not seeing it. I mean, Matt, you said PSR has caused, since PSR you've been suffering more delays. Gene, you've kind of suggested the same thing. So I don't get it. Can somebody, what's wrong with this picture?
All right, so let me take a shot at this. The velocity numbers, generally speaking, have improved, certainly over the last couple of years, if you just look at it. And we would say, looking at our numbers, because we look at origin dwell, loaded move, destination dwell, empty move back. So if you just take when the car's in the possession of the railroads, it's fairly consistent, but it's generally been improving. Where we run into trouble, and whether you're the CSX, the NS, UP, BNSF, any of the class ones, it's the first mile, last mile is where they're struggling. So if you hear angst from this group, and I don't mean to speak for everybody, but I know personally, and as Cargill, where we feel it the most and where we're not seeing the real benefit of PSR, and we're struggling to really recognize this, it's on the origin piece where the cars are being spotted to us, and the destination piece if you're a customer or if you're Cargill, because we receive cars as well. That's what's inconsistent.
Is that where the, well, go ahead, Matt.
I'm just going to say just quickly, our challenge is on the last mile. That's where our delay is, and it'll sit outside our gate for multiple days, and that's where our delay is. And if we're charged a demurrage charge, it's because it's sitting outside our gate, not because, and we do all private cars. So this conversation, there's 2 different 24-hour issues going on. One's, right.
But I'm sorry, Gene, go ahead.
It's just that averages will kill you, right? So they're sharing numbers in high averages across a very complex system. And frankly, we have a pretty complicated system as well of facilities. So when we look at just high averages, it's really not going to tell you enough. The significant pain points, there are chronic areas that are still going to, kind of detail far better what's actually happening there. And then there's always the whack-a-mole picture. You fix one, the problem pops up somewhere else. And so, it doesn't reduce the pain level. It just has you constantly chasing it.
So, first mile and last mile, are you talking about situations where the class 1 is actually delivering the cars and picking them up to your facility as distinguished from a short line?
Yes, I am.
Yeah, because you had talked about how the short line. So you're saying that the PSR has caught, if I get this right, the PSR programs seem to have improved performance on the hauls, the long hauls from origin to destination until you actually get there. And then doing the switching and moving the cars in and out of your actual facilities is somehow worsened by PSR. Because of the rigid scheduling, is that the reason? Or rigidity in scheduling?
Some rigidity, but I think it's also they've whacked bodies. They've reduced crews, and so you've got, God bless the crews that are out there because they're being charged with serving more customers than what they would normally serve, and they just run out of hours. They start off every day and they want to get to every customer, but sometimes things slow down, and then all of a sudden they run out of hours, and then they don't get to serve those that are at the end of the line.
Right. So we should be asking these railroads when they come, the next group that comes up here, what their data is on the first mile and last mile, and not the big picture items. Is that?
That'd be great.
Trying to get at the bottom of this. Okay. Thank you.
Wonderful. In our written testimony, we provided data on that topic. It's a small sample, but it is a 30-day sample. And in that case, there were 21 switchable events, and they missed 5 of them.
The last time I looked at statistics was in 1964, and so I glazed over when I looked at your tables. But I'll look again, thanks.
I'd be happy to spend any amount of time on the phone with you.
I will need it, thank you.
Any further comments?
I would just say thank you again for the seriousness and the great questions. It's really clear to us that you're trying to understand this issue, and it's important for us that you do that. So thank you very much.
Thank you. Thank all of you. It was very helpful.
Thank you.
Our next panel is panel 5. Thank you. Thank you for the very short break so we could stand up for a second. We'll now have panel 5.
Good afternoon, Chairman Begeman, Vice Chairman Fuchs, and Board Member Overman. I'd like to thank the Surface and Transportation Board for holding the hearing and investigating the unreasonable railroad demurrage and accessorial charges practices. My name is Michael Bodie, and I appear before you today in conjunction with PERFBA and as the Chief Operating Officer of the Anderson DeBose Company, a small business that utilizes inbound rail service. The Anderson DeBose Company is a private minority-owned food service company that provides logistics and distribution service to McDonald's, covering Ohio, Pennsylvania, New York, and West Virginia. In April 2012, we decided to consolidate 2 older centers located in Solon, Ohio, and Carnegie, Pennsylvania, into one state-of-the-art center in Lordstown, Ohio. This investment was made to realize long-term financial savings from a more efficient distribution center and logistics benefits from a more strategic geographical location. A key factor in our business case to build the new $22 million center in Lordstown was the ability to utilize and leverage inbound rail service to receive several of our core refrigerated products. Our studies and business case identified that we could fund this facility, pass on the efficiencies and savings gains to our restaurants we serve, which are primarily owned by other small business owners. Locating the center in Lordstown, Ohio also provided new well-paid jobs to a struggling local economy. As a small business, we do not own our own rail cars. We utilize refrigerated rail cars that are owned by BNSF Railway, and we receive rail service from CSX at our Lordstown facility. The reference to demurrage rules and guidelines in my testimony apply to those imposed by CSX. When our facility was built in 2012, it was built to support our current projected future needs. The sales of the products we received were projected to remain fairly consistent, and we were projected to order 1 or 2 refrigerated cars each day. Our facility was designed with 2 inbound rail doors, and in order to accommodate these projections, and over the past 7 years, these sales and ordering trends have remained consistent. While we should receive a regular flow of 1 or 2 rail cars per day based on our ordering and shipping, on a regular basis, we have our rail cars held at CSX rail yards, awaiting future cars destined for us. This practice of bunching cars causes operational challenges and inefficiencies for us. This CSX rail car bunching has increased over the past several years with the onset of the precision scheduled railroading. This attempt by railroads to become more efficient has severely impacted our operational costs. Since PSR was initiated, we are now consistently having days with 0 rail cars arriving and then receiving a bunch of 4 or more rail cars at one time. The CSX initiated bunching causes operational issues which impact our workforce, increase our operational costs through employee overtime, additional equipment needs, diminished warehouse productivity, and the use of truckloads to supplement our needs. Although we have always incurred some level of bunching and added operational costs in the first few years after opening the facility, we were able to control our CSX demurrage charges using unload credit days provided by CSX. When we began rail service in April of 2012, we negotiated a CSX local demurrage tariff which provided for 3 days of credit. The 3 days of credit were beneficial and allowed us to accumulate credit days when we unloaded and returned cars early. These credit days were utilized to offset the additional dwell days that we accumulated when we received bunch cars from CSX. This local 3-day credit was eliminated by CSX in 2017, and we are then subject to demurrage tariff terms outlined in the National CSX 8100 publication, which only provided 1 day of credit. With only 1 day of credit, the ability to accrue credit days was essentially eliminated, exposing us to additional demurrage charges caused by CSX bunching. In addition to the elimination of credit days, CSX has also adjusted the demurrage tariff several times since 2017, increasing the per-day demurrage charge. With the CSX demurrage tariff change that was placed in effect on January 1st, 2018, we are now charged $250 per day for cars that are not processed within 1 day. This is a 67% increase from the $150 per day that was in place prior to January 1st, 2017. With the increases in the daily demurrage tariff rate and the loss of credit days previously provided, we have seen our CSX demurrage charges increase by 165% since 2016. This exponential increase has resulted in over $400,000 of additional demurrage expense each year, which has severely impacted our business plan and eliminated our ability to pass along the planned efficiencies gained to our customers. If PSR practices and the current demurrage tariff policies continue, we and other small businesses that utilize rail service may be forced to abandon rail and return to truckload options. With the current and future trucking industry gap in CDL drivers and the added environmental impact of additional truckloads, we find this option less appealing. We believe that rail service can be a viable option for small businesses like us by eliminating these unreasonable practices and by stopping PSR, practice of bunching, increasing the credit days for unloading to 5 days, and rolling back the demurrage tariff rates. We at the Anderson DeBose Company respectfully ask you for your review of the current unreasonable practices and charges that are impacting the industry. These practices and the imposed demurrage and accessorial charges have been particularly impactful on small businesses such as us and the customers we serve. Thank you for allowing me the opportunity to share our concerns and be part of this important hearing.
Thank you. Ray?
Thank you. First, I'd like to thank the board for taking the time to review these charges and listen to the testimonies. It's well known that the Class 1 railroads in North America today are going to the precision-based railroading. This has 3 components to it: shipping consistent, shipping on time, and shipping with fewer assets or better utilization. The railroads and their networks in North America should be viewed as economic assets to North America. Loas North America supports the efforts of the railroads, as they would any business that continues looking for ways to improve efficiency and effectiveness. Shipping in single car shipments should be the most economical way to ship shipments throughout North America. However, these new changes have not been reciprocal to both parties. They're difficult to manage and dispute, and are showing signs of pushing freight off of the railroads onto trucks or highways and interstates. One of the key principles of precision-based railroading is running freight consistently and on time. In my experience as a logistic manager, the first implementation of scheduled railroading can be very difficult to achieve. The precision scheduled railroading concept, when successful, allows logistics managers to better plan the supply of raw materials and finished goods to the customer base. It is widely known that just-in-time inventory is an active principle in the production world, and the transit times in these shipments are very impactful. A way to overcome a shipment that does not make it on time is to bring truck in and supplement the inventory. This situation can be expensive because it's short-term notice, and the spot market on trucks is usually double what it typically is. It also has bad effects financially, and that is the accessorial charges will follow. So once you've filled up your bins and you've filled up the need for the inventory, the rail car will arrive. At that time, has been testified from others, sometimes you don't have room for that rail car anymore. So you have to just basically suffer the demurrage charges. When this does occur, it's very difficult to fight those charges. The tariffs do not protect the shipper or the receiver at that point, and you're just charged the charge. You've also lost the utilization of your private cars if you have private cars. Another key principle in precision-based railroading is limiting railroad-owned assets or increasing utilization. This one to me kind of hits home. It's something that as a shipper I can partner with the railroads and have skin in the game. So bringing on owned assets or leased cars is something that I feel very strongly about. And in doing that, you've got to make sure that you know what your ratios are, what your transit times are to size your fleet correctly. The railroads do not want these extra cars sitting around in their yards because it does cause congestion, and it also causes operational impacts to them as well. So knowing what those schedules are and being able to right-size your fleet is very, very important. If they don't adhere to that, they don't use the precision railroading or aren't able to meet the schedules, there are no provisions in the current tariffs that allow us as private car owners any type of repercussion on the railroad or cost justification. In addition to the lack of provisions of the tariff in protecting the shipper, these charges are administratively challenging. These charges start after a day, as has been discussed. The shipment history doesn't seem to matter if the car was bunched or wasn't picked up on time. That's not figured into the demurrage. It's just the demurrage bill is just simply cut and sent to you. The charges really impact the freight portfolio and make it very difficult to sometimes be effective and efficient. These updates are not always operationally accurate. It makes it difficult or possible to understand how many cars will receive daily. That's the, excuse me, just one second there. When I'm speaking about that, I'm talking about the notifications. So we get notifications from the railroads on our shipments. It'll let you know if the ETA of that shipment is on time, if it's going to be delayed, or if the shipment's actually going to arrive early. Many times with that, especially with cars coming back, there's nothing that I can do to impact that. If they send me an email that says that the car isn't going to make it on time or it's going to be early, I can't make changes within my operational logistics plan at that point to accommodate that. And the last topic really is pushing shipments off of our rail lines onto our railroads. Since 2019, I've seen a dramatic increase in this type of behavior. It's rapidly increasing, and it's based off of the logistics charges or accessorial charges that the shipping and receiving folks are accruing. So what they're doing is they're moving to the truck base. In my experience, the trucking industry is struggling as well with drivers and as well as our infrastructure. My fear is that our 16-mile industry spur in Tennessee will suffer the same fate as our facilities in Florida and Texas have seen, and that is Lost North America will eventually be forced to abandon the rail. In time, the tracks will become too deteriorated to use and the capital to be too great to reinvest. It is crucial to our market to have efficient and cost-effective transportation. Rail shipments have the potential to be the most cost-effective method to transport material, like ours. These changes are accelerating the demise of rail shipments at an alarming rate. And once those shipments are gone, they are gone in my experience. The shipping base will just stay with the truck base then. I'd like to thank you for your time today. I appreciate your concern and willingness to listen to all of the testimony.
I'm sorry, hit the wrong button. Mr. Weiner, thank you.
Good afternoon. It's been a long morning and afternoon. I appear before you today wearing a couple of hats. That of the president of North America's largest privately held lessor of 2,200 insulated mechanically refrigerated rail cars. I'm also the owner of two 375,000 square foot refrigerated warehouses, one in Perryville, Maryland, the second in Chambersburg, each served by the CSX Railroad. My associate Herman Hackstein has spoken to you earlier from a rail lessor perspective and as president of the Private Railcar and Food and Beverage Association. My appearance here today is not without a great deal of concern. Allow me to explain. In October of 2017, my CEO, Mr. Hackstein, spoke before this same board at a hearing that included testimony from the now departed Hunter Harrison, then chairman of the CSX, the same railroad that serviced my two warehouses. 6 months later, in March 2018, demurrage and detention credit days were reduced from 3 days to 1 day. Railcar placement times became erratic, service days were changed, and car placement refunds were eliminated. I would hope that further retribution by the CSX against my facilities would not be the result of my participation today at this hearing. Public Law 96-448, enacted on October 14, 1980, the law that created the Surface Transportation Board as one of its stated goals, and I quote, to provide a regulatory process that balances the needs of carriers, shippers, and the public, end of quote. There's nothing fair from the railroads. There's no balance of the needs of the rail community. There's nothing reasonable emanating from the railroad to the needs of the shippers and the public. In Black's Law Dictionary, 10th edition, 2014, reasonable is defined as fair, proper, or moderate under the circumstances, sensible. There is nothing fair, proper, or moderate in the railroad-shipper relationship. 96-448 has created a monopoly that inures to the benefit of the shareholders of the railroad, absent of any financial normalcy in rates, accessorial charges. Market power has been created that is unparalleled in other sectors of the economy. Market power or monopoly power creates a duopoly, the ability of a company to heavily influence the price charged for its product. Since the railroads have exclusive franchise domination granted each of them by the STB, absent reciprocal switching, they enjoy unfettered market power. And where firms possess market power, there exists a danger such power may be abused. For example, the charging of monopolistic pricing to the detriment of its consumers. And such is the state today of the shipper-railroad economic relationship. Railroads, under the protection, not of the law, but of the STB, are afforded the luxury of market dominance, the cost of which transfers to the distribution system and ultimately then to the consumer. The cost today is not even quantifiable. Allow me please to offer a couple of personal examples issued that speak to the subject of today's hearing. Perryville Cold Storage, Perryville, Maryland, is located midway between Baltimore and Philadelphia. There's a rail car delivery track adjacent to the main rail line between Baltimore and Philadelphia, on which the Perryville cars are placed by the CSX. The delivery track is almost a mile from the Perryville facility. The cars are brought to our facility from the delivery track by a third-party switcher. CSX starts the demurrage detention clock at the time the cars are placed on the delivery track, not, I repeat, not when the cars are actually delivered to our facility. There's no consideration as to when the facility actually receives the cars for unloading. In order to minimize the exposure to demurrage or detention, we have repeatedly requested the CSX deliver the cars directly to the facility, which is their obligation under the railroad bill of lading, and not leave them for the switching service. This then would be fair and reasonable as to when the clock starts in determining charges for detention and demurrage. Not only have we been unsuccessful in our approach, but using the years 2017 and 18 as an example, Perryville and their sister warehouse, Chambersburg, have paid in excess of $271,000 in demurrage and accessorial charges. Bunching is prevalent, and minimal consideration for relief by the CSX is normal. I have in my hand, which I'm happy to share with the board, a document that shows a listing of 20 bunched cars delivered at 11:03 p.m. at the CSX delivery track at Perryville last Wednesday, May 14th. All but one shipped to Perryville from the same Oregon location. The days in transit range from 11 days to 22 days, a span of 11 days extra. Would you not agree that this is ludicrous? Is this what the railroads refer to as precision scheduling railroading? In closing, members of the board, we are here today because the STB has not yet addressed its mandate of providing a regulatory process that balances the needs of carriers, shippers, and the public. The railroads must be held accountable to not only the board, but the shipping and receiving arms of the rail transportation system. Until the STB takes a firm position in protecting the public from the arrogance and monopolistic posture of today's railroad system, the result will continue to be the same: a deteriorating service level and a push by the railroads to pass on to the consumer the costs associated with the inefficiencies of the system. I join and respectfully request that the STB consider the plight of the associations represented here, shippers, receivers, and private rail equipment lessees, by crafting a firm policy of reasonableness by the railroad of its charges to the rail community at large. Absent such a policy by the STB would be a monumental economic tragedy. Thank you for affording me the opportunity to be part of this hearing today.
Thank you. Brad?
I'd like to thank the board for this hearing and for allowing me to participate in it. My name is Brett Mears. I'm the president of Palmer Logistics in Houston, Texas. We're a third-party warehouse. Very similar to the gentleman from Kinder Morgan, we don't have any control over the shipping and receiving of the cars. It's directed by our customers. We ship about 300 box cars per year of chemical goods, and we receive about 600 box cars of foodstuffs. At the end of 2017, we secured a contract with the U.S. government, with USAID. We were the pre-positioned warehouse for food aid for USAID. We started handling that business in one of our existing facilities that's served by the Union Pacific. We're limited there by the UP to 3 switches per week with 7 cars per switch. So February, March of 2018, we quickly racked up about $150,000 in demurrage and decided we needed to do something differently. So we went out and we procured a new facility, leased another warehouse in Houston, a multi-million-dollar lease over 3 years, and we approached the UP. They agreed to switch us 3 switches per week at that site to 10 cars per switch. In June of 2018, we started receiving heavy volume. USDA had tendered to their suppliers, and we started receiving heavy volume for a buy for the humanitarian crisis in Yemen. Over the next 3 months at this site, we had serious UP service issues. They missed 15 of 40 switches, and they refused to increase the switches as well. And those numbers are their numbers. We actually hold it to be higher because we didn't get our 10 switches per switch, and we got them on every day of the week. So we quickly racked up $750,000 in bill demurrage by the Union Pacific. We also delayed a humanitarian shipment to Yemen. The initial bill, as I said, was over $750,000. It's since been reduced to $242,800, which is what UP says it would have been if they gave us perfect service. Unfortunately, this is going to be passed to the taxpayers, and it's going to reduce the amount of money that USAID can spend on humanitarian relief. And it really could have been avoided if the Union Pacific had expanded service to that site and gave us more than the 3 switches at 10 cars per switch. We're in a similar situation with respect to preparing for a humanitarian issue that's ongoing right now. This year, the U.S. government and their suppliers have decided to truck the material to our facility because they were concerned about the reliability and the demurrage costs if they tried to ship this by rail. So that's over 10,000 tons of material that's going to ship to our facility via truck, over 500 trucks on the road instead of 180 approximate rail cars that are coming to us to deliver this humanitarian aid. One thing to note, these cars are packed with about 1,500 floor-loaded bags of agricultural products, beans, lentils, flour, rice. So we have to line up labor in advance to these cars delivering. So if we line up labor and then the switch doesn't happen, I now have 12 people that I have to pay to sit around to do nothing, because if I don't pay them when the rail car comes, they're not going to come back and work for me. So we have a significant issue when the railroad does not deliver to schedule. So what I think is, what I'd like to point out as unreasonable is the inflexibility of the railroads to increase switches vis-a-vis the shipment volume. That was a 4-month time period that we did not get any extra switches despite the volume that delivered to Houston in 2018. We get fined for driving rail efficiency, but what recourse do we have when they don't deliver and I have to pay that labor bill? And then finally, Demurrage is just billed out of their system. There's no sync up to what their operational performance truly is. So the burden falls on the shipper, or in this case, the third-party warehouse, to contest that. It's spending a lot of time and effort to do that. I would ask the STB that if the switch days are limited, define reasonable flexibility for railroad when the volume exceeds the switch capacity. Everybody else in the supply chain has to be flexible, has to account for spikes and seasonality. I believe the railroad should as well. If there are punitive measures for driving railroad inefficiency, there should be punitive measures for shipper and receiver costs associated with the railroad failing to deliver. And then I believe the demurrage bill needs to be validated before sending it to the customer. That concludes my remarks. Thank you.
Thank you. Ken?
Chairman Begeman, Vice Chairman Fuchs, Board Member Oberman, thank you for your time today and good afternoon. My name is Ken Johnson. I'm the CEO of the Shippers Group. We're a provider of third-party logistics services based in Dallas, Texas. We have facilities throughout the United States. Of those facilities, 3 of them are rail served. One of them in the southeast and 2 of them in Texas. We're served by the Norfolk Southern in the southeast and by the Union Pacific in Texas. On the 28th of August in 2018, we were notified by the Union Pacific that they had, based upon their analysis of our volumes, they had decided that our service days per week were going to be adjusted from 5, those being Monday through Friday, to 2, being Monday and Thursday. Now this is prior to the implementation of the tariff that came out a few months later that changed the free time from 48 hours to 24 hours and changed the demurrage fee per boxcar from $100 to $200. In November, 2 months later, we received a demurrage bill for $11,000 for a facility that we had never had a demurrage bill for. We've been in that building 3 years, never had a demurrage bill at all. When we approached the Union Pacific in regard to this demurrage bill, their response was that it was our fault for not controlling the volume once they told us they were going to reduce our switches. All of our switches are multi-customers serviced by boxcar. So there is no one customer in any facility that takes up all of the boxcar service. Had, as you might expect, a number of discussions with the Union Pacific about this 2 different times. We had them visit us in Texas. I had a long phone call with an executive, and I wanted to pass on some of the things that were said during those conversations. First of all, with regard to adjusting our volumes to fit what they say our requirement was, I made mention of the fact that we don't know. We don't have control over the volumes. I happened to have my customer in the room, one of my customers in the room when I made that statement, and he confirmed that. So he asked, the railroad executive asked the customer, when do you know? When can you let us know what this volume increase is going to be? And he said, well, the minute I know they're in your system, the minute that we make that decision, they're in your system. To which the railroad executive replied, well, then just look in our system and tell us when you're going to have this additional volume. And both my customer and myself thought it was odd that they expected us to look in the system and give them the information back that they already had. We were fortunate in negotiating a way that demurrage bill in its entirety, but with the statement from the railroad that that would not happen again. That being said, we feel confident in our analysis of our business that we absolutely are going to incur significant demurrage charges in the very near future if we haven't already and maybe just not received the bill. All of our customers have been notified that if it becomes a big enough financial burden upon our company, that we're simply not going to accept boxcars anymore. 850 boxcars equates to about 2,500 trucks back on the road, but we're simply not going to eat that. We're not going to get in the argument with our customers, since there are multiple customers in each location, about which one is responsible for the demurrage. It's just an unrealistic situation that I don't think the railroad understands. They made comments to us about, well, we have 3PLs that do control their volume inbound. And I said, 3PLs are like a lot of businesses. They change. They're all different, and I can't speak for the other companies, but I can tell you that we don't. We don't control our customers' volumes, and we're not going to be allowed to. And I want to briefly mention another couple of subjects. Bunching. The railroad executives admitted to bunching. I actually don't have a problem with bunching. I understand why they do it. The only problem I have, and it was discussed in one of the panels earlier, is it ought to be taken into account when demurrage charges are assessed. I understand the need to utilize their assets as effectively as they can, but don't make us pay for it. Second comment I'd like to make is when credits are issued for a service failure, such as a failure to switch. For instance, one of our facilities has 10 spots. So if they don't switch us, they give us 10 credits. My argument with that is you didn't just add 1 day to 10 boxcars. You added 10 days absolutely to every boxcar that's in constructive placement, and really you added a day to every boxcar that's in the system, whether it's in constructive placement yet or not. They don't agree with me, but I think it's fairly logical that that's the fact, that a day was added to every single boxcar. And the last point I'd like to make is we feel that the basis of any fair demurrage rule going forward would be based upon actual placement, with 48 hours given after actual placement. Obviously, it would be much more involved than that, but we think that should be the bones of it. And in that, I'll conclude my comments. Thank you very much.
Thank you. Ken, when you receive your demurrage bills, since you have a variety of customers, do the bills identify which customers' cars are at issue?
By number. By number, yes. But when you get it, first of all, our customers' volumes per month are not uniform. They all have different spikes throughout the year in their business. And sometimes those spikes change. One year the spike might be in March, the next year it might be in June, and there's 5 at least in every one of those buildings. It's next to impossible for us. Well, it is impossible. We feel it's impossible for us to control that. We have a knowledge right now. We got a new rail customer that we're going to get in one of our facilities, and we've already told them they're coming. They tell us it's going to be this many boxcars. 2 switches per week is not going to be sufficient when it happens. And I'd failed to mention that on the since the railroad told us they were going to give us 2 switches per week, they've been pretty good about doing that, but they told us they'd be Monday and Thursday. 33% of the time they missed Monday and Thursday, and some of the 33% of about half the time, the switches were made on the weekend. That only refers to days. With regard to uniformity of the time of day, there's none whatsoever. Even when we get the Monday and the Thursday switches, there's no telling at what time of the day it'll be.
Couple of questions, and I'm just going to go back down. Ken, when you said that you had never had demurrage charges ever, and then you got the bill for $11,000. So do I understand that the reason for that is because with the reduced service days, there was bunching, and therefore you couldn't unload within 24 hours, and you also got 24 hours of free time?
Yes, sir.
So that's what caused it?
That's correct.
And did you know that was coming?
No. No.
Well, they must have told you they were reducing your free time to 24.
Oh, no, we knew the change. No, I'm sorry, I misunderstood.
Yeah.
Yes, we knew the changes in free time was coming.
So you knew that you were, if you couldn't unload them, you knew you were going to be getting a demurrage bill?
In all honesty, we should have known. We should have known if had we known the volume increase that our customers were going to give us. We didn't. Given the fact that when they switched us every day, those same yearly fluctuations based upon peaks and valleys, we never had a demurrage bill.
Even with fluctuations in volume?
Even with fluctuations in volumes, we had never had one.
So my question is, had you known, or now you do know, what can you do to avoid the demurrage charges?
If they're bunched in transit with the additional volumes and there's no alteration made to the way the demurrage is calculated, we're not going to be able to avoid it. That's why I made the comment that I made, that we've already told our customers, but this becomes a financial burden that we think it's going to be.
Let's assume that you were willing to spend whatever it took physically. What can you do to avoid the demurrage? Is it hiring more people, getting more warehouses, or what would you have to?
Well, you know, warehouse is a pretty big fixed cost.
No, I understand. So I'm trying to get.
Come close to the savings of avoiding the demurrage.
Well, that's really sort of the question. The concept that we're being told is that this is an incentive to get you to move faster. It sounds to me like it's an incentive to get you to stop using the railroad.
Well, actually, I don't agree with that. I think it's a profit incentive by the railroad because they one of the comments I'm making some conversation out in the hallway was, if our company has a consignee that's difficult to deliver to, and we double their rate to make delivery to that consignee, what that is, that's a negative incentive because we're trying to change behavior. However, the difference is there's 500 other trucking companies that'll take that delivery, and if they choose to. In the case of boxcars, that's not the case. So my feeling is that the railroad feels that we have no alternative, which makes that nothing but a profit incentive. And when you arbitrarily change a demurrage rate per day from $100 to $200, where'd that come from?
Well, that's what I'm trying.
I wish I could double my rates.
So the point, actually, I was trying to get at, and you sort of backed into it, is that there is no incentive involved because there's nothing you can feasibly do to meet these charges and still do the business you're doing. It'll put you out of business.
Nothing reasonable. Nothing reasonable that makes financial sense.
Well, or is another way of asking it, if you had to do everything you had to do to pay these charges, you couldn't stay in business?
Or we just wouldn't do it.
It would take your profits away.
Right. Right.
And actually, that's sort of the same question, I have for you, Brett. Is the cause of these enormous demurrage amounts this change in the delivery schedule and bunching? Is that what brought it about?
Yes, it's the limitation of the delivery schedule. So the railroad, because after the first episode of demurrage at the first site, we went back to USAID and said, look, please talk to USDA, and we have to schedule these shipments. They went to their commodity suppliers and they told them it's impossible for us to schedule deliveries into Houston because the rail times are variable. And then in addition, on top of that, you have the bunching scenario. So basically the feedback we got from our customer was you can't schedule it. So in the absence of scheduling, and if I can't get the rail car from the Union Pacific service yard to my facility, I could certainly keep up if they switched me 5 to 6 days a week, and I'm happy to add a work on Saturday and Sunday if I had to keep up with it. The problem is I'm powerless. I have no way to get the rail car from their yard to my facility to unload it in those interim days that they don't switch me.
So if the demurrage charge were $10 or $500, it wouldn't make any difference in your behavior because you can't change your behavior because these things are out of your control?
That's correct. It'll get to a point where we just have to declare force majeure and we can't do the contract anymore because of the punitive cost of demurrage, which we cannot control.
Same question, Michael, to you. It sounds like at some cost, Anderson DuBose could accommodate or could unload faster, right? Could you just comment on what is it you could do to avoid, you know, $400,000 a year is a lot of money to a company your size.
For sure. Additional staffing, you know, on premium shifts where possible, opening up additional shifts at a higher cost would be one thing. Expanding the facility, right? We're at 2 doors, so we can expand it to push the throughput, but that would be very costly.
Would you have to spend more than $400,000 to
I would think
avoid
so.
these charges?
Based on a recent expansion that we had, yes, I would say that's true.
So it's not an actual incentive to get you to do anything? And the only other question I had was for Mr. Weiner. Is it Weiner or Weiner? Weiner. You, I was interested, as the chairman is, in this retaliation question, and my only question was that you listed the things that happened to you after Herman testified 2 years ago.
Yeah, Herman got me in trouble.
Yeah, well, is he still around? There he is. Herman, behave yourself. My only question was, the changes that you mentioned, your time was reduced from 3 to 1 day and so forth. Was that only applied to your company and not other shippers and receivers by the railroad? I mean, in other words, were you singled out for this treatment? Do you
I
know?
believe so, sir.
Okay, that was all I had. Thank you.
A couple questions. Brett, you posed a couple solutions, one of which was that charges should be validated before they're issued. And I guess I'm wondering, you know, sitting where we are, how would we know something is validated? What, you know, how should we be thinking about whether or not there's appropriate validation protocols in place?
Well, I mean, you know, the fact that they billed us $750,000 and then after 3 months of kind of back and forth through their dispute process dropped it to $242,000 tells me that they basically just fired something out of their system and didn't ever go back and compare to see did they serve my site to what the standing agreement was, which was 10 cars per switch 3 days a week. So I think that would be the first step, and then the bunching would be a second step as well. So
yeah, and you beat me to that, you know, and so the kind of the hypothetical example that we've been using, I guess, today is, you know, the 5, 5, and 5 that comes back as 15 for, you know, with track capacity for 10. And again, talk me through how the board should be thinking about, if the board, you know, and how the board should be thinking about, you know, those 5 cars, and I think what was discussed in the last panel was ripple effects. So how should we be thinking about, you know, if we wanted to address bunching, how would we do that?
you know, I think I see the point of why cars are bunched, as my colleague Ken commented here. You want to be able to do that, but I think if the railroad's gonna do that, they spoke a lot about increasing the efficiency, and I think they're speaking about the point-to-point efficiency. The problem is they don't have the resources, you know, in the last mile delivery to affect that. So, you know, I think what is reasonable is if you're gonna bunch 5, 5, and 5 to 15 and you can only deliver 10 at a time, then you need to give them an allowance. Anything beyond those 10 cars when they get there, you need to give them an allowance.
The equivalent of 5 credits in that instance?
The equivalent of 5 credits until their next switch day, and that needs to be, you know, kind of to Mr. Johnson's comments, that needs to push back on every car in that backlog, because otherwise you can get a cascading
right,
backlog.
and that's what people are also talking about, the ripple effect, but the 5 credits that you're describing only captures the 5 there, right?
It has to be in it has to be done perpetually for all the cars in transit if you're operating close to capacity.
Up until capacity constraints are alleviated.
Exactly.
Within a reasonable period. Okay, and then Ken, you mentioned you get 1 credit. So let's use this hypothetical again. Are you saying that if you had kind of those 5 cars in constructive placement, and let's just say for whatever reason you just left them there for too long, and are you saying that the 1 credit, or in the 5 that are in constructive placement, are you saying that the 1 credit would apply just 1 credit for all 5 cars?
In the event that they didn't switch?
Yeah. You get 1 credit
You got to
for
get
all
1
5?
per car.
You get 1 per car, per day.
Or if there's 25 cars in constructive placement. My point is, when you don't switch, you don't just add a day to every car you fail to switch.
Okay.
You add a day to every car in the system.
I
And
see.
if you want to call it constructive placement, which is not every car in the system, but okay, constructive placement. But we all know that there's probably cars in the system that are not yet in constructive placement. And this thing, failure to switch is adding a day to everything.
I see. So then, and so what you're talking about is additional credits to capture, I guess, the ripple effect as it's been described.
Yeah, the way that Brett described
Okay, I
it.
just wanted clarity on those 2 points. Thanks.
Yeah.
Is there anything any of you would like to say with respect to the testimony you've heard so far, or anything as far as what we've been asking?
Briefly, I've been told by some folks I came here with not to be emotional, so I'm not going to do that, but I will say this. There were some comments made earlier about percentages of success by the railroad, with 73% on time, 95% correct billing, and the comment that I made was, we get fired for those kinds of percentages. It's not, that would be completely unacceptable in the world that we live in.
But don't cry about it. I'll just make this observation, and I don't want any of you to think, because we haven't maybe drilled as much home as we did with earlier panels. I mean, we're hearing a lot of the same things, and your unique stories are very helpful to us, but it doesn't mean we're not just as interested in your situations as all the others. Each one of you, to me, has added a great deal to our education, so I appreciate that.
And I think it's been really great that it's really been a diverse panel of interests.
I'd like to add one thing if I could. If the bill was sent to each of my customers, then I would have about 17 or 18 customers that received demurrage. So the comment that, we have a lot of customers that aren't billed demurrage, well, when you bill a third-party warehouse that has 10 or 12 shipper customers in that warehouse, they're not getting the bill, but we are, and it's essentially driven by their behavior.
Thank you.
Thank you. The next panel, panel 6. Okay, we will start with panel 6, and it is 408. Go ahead. Thank you, Richard.
Thank you. I'd like to thank the STB for having this hearing today. It's an important one to focus on the demurrage and accessorial charges that have been imposed on railroad customers. I'd also like to thank you for the efforts on the rate reform and other regulatory reform efforts that the STB is looking at. We want to have a partnership with the railroads. We want to make sure it operates in an efficient way. We also want to make sure that it's a true partnership and there's some accountabilities when there's deficiency. So we, again, appreciate you taking a look at this. Again, I'm Richard Gupton. I'm Senior Vice President of Public Policy and Counsel for the Agricultural Retailers Association. We're a nonprofit trade association representing agricultural retailers and distributors across the country. Our members provide goods and services to farmers and ranchers, which include fertilizers, pesticides, seed, crop scouting, soil testing, custom application of pesticides and fertilizers. Their certified crop advisors and agronomists work with the farmers on comprehensive nutrient management plans. Our ag retail distribution facilities of our members are scattered throughout the United States, and they range from small family-held businesses to 1 or 2 outlets, to farmer cooperatives, to large companies with multiple outlets across the country. Our members use the railroads to transport crop input materials because it's generally the safest, most secure, and efficient way to move these products. Assuring that the rail service is dependable and provides consistent delivery to agricultural retail and distribution operations is critical to ensure that a complex distribution system moving a large volume of products remains successful and efficient. For example, in the Midwest, nearly all the regional dry and liquid product fertilizer warehouses are primarily filled by train. The other modes of transportations, which are pipelines, trucks, or barges, all have their more limitations, and whether related to lack of capacity, lack of trucks or drivers, which is a big debate right now, or geographic limitations when it comes to barges. Those are all a lot of constraints. The cost of rail service for ARA members has increased at a rate that forced the industry to try to look towards alternatives, but there are few realistic, economically viable options that remain available. The Fertilizer Institute had conducted a survey, and they're testifying later today about the significant increase in the rates for a product called anhydrous ammonia, which is a widely used critical crop protection product. Their rate went up over 200%. That compares to inflation only going up at that same time of 26%. So looking at these issues is very important to our members. Reports that have been submitted by the railroads actually clearly show the significant railroad revenue being generated through demurrage charges being imposed against their rail customers. And this type of reporting is something that the STB needs to kind of bring about the necessary transparency and should be continued as part of any regular reporting process. ARI believes that these charges are well above and beyond the intent of the STB demurrage liability regulations that are designed to encourage an efficient transportation network. We recently surveyed our members on this issue, and they all came back that they had problems with one Class 1 railroad or another. And the main issues, and it's the theme I think that's throughout this day is focused on, is the 24-hour constructive placement is a totally unreasonable time for our members. We recommend a minimum of 48 hours and potentially up to 96 hours as needed depending on the circumstances, like in the busy season. The short time frame when moving these cars from the short line interchange to the ag retail facility, then back to the interchange, effectively leaves about 15 to 16 hours to load or unload after constructive placement, with little time to align the crews and inspectors within that window. And a major problem relates to, as was been discussed today, is the bunching until they have more cars to be sent to those facilities. And I understand why they're doing that, to be more efficient, but you also need more flexibility for those facilities and more time, a more broader window of time to accomplish that. Our members should not be charged for the delayed delivery of those rail cars and given only short notice and narrow time frame to unload or load the products. The overall transit time for products can be anywhere from 14 to 21 days, but they're only given this short window and then having to do a short notice trying to hire the additional people and personnel to handle the cars. And during the peak seasons, there's not enough time during the day to handle that under the current rules. And so what they're having to do is, again, hire more people at overtime. It's having to sometimes be done unloaded during the dark, which adds increased safety risk and issues. We were informed by one of our members that in the first month of the new demurrage rules, they experienced railroad charges from yard storage exceeding $130,000, forcing them to try to look at alternative transportation sources to move their product. ARA members have also been required to build additional tracks at their expense, and the cost estimates we got back was roughly $800,000 or more per facility, but many of them do not have the physical room to expand their in-house storage tracks. The railroads have not, from the input we've received, have not provided the sources of the fixed and variable costs, so there's really not the transparency about how they come up with these charges, the numbers. And they've been closing some of their yards in the name of efficiency, but that increased distance of being serviced, all the costs are being imposed on our members. So what we would like to see is a more, and it was mentioned today, they're implementing these systems for a more efficient, timely reporting of where the products are in transit. So if they do have that kind of real-time information for our members, I think that'll go a long way to at least help them know when those cars may arrive. And I think if the cars were delivered 5 at a time, those could be easily handled at our members' facilities. But when you're getting 20 cars at a time, they can't reasonably make that 24-hour period to unload those. It's just not reasonable and impossible. And when they have, from our members, they said when they have unloaded ahead of time and got ahead of schedules, the railroads may not be able to take them. They're not getting credit for those things. So if they are running ahead of time and be more efficient, they need to get the credit for that. The last thing I'll mention is there needs to be, again, some reciprocity. If the railroads aren't living up to their shipment dates and the like, then there needs to be reciprocal demurrage charges against them or some type of credit system where they're held accountable. This will lead to more commercial fairness, foster increased competition and accountability, and a more efficient rail system. And we look forward to working with the STB and the railroads on this important issue. Thank you.
Thank you. Hi, Greg.
Hi. Commissioner Oberman, Vice Chairman Folks, and Chairman Begeman. Thank you for this opportunity to present here today. My name is Greg Twist. I'm the Senior Vice President of Transportation for Ag Processing, Inc., better known as AGP. AGP is a leading agribusiness engaged in procuring, processing, marketing, and transporting of oilseeds, grains, and related products. AGP is a cooperative owned by 147 local and regional cooperatives that represent more than 250,000 farmers throughout the United States and Canada. I started my career in agribusiness in 1982, and I've witnessed firsthand a number of changes in railroads, structures, operations, and profitability during this time. I appreciate the opportunity to address the Surface Transportation Board regarding demurrage and accessorial charges and the fundamental question of fairness. Unfortunately, it is sometimes difficult to focus on these current charges without knowing some of the history of how they came about. I'll do my best to shed some light on this history. The C&W Railroad was bought and merged into the UP Railroad in June of 1995. In conversations with UP marketing personnel, AGP was encouraged to supply more of our own private covered hoppers, which at that time comprised about 25% of our fleet. The UP was dealing with a lack of system equipment and capital was at a premium as they took on the acquisition of the Southern Pacific merger in 1996. The BN had similar concerns with the acquisition of the Topeka Santa Fe in 1996 as well. AGP invested in covered hoppers that cost about $53,000 to build at that time. A similar car today would cost about $84,000 to build, an increase of 58%. However, compensation on these covered hoppers has dropped 30% per trip to a domestic point like Turlock, California, and 53% per trip to an export facility like Aberdeen, Washington, since these cars were first built. Part of the rationale used to reduce our compensation on private covered hoppers was the ability to turn cars quicker in units versus manifest service. Ironically, Turlock and Aberdeen are destinations the UP has chosen to move back into manifest service as part of their PSR model. However, the UP has not increased the private car allowance as a result of their slower manifest service. Our export facility in Aberdeen, Washington experienced a 114% increase in transit time for the UP since that move to manifest service. And to your point, Mr. Oberman, talking about the difference in the numbers, if you take that out of unit shipment and you can't load it in 24 hours, that makes the remainder look higher by simply moving that to manifest service. So their numbers look better, ours look terrible. Turlock, California, domestic point is scheduled to go to manifest service come June 1. I expect a similar increase in transit there. When shippers like AGP started adding private covered hoppers, demurrage charges were $25 per day per railroad covered hoppers for as far back as I could find a railroad tariff, and that was the BN 6004 dated August of 2001. At that time, all the Class 1 carriers held our private empty cars for free. Today, now that AGP provides 90% of its covered hopper fleet, the UP and the BNSF now charge more for private empty car storage than demurrage. UP is now $140 for private empty car storage versus $100 for demurrage. BNSF is at $150 per car for PEX versus $75 for demurrage. How can these railroads charge more for private cars that they encourage shippers to invest in versus demurrage for their own cars, which should have a car component cost? Simply put, because they can. Accessorial charges are completely tilted towards the railroads who wrote the tariffs. Take, for example, UP Tariff 6004 Item 9613, which deals with unit train service. AGP is required to forecast a day that the unit will ship 30 days in advance and can adjust that date no later than 72 hours ahead of the forecast date. AGP built a 105-car unit at Sergeant Bluff, Iowa on February 6 of 19 at noon, destined for Mexico. The UP pulled the unit 81 hours later. Had AGP missed our target by 81 hours, we would have owed the UP more than $50,000 for being that far off the target. AGP competes against international competition in South America, mainly from Argentina and Brazil. These countries have spent millions of dollars to reduce transportation costs from the source to export. Meanwhile, rail transportation costs, including accessorial charges, continue to climb in the U.S. AGP has a rail cost of approximately $36 per short ton to move 1,900 miles from our Nebraska crushing facility to our export facility. Our ocean freight to reach essential growth markets for soybean meal is approximately $30 per short ton and moves 6,700 miles. Put another way, our rail freight from our processing plant constitutes 55% of our total transportation costs, only traversing 22% of the total miles. Accessorial charges only add to the challenge to compete long-term internationally. The adoption of PSR by most of the Class 1s, I should say by all but one of the Class 1s, has brought with it a barrage of new charges, all under the guise of efficiency. The UP recently added a not prepared for service charge, which in essence penalized shippers $400 per occurrence. They cannot immediately access cars that are listed to be pulled. However, the UP cannot accurately tell us the time of day to expect our service. Our facility at Mason City, Iowa went 1 full week. It's a tri-weekly service, so they missed 3 switches at Mason City, Iowa in February. Yet they show up after no service for a week and find a rail car in the way and they can charge us. AGP received notice of not ready for service on 8 different occasions between May 3rd and May 16th at our St. Joe, Missouri plant. In every case, our personnel at St. Joe, Missouri used the UP's automated OrderX system to order cars in as required. For example, on May 3rd, we used the OrderX system to order in 20 private covered hoppers from the UP yard. OrderX takes our request and applies the 20 private covered hoppers against the order. However, when the local switch crew, local UP switch crew, is ready to serve our facility, they discover that the cars the OrderX is applied are not the 20 most convenient cars to bring into our facility. So they in turn bring in the most convenient cars, which generates the charge. An invoice is generated because the UP automated system and local crew cannot agree on what cars should be received. We have to dispute the charges. I see the UP has changed and pulled back some of these types of things. They can be charged on this tariff, which was amended on May 17th, and I applaud them for their effort. However, it would have been preferred to resolve this in our hometown at Omaha, and not in Washington, D.C. because of written testimony. The problem is that tariff interpretation usually generates bills that have to be disputed. And thanks to PSR, there are fewer and fewer people to talk to that have the authority to grant relief. AGP spends an inordinate amount of time disputing these charges, which are highly inaccurate. The UP also warned shippers that single cars need to be pre-blocked. In other words, cars headed to similar destinations need to be blocked together, a function that used to be performed at the local UP yard. UP also suggested level loading of rail cars, meaning that an equal number of cars be switched out every day that we are serviced. That would be ideal if our plants were designed just to accommodate the UP. Unfortunately, we have customers to service that require more truck loading Monday through Friday, and thus more rail loading on weekends. What other business can provide a service and dictate how customers run their business or levy a penalty? It will be interesting to watch if future accessorial charges develop from these. Railroads used to be a key economic indicator for U.S. economy. My concern is that they have become an impediment to economic activity. Through their adoption of PSR, they have lowered their operating cost, which limits capacity, less local service, which increases dwell times at shippers' facilities, which are not reported in their transit numbers. And accessorial charges, which lack reciprocity, reward the railroads for their poor performance. The UP also reported personal injury increased 22% in their last quarterly report. That concerns me as a customer. My goal today was to present my facts with passion, not emotion, to convey frustration with railroads' behavior, not anger. But I'd be less than honest if I told you I was not very concerned about the wave of accessorial charges coming at us, and thanks to PSR, fewer people to resolve erroneous charges at the railroads. Railroads have done a wonderful job of redefining the English language. Customer no longer means shippers, but Wall Street. Shipper now means income stream necessary to please customers, see above. Railroad efficiency means customers doing more of their own work. And not ready for service means get out of our way when we finally make it to your plant. And my personal favorite, incentive means penalty. I was raised in rural Illinois, the youngest of 4 boys. My father would occasionally have to spank one of us, and it was usually deserved. Well, always deserved. But he never referred to it as an incentive.
How rural? Where
Central Illinois, kind of outside Decatur, Clinton, Illinois. Yeah. So, lastly, before I wrap up, I just wanted to clarify a couple things we were talking about some of the charges, the $3,200 per charge, taking units off the soybean meal units. Those units never stayed in our plant. It always took 4 to 5 days to build those units, and that power never stayed inside our plant. So to say those units going out, somehow that's a new cost, just, I don't get that. Lastly, with PSR, and on the same vein, we had 4 markets we could go to on the UP with unit shipments. Okay, we could go to Mexico, we still can. That's still allowed under their PSR. But it costs us $3,200 more in and out. We had the river market, Mississippi River Market, and the P&W we could go to. That's moved to manifest service. So to my point I said earlier, that's increased our transit time 114%. To the UP's assertion that they have a manifest model, they do. That spread, which they didn't want to talk about, it's about $900 to $1,000 more per car. That's the reason AGP invested $32 million over time to reduce charges and be able to unitize our shipments. And now when you wave out of that, that makes our investment look very, very shaky going forward. So that's a concern to us as well. So lastly, I encourage the STB to use the power and authority you have to balance these charges. My concern is if something is not done to balance these charges, there'll be less shippers to testify going forward as railroads ration their way to greater earnings with capped capacity. I welcome your questions.
Thank you. John?
Thank you. I'd like to thank the board not only for the opportunity to testify today, but also especially for the engagement of the board in this hearing and the dialogue that's occurred. This is the way hearings of this kind ought to work. So thank you for that. My name is John Bodie, and I'm president of the Corn Refiners Association. CRA is the National Trade Association, 106 years old, representing the corn refining industry in the United States. Corn refining is a value-added agricultural process during which kernels are separated into their principal parts and utilized in thousands of different consumer products and industrial goods used every day around the world. My member companies are highly dependent upon rail transportation with few or no alternatives for inbound deliveries of raw materials and outbound shipments of finished products. This fact can create a sense of helplessness when it comes to objecting to practices they believe are unreasonable. My members play an integral role in the agricultural industry and the U.S. economy. CRA also endorses the testimony of the National Grain and Feed Association in this proceeding. The shipping community, our customers, and ultimately consumers would benefit greatly if the board provided clear guidance to assess the reasonableness of demurrage and storage practices. The board has at least 2 tools by which it could do so. First, as a general matter, the board could issue a policy statement that sets forth key principles and facts that it would consider in evaluating reasonableness. Second, with respect to the across-the-board reductions in free time recently implemented by the Class I railroads, the board could invoke its statutory investigative authority to review practices of regional or national significance and ultimately determine their reasonableness based upon application of key principles. And I'd like to submit for your consideration. CRA urges the board to take these steps and include the following 4 principles among the factors you consider. The degree of reciprocity and commercial fairness reflected in railroad practices. Second, the ability of shippers to comply with new practices in a timely and cost-efficient manner, if at all. Third, the extent to which rail service inconsistencies preclude compliance with a rail practice. And fourth, the extent to which railroads are likely to profit from the new rules, either directly from payment of unavoidable demurrage or storage charges, or indirectly through other rail services a shipper must purchase to avoid demurrage or storage charges. Before I address each of these foregoing principles, I'd like to make 3 fundamental points. First, CRA members do not object to demurrage and storage charges to truly incentivize the efficient use of railroad assets. Such incentives benefit all stakeholders, including shippers, by fostering greater network fluidity, which in turn can reduce costs and benefit the consuming public. However, recent across-the-board free time reductions to as few as 0 days on private cars have stretched the credibility of railroad efficiency justifications. Second, recent actions by the rail industry have treated efficiency as a one-way street, where any charge that enhances rail efficiency, no matter how small the enhancement, is justified without regard to the negative impacts upon rail customers, no matter how great those impacts. Third, railroads have not been willing to accept responsibility for the efficiency effects of their own behavior upon their customers. These concerns underlie each of the 4 principles that I will now address. First, reciprocity and commercial fairness is CRA's #1 priority. This has taken on greater significance over the past few decades as railroads have shifted more and more responsibility for the instrumentalities of transportation, primarily the supply of rail cars to their customers. Indeed, CRA members own or lease tens of thousands of rail cars, including some of the largest private rail car fleets in the nation. For example, according to their written testimony in this proceeding, 2 CRA members, ADM and Cargill, have rail fleets of approximately 28,000 and 19,800 rail cars respectively. In addition to shifting responsibility for supplying rail cars to their customers, railroads also require those customers to pay for storing those cars on railroad tracks, even though the railroads incur that cost themselves when storing their own cars. This cost shifting requires a more balanced assessment in unreasonable practice determinations. Demurrage and storage charges originally were designed to foster the efficient use of railroad-supplied rail cars and storage track. But with most of the nation's rail fleet now privately owned, these incentives need to be a two-way street. Shippers have the same interest as railroads in the efficient use of their rail cars. Reliable and consistent railroad service is a major factor in determining how large a fleet must be in order for shippers to meet their needs. But remarkably, there are no comparable incentives to demurrage and storage charges to incentivize railroads to make efficient use of shipper-supplied rail cars. Railroads rarely, if ever, accept accountability for the effects of service disruptions and inconsistencies upon their customers, even when the railroad is at fault. This board is the only entity that can require such accountability, and it can begin by requiring reciprocity in demurrage and storage charges. Such reciprocity could take the form of paying the shipper a comparable charge when a railroad fails to move the shipper's private car within the same time frame, same free time that the railroad grants the shipper before assessing demurrage or storage charges. The rail industry has taken a very narrow view of the reciprocity and commercial fairness of what reciprocity and commercial fairness means. In response to the chair's letters last fall asking the railroads to review their tariff charges from the standpoint of commercial fairness, they pointed to their willingness to give demurrage and storage credits for selected service and weather-related issues that could delay a shipper's ability to load or unload a rail car. That is not reciprocity. It merely recognizes that shippers should not pay demurrage or storage charges when the extended detention of rail cars or occupancy of storage track is not the shipper's fault. While such credits will mitigate the demurrage and storage charges that the railroad may collect from a shipper, they do nothing to compensate the shipper for the cost to its operations caused by railroad service failures. If railroads are able to charge shippers for acts or omissions that adversely affect rail operations, reciprocity means that railroads should compensate shippers for acts or omissions that affect shipper operations. Next, cost-effective and timely compliance by shippers is CRA's second principle for determining reasonableness of demurrage and storage facilities. These charges cannot serve their efficiency-enhancing objective if a shipper cannot avoid the charge or can do so only at excessive expense. By pushing free time all the way down to 0 days, the rail industry has selected the lowest possible number. Only those shippers with sufficient track within their facilities can comply immediately. Others will have to build more track, or if there is no space within their facilities to do so, they will have to lease track at remote locations. In some instances, those locations may be very remote, simply because there is no storage track available in the vicinity of their facilities. These measures will impose additional costs upon those shippers in the form of track leases and switching charges to and from the storage track, potentially onerous enough for them to conclude that it is less costly just to pay the demurrage and storage fees. Furthermore, the construction or acquisition of additional storage track cannot be accomplished within the short time periods shippers have been given to comply with the new free time rules. A one-size-fits-all approach to demurrage and storage free time, especially when reduced to 0 days, is unreasonable because it fails to account for these significant differences in the ability of rail customers to comply. In addition, railroad efficiency claims should be carefully scrutinized for inconsistencies. For example, because many shippers must secure storage track at remote locations to avoid demurrage and storage charges under the reduced free time periods. That creates additional work for the railroad to switch cars to and from those remote locations. Also, depending upon how remote a storage location is, shippers may be challenged to retrieve cars from storage track in a timely manner. That reduces the utilization rate for those cars, which requires the shipper to acquire even more rail cars to transport the same volume of traffic, thereby consuming more rail capacity. We appreciate that your guiding principle is public welfare. Thus, your determination of reasonableness dictates a consideration of efficiency that is broader than merely reducing railroad operating costs. We respectfully submit that this board should weigh the costs and benefits to both railroads and shippers of the free time reductions. Even if the alleged benefits to rail operations materialize, the burdens imposed upon rail customers may far exceed those benefits. Although the balancing of costs and benefits ordinarily would occur through competition, competition is more limited and often non-existent for many rail shippers. The reasonableness of railroad demurrage and storage charge practices, therefore, requires the board to conduct that balancing, in our view. The role of rail service in the imposition of demurrage and storage charges is CRA's third principle for evaluating reasonableness. Demurrage and storage charges only serve their desired efficiency objectives when the rail customer can avoid those charges through its actions. Rail service, however, is inherently variable, and that variability, over which a customer has no control, can impair that customer's ability to avoid demurrage and storage fees. Bunching of rail cars by a railroad is the most common example of this. I appreciate it's been extensively discussed today. Most, but not all, railroads offer credits for bunching to offset resulting demurrage and storage debits, but only when the bunching occurs on their rail line. Bunching, however, often occurs on a connecting railroad through no fault of the shipper. It should be unreasonable for a railroad to assess demurrage and storage charges anytime the reason for such charges is beyond the shipper's control. Inconsistent or variable rail service also should dictate how much free time is reasonable. The greater the variance in a railroad service, the more inventory of loaded and empty rail cars the shipper must maintain at its facilities as buffer capacity to ensure that rail service does not impair the shipper's operations. If the railroad provided consistent rail service, that buffer capacity could be reduced, if not eliminated, leaving more track within a facility to receive rail cars within reduced free time periods. Thus, it would be equitable to evaluate the reasonableness of free time by comparing it to the variability of rail service to a customer. Railroad motivation is CRA's fourth principle for evaluating reasonableness of demurrage and storage practices. It is beyond dispute that demurrage charges are not to be regarded as a source of carrier revenue. That principle, however, should be applied within the broader framework than just the demurrage or storage charge itself. As I've already pointed out, many rail shippers can only avoid demurrage and storage charges by leasing track at remote locations and then paying a fee to move their cars to and from that track. Often that track is leased from the very same railroad assessing the demurrage charge, and always that same railroad receives a fee for transporting cars between the leased storage track and the customer's facilities. Moreover, in a particularly perverse arrangement, when inconsistent railroad service necessitates the lease of remote storage track, the railroad is rewarded for that inconsistent service with this additional revenue. In conclusion, CRA urges the board to issue a policy statement that outlines key principles it will apply when evaluating the reasonableness of railroad practices pertaining to demurrage and storage charges, including the 4 principles that I have just suggested. CRA also urges the board to invoke its investigative authority to review and evaluate the reasonableness of recent free time reductions pursuant to those principles. That review could consider factors such as reciprocity for railroad service failures, shipper ability to comply with free time reductions in a timely manner, if at all, rail service inconsistencies, and railroad motivations to create new revenue streams. Thank you for your consideration of our views.
Thank you very much. Randy?
Hi. Good afternoon, Chairman Begman, and Vice Chairman Folks, and Commissioner Oberman. I am Randy Gordon, President and CEO of the National Grain and Feed Association, and I'm accompanied this afternoon by NGFA Transportation Counsel Tom Wilcox, a partner in the Washington-based law firm of GKG Law. We're going to kind of divide up our statement based on our presentation. We deeply appreciate this opportunity to summarize the major points in NGFA's May 8th filing, as well as to bring some additional new information to the board's attention that we believe only strengthens and reinforces the need for the board to follow up this public hearing with further action to facilitate the adoption of commercially fair, commercially practicable, as well as reciprocal demurrage and accessorial charges and policies by the Class 1 railroads. You all are very cognizant of who NJFA is. We've got 1,100 member companies, and our diverse membership handles about 70% of the nation's grain and oilseed crop. We're very pleased to have our statement, for the record, supported by the Corn Refiners Association, as well as the National Oilseed Processors Association, the North America Freight Car Association, and the North American Millers Association. Let me start by thanking Chairman Begeman and this board for focusing on this very important issue and the diligence, which is very obvious today, with which you're doing so. We believe that in far too many cases, current demurrage and accessorial charges and practices merely exemplify the market power of today's Class 1 railroads, reflected in their ability to unilaterally impose one-sided terms and conditions on their customers. There is no question that the board's attention has brought increased transparency to these practices and triggered what has been a pent-up groundswell of concern among rail customers, as evidenced by the heavy turnout at this hearing. Frankly, NGFA members in some segments of our industry believe they are at a virtual tipping point in their relationship with Class 1 railroads. In our time today, NGFA wishes to do 3 things. First, we want to highlight several examples of Class 1 railroad tariffs that we believe contain commercially unfair, commercially unachievable, and non-reciprocal demurrage and accessorial charges and practices, many of which have already been discussed today, and I'm not going to belabor those or go through all of those that we cited in our written testimony and written statement, because those are already in your hands and been reviewed. Second, NGFA wishes to highlight the disparity in dispute resolution procedures, including several that we believe are designed to intimidate aggrieved parties from ever filing a dispute. Third, and perhaps most importantly, NGFA would like to present for the board's consideration a path forward on developing and implementing policies and guidelines that would, we think, help lead railroads to modify their tariffs to be more commercially fair, practicable, and reciprocal, and the legal basis and justification that we believe the board has for doing that. I will address the first two items of that outline and ask Mr. Wilcox to address the third. Before doing so, I do want to just make a couple of statements. It's already been referenced about the extent to which the railcar fleet today is privately owned or leased, including 100% of the tank cars, and in the grain sector, about 80% of the grain hopper cars are now privately owned, owned or leased. In addition, many rail shippers and receivers have invested tens of millions of dollars at individual facilities to acquire, expand, operate, and maintain track and other physical loading and receiving assets, as well as hired additional personnel to perform tasks previously done by the Class I railroads. Meanwhile, the number of tariff provisions pertaining to demurrage, car storage, and accessorial charges has expanded significantly during the past 6 years, and those charges have increased dramatically. Further, these tariff changes often are being imposed unilaterally and with little to no notice. We would make note of one NS charge related to locomotive charges from removing and adding a locomotive of 100 cars per locomotive that went into effect immediately upon notification, rather than an email notification, rather than with the required 20-day notice. But in that regard, in the longer term, we do believe the current 20-day notice requirement for tariff changes needs to be increased significantly to provide sufficient protection to rail customers and in recognition of the investment made by rail customers in their facilities and capacity to handle rail traffic. NGFA's written statement notes the majority of complaints received from its members have been associated with demurrage and accessorial charges and practices implemented by the Union Pacific and the Norfolk Southern. But it's not limited to those two carriers. And in fact, we think a broader statement of board principles and guidelines is needed in order to provide some parameters around railroad conduct in this area. First, each tariff should be evaluated from the standpoint of commercial fairness and whether it is achievable given best practices of the shipper or receiver. One example cited by many parties in this proceeding is the reduction of credit days to 0, and I will not further elaborate on that, but we do believe that a minimum of 24 or even 48 hours of free time once a unit train or a train is actually placed at a customer's facility needs to be considered. In this regard, UP concedes in its May 8th statement to the board that its unilateral reduction in free time to unload cars to 24 hours now from the previous 48 hours is a major factor in its increased demurrage revenues. Second, tariffs should be required to contain clearly stated and monetarily comparable reciprocal provisions that will apply to the railroad if it is at fault or the rail customer is not responsible for delays, such as for spot and pull delays. A classic example there is the much discussed not prepared for service tariff requirement by the UP, which I won't further belabor. The same principle applies to UP's general rule that penalizes rail customers $10,000 per occurrence that if they cancel unit trains within 48 hours of the forecasted date of release. That's been brought to our attention by many members of NGFA and has been elaborated on already by Greg. BNSF Railway also states in its May 8th filing with the board that its practice is to excuse demurrage charges imposed on affected shippers if BNSF is responsible for delays and inefficiencies that result in such charges. But there is no mention of reciprocity in the BNSF tariff. Third, or in this BNSF statement. Third, some Class I railroad tariffs previously contained language that excused demurrage and accessorial charges caused by the rail carriers' bunching of cars. Tariffs should be required to contain language that specifically spells out when charges will be waived because of bunching, and any penalties that should apply when the bunching further compromises the individual rail customer's facility's ability to function. Fourth, some railroads' debit and credit systems are vague, while others are commercially unfair. Rail tariffs should be specific and unambiguous regarding debit and credit procedures. In other cases, NGFA believes the charges being imposed clearly are commercially unfair and unreasonable. Our written statement cites several Canadian Pacific Railway and CSX Transportation Company tariffs as examples of this. I'd like to bring to the board's attention, though, 2 or 3 others that have surfaced since we submitted our filing on May 8th. And these all involve the Canadian Pacific. First is a $500 per car diversion charge even if CP is responsible and even if the reason is to divert empty cars to load balance private cars. Second, a CP $535 per car charge if a car must be switched onto a train after being set off at an unplanned location with no reciprocity provided by CP if it caused the set-off. Third, $125 per mile special train service even if CP is at fault. And finally, on CP, a $110 fee to collect a refund if the shipper is shown to be correct in challenging a demurrage bill or accessorial charge. Given the focus earlier today on dispute resolution and NGFA's involvement in that, Chairman Begeman in particular, in response to your questions, I want to highlight some items in that area by looking at briefly highlighting our concerns regarding the current dispute resolution processes. By omitting or eliminating tariff language that specified when demurrage and or accessorial charges would be waived, credits issued, or the absence of customer fault recognized, the Class 1 railroads have given themselves sole discretion to make such determination if a dispute occurs. NGFA's written statement documents the one-sided nature of most of these dispute resolution mechanisms, and the rail carriers' own filings document that they collect the vast majority of their claimed amounts. One railroad, BNSF Railway, states in its tariff that it will arbitrate all disputes, claims, questions, or controversies arising out of charges assessed under both its tariff and demurrage books involving the transportation of grain or grain products under NGFA's rail arbitration rules unless the parties agree otherwise. That's a positive move. In addition, NGFA learned for the first time from UP's filing on May 1 that it purportedly has agreed to arbitrate contested demurrage and accessorial charges using a number of commodity or mode-specific rules, and it specifically referenced NGFA's rail arbitration system. But we've not been able to identify that language in any UP tariff to this point. Yet, even as a full-throated proponent of alternate dispute resolution, NGFA believes that absent a clear set of STB-established basic ground rules outlining what demurrage and accessorial practices are and are not acceptable, arbitration too would become a cumbersome process by forcing the current myriad of questionable practices to be resolved in individual disputes rather than having many eliminated by the existence of basic principles of whether a tariff is commercially fair, practicable, and reciprocal. And Chairman Begeman, in response to your question earlier today, our rail arbitration rules do provide for arbitration under our rail arbitration system of the application of demurrage terms and rules, but not necessarily the terms of those rules or the fairness of those rules or the reciprocity of those rules. And under our arbitration system, rail carriers obviously have an ability with 90 days written notice to withdraw from that system as well. So those are, again, I think that points to the need for some basic principles by the board to put some guardrails around what is a reasonable tariff and what is not in this area. As an example that NGFA believes clearly is commercially unreasonable is the one that Commissioner Oberman already cited, the NS's language related to having all reasonable attorney costs borne by the shipper, but not any reciprocity in terms of if the shipper wins a case. In NGFA's view, that kind of language has a chilling effect on a rail customer's willingness to challenge any NS charge. NGFA's written statement also cites UP tariff language that has a similar effect. NGFA also has recently been informed that under CP's 15-day timely dispute process, it typically responds to a customer dispute by asserting that its computer system prevails and rendering a verdict dispute declined with no further explanation. In these instances, too, we believe the board should rule that such language is presumptively commercially unfair and non-reciprocal. Now I'd like to turn our presentation over to Mr. Wilcox to discuss how NGFA respectfully suggests the board proceed from this point and the legal basis for doing so. Thank you.
Thanks, Randy. I think we only have a few minutes left, so I'll try to be quick. NGFA submitted a long submission, and the reason is that NGFA has been looking at these issues for a while, and that included a review of the various statutory provisions, maybe not as exhaustive a review as Commissioner Oberman mentioned earlier today, but we took a look at it, and NGFA believes the board has ample authority to direct the railroads to modify their current tariffs to be more reciprocal, commercially fair, and should do so as an outcome of this proceeding. Our discussion starts on page 29 and includes, we talk through the various statutes and some precedent, but some of the precedent we cite are several decisions where the board held that mere statements of the railroads about how they intend to interpret their tariffs in dealing with their customers, and you've been hearing a lot of those statements really since November of last year. Those statements are not acceptable if there's no support in the tariff for what the railroad is saying, in terms of how we're going to work with our customers and we're going to add credits and do whatever. If the tariff doesn't really spell that out, the board has held in several cases that tariff provision is unreasonable because it's impermissibly vague. And that's a big part of the problem, as you've been hearing today, and as Randy just discussed. You have some language that used to be in tariffs where the railroad admitted fault or took care of if it's if the railroad was at fault or the shipper was not at fault, charges would be waived or credits or that kind of language. Even bunching, that language has been removed from a lot of tariffs, and so you have a lot of arbitrariness. You have a lot of uncertainty and inability of a shipper to point to a tariff and say, here's our deal under the tariff, and you're at fault there. You need to waive your charge or whatever. Instead, it's thrown into these dispute resolution processes, which you've heard about, and then the step beyond that is a place where shippers are reluctant to go, which is litigation, formal litigation in federal court or before the board. And so the general approach historically from the STB, the default position has been, if there's a dispute over a demurrage or accessorial charge or tariff, is to bring a formal complaint. And the board said something about this. Chairman Begeman mentioned EP 707. There was a very narrow decision, and during the comment process, some shippers tried to say, well, let's talk about these other issues, and the board said no. We have ADR and we have the complaint process, but ADR is not shown to be effective, and more significantly, as you've been hearing and reading, the volume and the breadth of the changes have just been staggering, particularly over the last couple of years. So the idea of resolving all those issues complaint by complaint by complaint is really unrealistic and would be administratively burdensome. And plus, you have to remember that a lot of complaints that are brought before you are eventually settled by the parties. And so the idea of getting a precedent that could be used in the future by other complainants, potential complainants, and it goes away if those parties settle and they settle confidentially. So that's a consideration. And that's not even getting into the cost and complexity and all those issues. And as has been mentioned throughout this proceeding, the industry has changed in terms of the distribution of rail cars, private rail car ownership, assets. And so that begs for a policy change in terms of the rules. And so NGFA believes there's a pressing and current need for the board to act by developing specific guidance, as Randy mentioned. And as we talk on page 34 and 35, it's so long I have to give you the page numbers. We suggest that the process the board followed in the fuel surcharge proceeding lends itself to this proceeding. In that case, there was no complaint filed, there was no petition for declaratory order filed. There was just a really large outcry about percentage of the rate-based fuel surcharges. And the board proceeded in EP 661 saying, under 10702, they have the authority to adopt rules of general applicability for future conduct to address an unreasonable practice. And so in that case, there was a first round of hearing, like this, oversight hearing, and that was followed a few months later by a decision with some proposed guiding principles for rail fuel surcharges. And then there was another comment period to discuss those proposed guiding principles, and then that was followed by a final decision where the board issued guidelines and gave the railroads 90 days to amend their tariffs to comply. The railroads were directed to amend them. And so we suggest that you know, the information you've been provided, and to the extent you want additional information about some of these principles and that you've been hearing, there's a lot of themes, consistent themes, would lend itself to that kind of process. And we suggest it could be used, but also with the addition, and somebody mentioned this earlier, of board oversight. Rather than have the process where the board directed the railroads to amend their tariffs, they amend their tariffs, and then the way of testing whether they complied is for someone to file a formal complaint. That's happened in other proceedings. We suggest a more efficient way would be for the board to retain oversight, and you could have shippers that didn't think their particular railroad complied could file like a motion to show cause, as to why that railroad didn't comply with the principles that the board has issued. In the alternative, you could have shippers file a petition for declaratory order, something short of a formal rate complaint. Or excuse me, in order to do that, no one does, right? A complaint case, but it would still. This would not eliminate complaints, formal complaints, but what is needed now, and I think you've been hearing, is there needs to be a step by the board to rebalance some of these tariffs and the relationships, the commercial relationships through the tariffs, in sort of enable the parties to resolve it that way through the language in the tariff, restore some of this balance, while leaving the complaint process in place for bigger issues that can't be resolved. So that's under my time.
Really, your testimony, all of it collectively, was terrific, and I will admit that when I got to your 43-page document to read, when I still had half of the testimony to go, I was like not overly thankful until I got through it. It was super helpful in focusing on a number of the tariffs that otherwise I may not have been as familiar with. I'm going to make a comment because I don't want to forget to say it, and then I want to make another comment. But Tom, well, I appreciate your recommendations as far as what the board could do. And I started, as you were playing it out, I'm not a patient person. And so while I just thinking, so by next year, if the board could put something out, what I would ask the carriers to do in the meantime, again, I don't know what the board will do, but I think the board will be doing something here and there, is to really please take to heart what your customers are saying. UP, again, I commend you. You read the testimony and you've taken some action. I'm not saying it's enough action. I'm just saying thank you for being receptive and to trying to work with your customers. Greg, I thought your testimony was amazing as usual. Whether you're here at the Grain Car Council, you always have a story. But before I forget to say it, I wanted to, for planning purposes, because we still have scheduled 2 more panels to go, and I don't want to end up really shortchanging any of you who are before us at the moment, or the other 2 panels. The rail panel, KCS and CN, I believe it is, who is scheduled to go next, they are willing to defer until tomorrow morning so that we could then turn to the last panel, the chemical panel. I realize that those of you who are on point for tomorrow are like, but I have a plane to catch, etc. If any of you feel that are worried about how you're going to get through the day and home again, if you would just come and visit with Lucy Marvin. What we will do is we can. You don't have to be on your panel. We won't put you on the rail panel, but we can work you in early, or maybe we will. Might be a good dialogue, actually. But if you please would talk to Lucy if any of you are concerned about delay, particularly for the afternoon. So thank you for that. And thank you, railroads, for your willingness to defer and readjust your testimony. Thank you. Either of you want to chime in?
Thank you, Ian. In no particular order, Tom, a couple of things. First of all, I should mention specifically that when I said we had done a thorough review of the law, I'm talking about Julie Waddell on our staff and Sarah Francher, and they should be noted by name because the research they've done for us is phenomenal. You would all be lucky to have them on your team. So and the carriers as well. So I wanted to not let the day go without mentioning that. Tom, just because you are a lawyer and I like to ask lawyer questions, a couple. I don't know that you've prepared for this, but you know, there's been a great deal of talk today about shippers being, if they request service, are being told, here's the terms of the service, this is the demurrage tariff. And that's the way it is. So I went back to Black's Law Dictionary to look up, remind myself of the definition of contracts of adhesion. Would you think that's a fair description of what we've heard here today about the terms on which shippers and receivers are offered service and subject to these demurrage tariffs?
Well,
Do you want me to read the definition to you? Do you remember it from law school?
I haven't looked at it in a while. In fact, it was in the context of a percentage-based rail fuel surcharge being imposed.
Well, one of the definitions is, it may be a take it or leave it proposition, often called a contract of adhesion, under which the only alternative to complete adherence is outright rejection.
Well,
is that a fair description of what's being offered there?
I see where you're going, but the thing that gives me pause is that in the contract of adhesion, you usually don't have any recourse, and there is, you know, just the board has jurisdiction over these demurrage practices. There is recourse, but it's seldom taken because it's.
Well, in a contract of adhesion, you can ask a court to declare it invalid. I mean, that's the usual remedy, so it seemed to me it had some analogies to it.
But in terms of the current market and rail market such as it is, and the captivity of many shippers, yes, it gets very, very close to that, indeed.
All right, thank you. I wanted to just raise that issue because it's been humming around in my head all day as we've been listening to these.
Mm-hmm.
Greg, on a personal note, I grew up in Springfield and had some of the similar non-incentive treatments as a young child myself, not far from Clinton. I wanted to, that's why I asked you the question. I wanted to ask, and maybe both Greg and Randy, you can address this question. There's been a number of references in the testimony and in other aspects of things I've had to deal with since I've gotten to the board about the phenomenon of the railroads encouraging, particularly grain shippers, but others, to invest in facilities that would accommodate unit trains, and then they'd offer you unit train service, and of course it's at a lower rate than manifest service. And I've been puzzled by how businesses make these decisions. I think one of you talked about investing was that your $32 million to build such a facility? Yep. There's been others we've heard about. So could one or both of you tell me, how does this come about? And the railroad comes along and says, you know, we have this wonderful unit train option but you need to have a facility that can accommodate it. So if you spend the money, we'll provide the service. I take it there's no written contract between you and the railroad that says we're relying, or maybe there is, we are relying on your representation to spend this money. You can't cut us off, or maybe there is, or how do you make that decision to spend that money without some kind of assurance that you're going to have the unit train service for at least enough years to recoup the investment?
Well, that's the concern when you make that investment. But to be honest, when you're looking at our facility and thin margins that you have, we have to be competitive with our competition. And so railroads oftentimes know that. So if you're going to be competitive to the domestic poultry market in California, you're going to need to be able to ship that 100-car units to reach that market. If not, that spread from units to singles is about $1,000 a car, about $10 a ton, or about 24 cents per bushel from our standpoint when we look at being competitive there. And that's the difference in being competitive and not. So it becomes somewhat a cost of doing business, that if you're going to be a rail shipper and be competitive there, you have to go that portion, you have to make that investment. And I'll be honest, you take a leap of faith on some of this. That's why it's discouraging for us when we look at the PSR model now moving away from these units, because when we made these investments, and granted these were probably 10, 12 years ago, and for some of these investments, there was no mention of 24 hours to load a unit. Why would there be? We're loading private cars on our track. So how long it takes us to load inside our own facility is really inconsequential, because power was never left with that. What they assumed was, and we did too, is when the unit was done, they bring it in, it's blocked, ready to go as one unit, and out it goes. And that was it. And our whole return criteria was the spread between single cars and the unit shipments. That was our complete return criteria. And yes, we've thought about that in terms of when you enter into this, what keeps a railroad from changing with the stroke of a pen any tariff or any spreads out there and taking your return criteria for your investment away. That is definitely a concern, and that's happening now.
Well, I'm
as
sort
we
of
see this going forward.
Well, and it's even beyond that, isn't it? Because I hear that UP and others are saying we're going to just stop unit train service in some cases altogether. It won't be an option 24 hours or anything else. Is that, you're experiencing that?
In 3 of our 4 markets we reached by units as little as a year ago, yes, by June 1 through those 4 will be moving manifest service. Now, in fairness, they're protecting for now the unit train rate. The challenge becomes October 1 when they said they're covering things till September 30th. What happens then? If they take it and simply move us to a manifest rate, then our investment is worth nil now in terms of what we put into it.
You may not want to answer this, but I've really been curious about this, so as long as the subject came up. When the railroad, any railroad, came to you, anybody who's built a unit train facility, and says, if you do this, we will bring unit trains to you. What did those conversations actually consist of? Did they say, yes, but there's a risk, don't assume we'll always provide them, you proceed at your peril? Or did they say, trust us, we'll be with you forever? I mean, what was the actual nature of those communications, and were they written representations, or was it all just a handshake? How did that work?
No, there was nothing in writing as far as guaranteeing anything long term. Basically, they pointed out to us and others what the spread was going to be for single cars versus units, and then it was up to individual companies to make that decision if it was worth the investment to lower their costs relative to unit.
I mean, to be candid, I'm just thinking $32 million is a lot of money to write a check on a hope and a prayer.
Yeah.
Sort of mystifies me, but did you want to add something?
Because this goes back to ways when, several years back, even before the current situation, but exactly what you're talking about, where they were encouraged to invest in additional track and to update that, but there were no guarantees, and because they weren't servicing enough cars at that retail facility, they were stopped service. I don't know what the current situation is. This goes back a few years, but the situation you're talking about is exactly what happened, where they did make investment, upgrade their facilities, but there was no guarantee the railroad was going to be continuing to deliver the cars at that facility, because the volume to move cars there was not, good for the railroads. It wasn't conducive. So that issue, even before today, has taken place. This goes back a few years.
No, I know. I've seen it in other situations. That's why I wanted to just be enlightened on it. Randy.
Mr. Oberman, if I could add very quickly, I think the other thing that really grates on our members that report this to me is that when they decide not to provide unit train service any further and to go toward manifest traffic, it's on very short notice typically, we're going to change our model, we're going to switch over. It may be 3 months, 4 months down, and that doesn't take into account the amount of investment that the facility made and the return on that investment over time. And a couple of statements that have been repeated to me from the railroads has been, well, we didn't promise it would last forever.
Apparently not. I have a few more, but
So I think, Greg, in your testimony, you were talking about the push to private cars. And, I think you have some really helpful graphics explaining those dynamics. I guess I'm wondering, in your discussions with the railroads, what justification is given to you as to why you make the investment in private cars and now you're on less favorable terms than a system car?
Well, it's been a slow erosion as far as the return. When we first went into this and were really asked to invest in cars was probably about 1996, 97. The UP was very tight in terms of equipment. Then they were tight in terms of capital. And when you looked at what we could get for return on the cars, for instance, we took a point like Turlock, California, and Aberdeen, Washington, showed that the return, we got full mileage based on the value of the car. And that was somewhere in the neighborhood of $940, $950 per car. They took the first chip away when they went to zero-rated private car rates. And the rationale was pretty simple. Look, you don't need all these accountants. We don't need all these accountants keeping track of these invoices going back and forth. Let's just discount you on the rate in advance. And in theory, that makes sense rather than send invoices back and forth. But when that happened, we handed kind of the keys to the kingdom to the railroad on the private cars because now they're controlling what the allowance was and they arbitrarily kept moving it down. And part of it was unitized shipments. As they turned cars faster, they also took that spread down more.
What reason was given for the difference between the private car storage relative to system car demurrage in that private car? It sounded like from your testimony you were saying that the folks who own their own assets actually are being treated worse for the purposes of demurrage and storage than the folks that are using the railroad assets. And I'm just kind of wondering how those discussions have played out and if I'm hearing you correctly.
Well, yes, we do get charged more for private empty car storage than would be railroad demurrage. I don't have an answer for you because we've asked that question and you hear some of the talk about the track and their availability. The reality is their yard should never be more fluid than it is now. Because you think about it, we've added all this track in our facility. We're taking all these private cars into our facility. Their yards should be more fluid than they've ever been. So the notion that they're having to build more track to hold our cars, it's nonsense. Because we've never supplied a higher percent of our privates.
So for the system car kind of, let's say in constructive placement using railroad track and the private car,
right?
There's a difference there that disfavors the private car?
We are charged more for private empty car storage from both the Burlington Northern and the UP than we would demurrage for a system.
And if that car magically became a system car, it would be charged less. That's what I just want to make sure I understand.
Correct.
Okay.
And I think part of which is it coincides with the fact that at the time where the demurrage was higher, we supplied maybe 25% of our fleet, our own private fleet, and now we provide 90%.
Right.
And all of a sudden the charges have kind of flip-flopped now that we provide 90% of them.
I see. I appreciate it. And John, I think you mentioned some aspects of the fact that railroads don't take into account the costs on the shipper when they're making these changes. And I think you talked about kind of that the railroad says there's benefits for them, but they don't take into account, costs on you. Are you saying that when the board's thinking about the reasonableness, that is a suitable standard by which to evaluate the reasonableness of charges?
We think it's an important consideration for the board.
And so let's say, for example, there were to be a case. How would you go about trying to disprove railroad claims about benefits for their system?
I too have the benefit of being accompanied by counsel, and let me ask Jeff Marino to help.
Appreciate it.
I think that's a good question at this point. Exactly how to do that, a shipper doesn't have access to that information. I think some form of discovery would probably be appropriate in those circumstances because what you're talking about is a complaint proceeding. At the same time, the shipper does have access to the cost to it, and the railroad does not know what
Right.
the shipper's costs are. So there's that form of reciprocal discovery would be involved, and I think that's part of the course of litigation.
And it's your view, Jeff, that, you know, when the railroad puts forward every possible benefit it could have, you know, they're going to look and see, you know, what the effects are on velocity and dwell time and others. It's your view that that wouldn't create a standard that would be too costly to litigate, or that would be something that would be practical for the parties to get good information on both sides?
I honestly can't answer that question at this stage of the process. This is more kind of trying to develop ideas for further exploration. And I think the questions you're raising are valid ones that need to be addressed as part of the public comment process.
And then a question for Tom and Randy about notice and something that goes beyond the 20 days, you know, and I think there were some things connected about, you know, good faith effort and these types of things throughout the testimony. You know, correct me if I'm wrong, but there may be some types of changes where 20 days is sufficient notice. You know, we have these spreadsheets of changes, right? And not all of them are so significant. And then there are some that are more significant. And so I guess I'm trying to think about, from your perspective, two things. One is, what is adequate notice? And the second is, what's the trigger by which something needs beyond 20 days of notice?
Well, you're right. I mean, in some cases, 20 days works fine. And we've had some discussions with shippers like Greg and others in terms of where their assets they've made, you know, investments in tracks and other assets, and now they have to change. And it's not that they can't, but we've heard as high, you know, if there's going to be a substantial change to operations from unit train to manifest, maybe, you know, 180 days even, to enable them to recoup what they can out of the investment or minimize the cost, I guess, or the impact of that, and not, you know, just immediately strand that investment and become, you know, non-competitive.
Patrick, I think that's a really key question that we're going to be talking with our Rail Shipper Receiver Committee and our governing bodies about. I think that's a concept that came up in March at our convention, and I think it's one we need to drill down more and to kind of classify the kinds of tariffs we're talking about. There may be some that need over a year, given the amount of investment that's been made by a facility. So I'd kind of like to defer.
But that's how you're thinking about it, is there's kind of a major change threshold by which some things are major changes that deserve more notice?
Yes.
That's kind of the way you're thinking about it?
Yes, but we're just beginning to have those kind of discussions internally.
And then to be clear, during this window, status quo in terms of, or some sort of break from whatever the change effect would have.
Or transition.
Transitional phase.
Go ahead, Brett.
One thing just to add, we're talking about the unit shipments and so forth. In the case of some new plants being built, I know in talking to some of these ethanol plants, in order to get service from railroads, they were required, in the case, sometimes 3 loop tracks. So it wasn't a case of you want to ship singles or units. This was a requirement for us, the railroad, to provide service to your facility. And now I think about some of these same plants with maybe 300 cars of storage are going to be shipping everything out of single cars, which seems a real waste of money.
Were those, did those situations involve different communication? I've just got my lawyer's hat on here and I'm trying to figure out what kind of reasonable reliance is going on here, or whether the reliance was reasonable. So did those situations where you're building a new plant and the railroad said, we won't even come there if you don't build the loop?
I won't speak for AGP, but in talking to other folks who built new corn plants, we're told that they were required to build a certain amount of track, in some cases up to 3 loop tracks or 300 cars in space before they would provide service.
Just to follow up on a couple of other points that are left hanging here. When you said, Greg, that the railroads are now requiring you to build blocks of cars on your property before they pick them up, service they used to provide in their yard, you said.
That was communicated to us, that they wanted us to start blocking cars together. That was part of the conditions for them to still grant this unit car rate.
Well, that was a question I was going to ask. Did they lower the rate when you're doing part of their job?
Right, that was part of what they requested us to continue to do, to try to do pre-blocking of cars and to try to do level loading. And that was sent out in the same communication, said we're going to continue to honor your unit rate even though we're moving this unit as manifest service. So it was not a mandate at this point, but it always makes me nervous when the railroads request something because that usually means down the road it's going to be a charge.
All right, but it was sort of a trade-off when they raised it.
That was pretty much implied, that came with the fact that we're going to continue to haul our units at a unit rate even in manifest service.
Richard, I wanted to just follow up with you a little bit more on the nature of your members. These are retailers, but I assume we're not talking about some store you walk into. We're talking about a facility that has tanks and things to store liquid.
Farm supply dealers. So I've been to a lot of retail locations. They're all different. They have similar business. The farmers they're servicing sell similar products, but no location set up the same. But typically it's farmer customers is who they're servicing. But there are some of our members that are also a local hardware store, feed store, servicing their rural community, if that's what you're talking about.
Well, I'm trying to figure out how they're getting their train cars. Are these people that have tracks coming up to their facility?
Sure, they have tracks that come up to their facility for delivery, and some that are here within driving distance too. So I would invite y'all to come visit a retail facility if you haven't been to any, to see how they operate.
And I take it that most of the stuff that's coming by rail is by tank car, it's liquid? Is it fertilizer?
It can be dry too, but it depends on what they're selling to their customers, liquid or dry.
And is any of this TIH material?
In the Midwest for corn, it would be anhydrous ammonia, so it would be TIH material.
Because you've talked about, when pressure is put on to unload and things in short order, there's, after dark it gets more dangerous. I'm trying to picture the setup here, that's all. Is that what you're talking about?
Well, just that doesn't help the situation, but any of the products that are delivered, obviously when you're doing it at night, it's darker, it's harder to see. You always have additional issues. If they can do it during the daytime, it's more visibility, less safety risk. If that's where you're getting on. That's...
Well, you mentioned it. I was trying to just picture the facility.
We just think having the deliveries during the normal business hours, during the day, for the rail car unloading, it makes more sense from a safety standpoint too, versus during the middle of the night.
I assume if we're talking about incentivizing people to meet the 24-hour, you're talking about extra people. You may be talking about building floodlights or something so you could work all night, that sort of thing.
All of that, they would have to hire extra additional people, and particularly, I think it was mentioned too, if they're not showing up at the time they're supposed to be, you're having to pay the extra for those employees and keep them on until that delivery takes place.
All right. Thank you.
Could you clarify for me, because I think I have forgotten the answer, but for the move from the unit train to manifest, et cetera, is that primarily with UP at this point that you're talking about?
Yes, it was. Yeah.
Okay. And I also believe that, if I remember correctly, not from this morning, but initially when UP made this announcement last fall, I think it was one of their first announcements with their Unified 2020, the rate was not adjusted or held harmless through, I believe it was going to be through May.
I think it was through like April.
But then they've ultimately they've extended it
through the end of September. Yes.
So one of the things I'm curious to know is, so I guess overall, so the unit rates are more economical.
Yes.
But when you say you want to sort of like, you haven't said be held harmless, but you don't expect that your rate would never go up at all. It's just that it wouldn't go up as high as a manifest rate. Is that your hope?
Well, our hope was that the money we invested, we'd still have a return criteria. And if it goes to the single car rate, then any return we had based on that investment is gone. Yeah.
And does anyone want to talk about the NS congestion tariff or and this is a different issue, but the issue of the credits? I mean, it seems credits actually expire, don't they, at the end of the month? And so Greg, take it away.
Well, we're not served by the NS. I can tell you that credits to me are a little bit like a slot machine at the casino that doesn't have a cash out button. You can keep playing, but you can never get cash back. So, so if you can never walk away from it. So that's the issue I have with credits. It's sometimes they won't allow you to use those for different commodities. Sometimes you can't carry them over from month to month. So to me, the credit system too is a bit of a game. And so if you're going to have a credit, to me, if we make an insurance claim, we get a check from the insurance company. Be nice if there's an amount that's agreed upon as an amount, you can use that against future business in whatever way you want, not have it all these different ties to it.
And there's one carrier that does, so it's by individual location and by week, if I'm not mistaken. So it's that limited. Is that correct? Did I read it? I think I read that in one of the May 1st filings. Anyone? Sounds right?
Don't give anyone ideas.
Yeah, right.
So, John, when you had really helpful ideas, and Jeff, thank you for always being present behind someone, sometimes by yourself. When you talked about the need for reciprocity and the focus on that, and this kind of ties in with the questions that we were talking with the credits, but is it more, you're not saying give us a check, but rather have there be like a level, a trade, a fairer trade, rather so that like the credits would continue instead of being cut off or by month, or what are you envisioning? I mean, to make things more complicated really wouldn't help any of us.
Right, we're not looking for more complications in the system. We seek simplicity, and we seek reciprocity, and the limitations on credits are simply, as Greg said, it makes it a game, and so that's the fundamental concern. Jeff, do you have more to add?
Well, I think one of the issues with the credits expiring is you can earn a credit on the 29th of the month, and it's only good until the 30th, one day. On an offset, it would seem to make sense to at least have the credits if they're only going to last for 30 days. I mean, make them all last 30 days, not just based on a calendar month where they expire on the 31st, no matter when they were earned.
You mean a rolling 30-day? Kind of a rolling 30-day period, is that what you mean?
Yes.
Why should credits expire?
Well, that's a good question. I would say, it seems reasonable that you don't want someone 5 years down the road applying a credit that they earned 5 years earlier, but the question is, where should that cutoff be? Should it be 30 days, or should it be somewhere 60, 90, or a year?
Wouldn't the credit just be applied at whatever debit bill they have? I mean, if maybe they have no demurrage and then they carry it over 5 years. That would be a pretty rare situation if you had carry forward. Would you? Am I understanding that correctly? It would be a pretty rare situation that you would have a balance of credits if you accumulated over months that could be carried forward over time, right? I mean, there'd be no incentive to not
extremely
use
super
that.
efficient.
Yeah, there'd be no incentive not to just immediately offset the first debit that you get.
So as association representatives, not all of you, Greg, you're unique. There are always issues that shippers have concerns about, grievances about, frustrations about. And I'm curious to know to what level you are hearing from the people that you work for that got you to come and sit before us at this table. Is this a different set of pitchforks that you haven't been used to?
Yes. I think, to use an analogy, the crickets are chirping loudly. And I think there are 2 or 3 major issues that, and the Rate Reform Task Force, let me compliment them and you all, and particularly Chairman Begeman on.
The task force
good
gets
work.
the credit.
Well, they come up with a good body of work that needs to be explored. I think that issue, the accessorial and demurrage charge issues are really top of mind for our members right now. And so it's a big deal.
I would add that I think the crickets are roaring. This was a leading topic at our last board meeting. It was a matter of extensive discussion. And our members operate billion-dollar-plus facilities, and a number of them rely exclusively on rail for the corn that they're processing. They process a tremendous amount of corn in a facility. And also the discussion was that operations of these facilities that are built to operate 24/7 for 361 days a year are being slowed because they cannot load out their production. And so you have these massive facilities, very heavy capital investment, where the operation of the facility simply is being slowed down because there's not an ability to ship out. That is a very serious detrimental effect on our industry, and that's why I'm here to express the concern.
Because of the variability in delivery because of PSI.
Yes, yes.
So I just wanted to follow up on something.
I just want to finish up.
Oh, I'm
Just
sorry.
echo what-
I'm
what
sorry.
I just want to, it has been a growing problem. This is just kind of the latest thing. And besides dealing with this, I mentioned, trucking shortages, driver shortages, other transportation pressures. So some of these products, there aren't alternatives to try to look to move these products in an efficient way. And it's just kind of it's continued to kind of grow. And so that's why we're here today. Again, we want our members that working with the railroads want to be treated as equals. And they're, if we have members in our association, they have their customers, but it's really a captive customer for the railroads. And so we just want to make sure that there's fairness, and what NGFA has suggested, I think, would bring about some of that thing and more accountability. And to the point brought up, why should the credits go away? If the demurrage charges don't go away, so why would credits go away? If you're not going to have that equal system to hold them accountable. So this is just the latest in the number of things. The fuel surcharge thing was one, but given the ag economics that are going on right now, and having these additional charges just puts more pressure on our members.
If I could add
follow up
real
on,
quick,
I'm sorry.
not part of an association, but AGP.
Many would like you to be.
Yeah, but
Pay dues.
with AGP being owned by cooperative, a lot of our members are pretty motivated on this. And I've had several customers call me up that I had not talked to before, saw that my name was listed to be in front of the STB, and called me up and said, hey, go get them. Here's things we're hearing. Here's what's going on our end. And so I would tell you, I haven't seen that in my time in transportation. It is, people are energized.
Chairman Bigman, let me add just one thing to echo what Greg is saying. I've heard from non-members of NGFA, would you please plead our case? And for other industry sectors saying the same thing. And I think it's because they feel defenseless in this environment right now. It's one-sided, it's arbitrary, and there's just a throwing up of hands saying, we don't know what to do anymore without some parameters around these practices.
I just wanted to follow up on the reciprocity question that Ann asked, because we have heard from some shippers today who've said prior to these practices we never paid a penny in demurrage, and now all of a sudden we're paying a lot. So when you say reciprocity, we've also heard a number of people say that when the railroad is unduly holding on to a private car fleet, shouldn't they pay for the detention just the way you pay if you're holding on to their cars? So in terms of simplicity, and you sort of asked if we're asking to write a check, I thought I heard that some witnesses today are saying, yes, even if we don't owe you, if you're holding onto our cars, write us a check. Is that one of the things you're saying? Anyone?
Yeah, I'll add it in.
Yeah.
Yes, and you circle all the way back to the very first panel. True reciprocity takes into, credits are a piece of it. It's a start, but true reciprocity takes into account, the business losses, the investment, the harm to the investment in rail cars, harm to assets, business damages. And so that would involve something beyond just credits. And the simplistic, it's certainly, more complicated than it sounds, but the idea would be if the railroad is charging me, $10,000 for something that I've done, if the railroad does the same thing, the railroad owes me $10,000.
Well, what I'm wondering is, based on the actual experience, would it be to any of your groups or individuals' advantage to just say nobody pays? Or do you think if the railroads were paying you at the same rate you're paying them, do you think you'd come out ahead based on what's going on now? Do you think you'd come out about even? What's the experience? And also because the demurrage law says they want to incentivize you to get the cars moving. There's no statute that I know of that says you want to incentivize them to get your cars back to you, other than the general requirement that the practices be reasonable, and that may be sufficient, I suppose. Maybe there's some I'm missing here. Tom or Jeff can fill me in. I'm new here, but I'm trying to sort of gauge the magnitude of the problem.
That's a great question. That's the source of our frustration, is that we're being held to a standard they can't hold up themselves. And so I would say probably in our case, yeah, they'd owe us more than we owe them. Yes, based on the service I've seen.
So if you were offered the choice to say nobody pays anything or everybody pays what they owe, you'd come out ahead on the latter.
I think so. That's my opinion.
So maybe just one last comment. Maybe I'll regret it. Won't be the last time or the first time, but the one thing it seems that is being said for the many different shipper panelists is that this isn't really about being a captive shipper, but rather in this circumstance, every shipper is sort of being treated the same. I don't mean to imply that every railroad has the same demurrage or accessorial charges. They have their own. They have their own programs. But am I missing something that some like our captive shippers somehow feeling even further, I'm going to say put upon, but that's not actually what I mean. But I think that whether or not you're captive or you have options, I mean, Terry has options, and there are folks also that there have been a lot of witnesses that are exempt from board regulation that have still come to and have really interesting stories to tell and compelling, and so it seems that this is sort of an across the board treatment, and if I'm wrong on that, could you correct me?
I think you're right. I think it is across the board. I don't think they've singled out closed shippers and said we're going to treat them differently than any point of ours that has access open to other railroads. So I think you're correct.
Chairman Begeman, if I can supplement a response to Vice Chairman Fuchs' question earlier about cost-benefit analysis. Part of the question in the complexity is dependent upon the scope of that analysis and what are you looking at. So for example, if you're asking are the total benefits to the railroad on a one-size-fits-all approach across its entire system, do they outweigh the cost to every single shipper compliance? That's a pretty Herculean task. But I think this can also be cut into bite-sized pieces for purposes of analyzing demurrage free time, for example. Because as we've heard from many shippers today, some have been able to comply with the new rules because they have the extra track, they have the extra real estate in which they can build. Others are very constrained, and nothing they can do will avoid those charges. And a one-size-fits-all approach might have worked well, or at least acceptably well, when we had 48 hours or more of free time, because that at least covered, gave 99% of the shippers the ability to comply. But now that we're come down to zero, some shippers can, some shippers cannot. And the cost-benefit analysis could be carved into more of those specific situations of perhaps this one-size-fits-all rule doesn't fit all.
And Jeff, you're saying by the same token on the benefits of for railroads, it could be carved up looking at, could you even look at local yard? But it's very hard to just look at one aspect of the rail network. You know what I mean? If things are interconnected. So I get carving it up on the shipper side. Could you even do that on the rail side?
I think you could do that on the rail side. I understand the thing about rails being networks, but in terms of one or a few shippers who can't satisfy these particular demurrage times, well, what's the incremental impact upon that rail network going to be? I think if you look at it in that more bite-sized chunks, it becomes more manageable.
As long as we're talking about a regulatory approach that measures cost-benefit analysis, what I'm thinking about is, given the fact that in demurrage, not just the overall regulation, but demurrage is subject to a specific statute and governmental policy, which is incentivizing movement of cars. It's really not aimed at, that is, everybody, railroads and shippers alike, seem to focus on that. So I'm wondering if I guess it's for the Lord Jeff or for you and Tom, if we were going to consider some approach, should the cost-benefit measurement be not what's the benefit to the railroad, but whether the cost of complying is greater or less than the cost of paying the demurrage? Because otherwise, in one scenario, there's no incentive at all, and the other one there might be. Wouldn't that be the analysis?
I think that's one way to plausibly look at it, yes.
Before you're excused, first of all, thank you so much, and thank everyone in the room. So for our next panel, we have more, if everyone uses their allotted time, we will be 2 minutes after 7, and we won't have an opportunity to ask you questions. And we know you want us to ask you questions. If there are a couple of you local folks that would be willing to defer until tomorrow, that would be great. I don't know your schedules, but if there's any chance that any of you would be able to, again, we want to hear it from as many of you tonight as we can. But if there's someone who'd be like, yeah, I'll go tomorrow. Yeah, Jeff, thank you. That'd be great. Jeff Sloan, yay. Anyone else? I know there are folks that are traveling, that are local folks, or non-local folks may not be. Oh. Justin, thank you. That, Sandra, are you sure? You don't have to get on a flight? Okay. All right, so the next modified panel, please come forward, and thank you all again. And thank everyone for still hanging in there and listening to this, too. It's very fascinating. All right, we are going to start because otherwise we won't be able to get through. Larry? Actually, I'm not looking at the witness list. I'm seeing you. Please go.
Chairman Beckman and the entire Surface Transport Board. I'm Larry Burkowski, President and CEO of Brunk Plastic Services and Brunk Transport. Thank you for allowing us to present our testimony at today's hearing on demurrage, storage, and accessorial charges. Compared to the many large companies here, we are very small, yet the magnitude of these tariffs are equally or even more painful for such a small private company who is a third-party consignee, not the shipper nor their customer, with little pricing power or market leverage. We're a service provider. Despite our size, Brunk is the largest toll pulverizer of polyethylene for rotational molders, with also a tractor-trailer fleet of 20 units to transload plastic pellets from rail cars to our trailers to the ultimate customers. The NS Elkhart Hump Yard has delivered Brunk its rail cars for 25 years, and we were never charged a fee of any kind, receiving now some 600 rail cars per year. I'm certain that has helped make NS Elkhart Yard, our business has helped make them a very successful railroad. The tariffs were available for NS to use for years, but they never enforced them. And they provided the details to us on occasion, but never enforced them. In essence, only 45 days prior to January 1 of 2019, did they give us the full magnitude or scope of what they intended to do. We had no idea how serious they were about implementing the tariffs, and we were given no direction or guidance from them. Though market conditions dictate buying and selling surges by the shippers and their customers, we as the consignee bear the burden of these tariffs. And NS should have put the burden onto the shippers and their customers equally to make them understand the magnitude of what was going on. There's one particular large petrochemical plastic producer who sold 30 rail cars of material to one of our customers at the very end of last year that overloaded the Elkhart Yard, which led to us as one of the main reasons why we had so many customer caused congestion charges, which I'll talk about in a minute. We had to abruptly allocate storage space to our customers who were uninformed, seemingly by NS, thus risking our business by limiting their purchase potential. For Brunk, we work on very small margins but very high volume of rail cars. And our customers have options. They can go to Grand Rapids, Toledo, Chicago, other places. We're not the only game in town, unlike the NS Railroad. We had to evaluate 4-track lease options and negotiate the terms of multi-year leases, which added cost and complexity to our business. We actually had to rush through the lease terms and accept ones we never would have just because we were running out of time. NS did nothing to prepare us, even though 2 of the 4 options we looked at were companies who leased their track from the NS, and in some cases put us on what I would call a wild goose chase trying to find our best option with very little time. The winning lessor, a short line railroad called Elkhart and Western, needed time in the middle of winter to excavate and lay a gravel road for our tractor trailers to pick up transloads. We were lucky the weather was decent and only several weeks were lost, but it still took over a month for the road to go in. Our customers, many large distributors, or plastic distributors or producers, they needed time just to change their ERP systems, including putting in the new address for our second storage track at the Elkhart and Western, that the Norfolk Southern couldn't even figure out what the right address was for several weeks, leading to many billing errors, many of which came our way. Charging $60 a day for private car storage and $100 a day for discretionary customer cost congestion is too high. It's price gouging, where we charge sometimes nothing up to maybe $9.90 per day. The 24-hour grace period for rail cars arriving at the Elkhart Yard before delivery is not enough time considering our size and complexity. It should be at least 48, if not 72 hours, because it allows us to work within our own logistics of our 4 tracks that we have. In addition, they now come every day of the week, bringing only maybe 1 or 2 cars per day, instead of what used to be 3 days a week, Monday, Wednesday, Friday, bringing us anywhere from 2 to 5 cars. That means we have to shut our plant down every day, and whether they're bringing in 1 car or 3 or 5, it takes about the same amount of time. So this is great for NS. The Elkhart yard is completely void of all cars, but the burden has now fallen to Brunk, and I'm sure everyone else in this room that has a similar story. Also, in the future, monopoly railroads need to give more notification for changes requiring new track leases and other long lead time items. I don't know enough about the other people here to know what their issue may be. We needed more time than just the amount of time they gave us. By March 1st, the Elkhart yard was literally empty of all cars, including ours, because they come every day, while NSPSR, Precision Schedule Railroading, or Operation Clean Sheet, I've heard different terms, were accomplished 2 years ahead of their own published date. Because their target date was the completion of 2021. NS said on numerous occasions they would, quote, go to bat for Brunk with management, who they never identified, they never gave us access to, in seeking a delay of the new tariffs until April 1, even though we only need until March 1, so that our new track, our lease, our company, our customers were ready. Instead, they invoiced us $66,000, which came January, February, probably into March, of which 55 of the 66 were these very nebulous, arbitrary customer cost congestion charges, while also claiming this was not about the money. The customer cost congestion rules actually penalize us. If there's a slow period where cars are not coming in over a period of time, and then they should start piling up, we could get hit because of how they identify or how they define customer cost congestions. This is a huge financial burden for Brunk that we can't pay. And considering that NS has forever to reap the benefits, we asked the STB to step in and deny NS this money. I can't afford, I've looked into it, I can't afford to pay a law firm $150,000 to bring a case before the STB. So you just heard my case. So in closing, I also, a few qualifying things, it did come up. The credits that we get when they don't show up, which is fairly frequently, once a week maybe, the credits expire at the end of a month, even though when we have a storage fee, it's due. An error on billings, we had a recent error on a billing where they did an interplant switch for us, which has a fee of $250, we pay, but somehow in their system, they identified that car as a Brunk car, even though it belonged to one of our customers, and they started recording a storage or demurrage charge to Brunk, even though that car moved from one of our track to another track, which should have been a $250 charge. They ended up invoicing us $800, and it was up to us to figure out they screwed it up within their own system. And it's in dispute right now, but we know we're going to win it. Unfortunately, it cost my customer service manager and his manager something like 5 hours to figure out their error. And lastly, we haven't heard from NS in 2 months. Even though we owe them this money, I considered not coming for fear of maybe this thing will just go away. But I decided it was worth it because, again, some of the overarching issues I think are good for the industry. They gave us too short a period of time to get a new track lease. Their fees for storage and customer are just too high. It's just not right for the industry to have to bear that. Thank you.
Thank you. Barbara? I'm sorry, I probably should have started with you, but...
No worries. My name is Barbara Hagler, and first off, I want to thank the board for their time today, especially as we get into this late hour. We appreciate you holding the hearing and would absolutely love the opportunity to participate in more hearings like this regarding service issues and other issues that we are having. Also want to thank you for your work with the Rate Reform Task Force. I need to read into it a little bit more, but I know it's much needed, and again, we appreciate that as well. I am the logistics manager for Auriga Polymers, a wholly owned subsidiary of Indorama. I have rail logistics responsibilities throughout North America. I was to be joined by John Fields, but unfortunately, due to health issues, he could not come, and our Senior VP of Procurement and Logistics is here, Mr. Hussam Awad, to join me as well. The purpose of our testimony today is to draw attention to the unreasonable revisions in Norfolk Southern rail tariffs and to request your assistance in seeking immediate resolution to stop the sustained damage being caused by the NS to our Indorama affiliated companies in general, but in particular the additional demurrage charges we're seeing at StarPet Incorporated in Asheboro, North Carolina, who is captive to the NS. Indorama has 8 manufacturing plants throughout North America, and with the exception of Mexico and Westlake, Louisiana, all Indorama facilities have been negatively affected by NS service failures and changes to NS operations due to their effort to initiate precision scheduled railroading. 3 Indorama businesses are captive to the NS, StarPet and Asheboro, as I've already mentioned, and then AlphaPet and Indorama Ventures, Xylene and PTA in Decatur, Alabama. As you know, in October of 2018, NS issued freight tariff NS 6004D relating to demurrage storage rules and charges. It's a revision to the 6004C, which was effective back in 2017. The revised tariff made various changes, including those to private cars, which are the matters we want to discuss here. The first revision it issued by the NS is to item 600, the rules governing cars held for loading. Reduced the number of credit days from 2 to 0, as we've all discussed today, that'll be earned for each empty private car under construction placement. The second pertinent change that NS made to this tariff is item 1010, which reduces all private car storage from 2 loading and unloading credits again to 0 loading and unloading credits. As a result, railroad-controlled cars are given 1 credit a day for loading and unloading, as I understand it, and private cars are given the 0. But we only use private cars, so my knowledge of the railroad-controlled cars is not as much as the private. These changes have resulted in storage charges being assessed upon shippers across the NS network, regardless of whether the shipper is diligent in loading or unloading operations. Specifically, with respect to StarPet, these NF tariff changes have in fact created immediate demurrage penalties. StarPet has advised NS on numerous occasions that its practices, including these tariff changes and changes to the points and yards where our CP occurs, are unreasonable and unfair. The facts in support of StarPet's objection to its recent demurrage charges are as follows. As part of their precision scheduled railroading initiative, NS simultaneously made multiple changes affecting StarPet's operation. They reduced train starts between Linwood and High Point, North Carolina, from 2 a day to 1. NS changed the way that StarPet was able to order in cars. Rather than our historical daily order of 7 empty cars, 7 PTA cars, and 3 glycol cars, StarPet must now order a total number of cars, and NS brings the cars easiest for them to deliver. StarPet then does not receive the correct mix of cars. NS has changed CP locations for StarPet from High Point, North Carolina, to Linwood, North Carolina, to Spencer, North Carolina, without notice. Furthermore, they would then move the cars onto Greensboro and Lexington while still under constructive placement. StarPet has no control over the location of the cars in the area, and some of these locations take 2 days to deliver to StarPet, and demurrage cannot be avoided. Despite being shipped according to a rateable schedule, our raw material cars continue to bunch, making it impossible to bring all of our cars in at once. These changes by NS have resulted in over 200 rail cars costing over $100,000 per month being added to our fleet to compensate for NS service failures and to protect our market share. Multiple production slowdowns at StarPet, as well over 30 failures at customer sites in Georgia, Ohio, and North Carolina, causing schedule alterations and truck deliveries. StarPet lost a sales of 1 million pounds per month at a customer only 2 miles of empty track from StarPet due to an embargo not related to StarPet until the customer could convert to receiving trucks. In addition, over the 20 months from January 2017 to August 2018, StarPet had a total of $540 in demurrage. So over 20 months before the changes, $540 total. Once CP placement was changed to multiple yards, we are now being charged over $20,000 per month. This happened with no deviation in StarPet operations other than trying to accommodate to NS tariff changes while maximizing our production. StarPet is constantly forced to react to changes by Norfolk Southern to its rail service and demurrage tariffs as it relates to the Asheboro site over the past 24 months, including many occasions of lowering production and near-miss shutdowns. In spite of these continuing unacceptable service events, StarPet remains committed to a partnership with Norfolk Southern. While at the National Freight Transportation Association annual meeting in March of 2019, we had a quick meeting with NS upper management and requested a more detailed sit-down in Charlotte, where we are headquartered, to go over all the issues we're having. NS responded with a date a full month and a half after our requested date. This speaks to NS's lack of urgency to help right the issues these changes in service failures have caused. Now, once we informed the NS that we are aware of the scheduled hearing today and that we plan to participate, they did offer an earlier date at another location, but unfortunately it wouldn't work with our schedules. Despite continued attempts by Indorama to resolve this conflict, NS ultimately returns with the same response. The charges were determined to be correct as billed. Quantities in High Point fluctuate from next to nothing to complaints of overflowing the yard. This is done by NS operations, not at our request. Demurrage charges for StarPet site now total over $150,000 as of May 8, 2019. Although we do not believe any of the demurrage penalty charges are valid, in view of the unreasonable and unfair initiatives, we offered to put some amount in escrow just as a good faith measure until this matter is resolved. However, NS rejected our offer. NS did offer to send in a third party to StarPet site to evaluate our operations with a view toward pushing more rail cars onto our property and reducing the dynamic track space used by StarPet to do switching and organize outbound loads and empties. We refused such direct calls to StarPet by the third party. NS then offered an in-house entity to evaluate StarPet site, which was also rejected because NS does not possess the expertise or have StarPet's best interest at heart. We believe NS is only looking for ways to use the customer property to subsidize their service failures. We have no leverage to cause NS to correct its unreasonable tariff changes and CP practices before costing StarPet thousands of dollars. With no way to recover these losses, except to use the only possible avenue available to shippers, which is appearing before the Surface Transportation Board. We do not take this lightly, and we feel we've been very patient. We see potential violations of two ICCTA provisions that may be considered here. 49 U.S.C. 10702, which requires that a railroad establish reasonable practices related to transportation service, and 49 U.S.C. 10746, which requires that demurrage charges fulfill two enumerated national needs objectives. While there has not been a case that deals with the situation where a railroad applies 0 credit days for storage purpose, the case law requires some credit days or time for a shipper to reasonably deal with the cars it receives from a railroad. The reasonable standard applies to demurrage. Due to time constraints, I had a whole bunch of examples in my written. I'm not going to go through them, so just wonderful. So I'm going to skip to the last page. NS claimed on December 4th, 2018 letter to the STB that they're only making these changes to properly align stakeholder incentives with improving our asset utilization, because using assets more efficiently will lead to network fluidity and better service. However, these demurrage storage changes have not had that type of impact. The only impact has been a substantial increase in its revenues for demurrage and storage charges. For example, NS also increased a one-day demurrage charge by 50% from $100 to $150 in the tariff without any basis. Based on the reports that the NS has submitted to the board this year, NS's quarterly review for demurrage has skyrocketed from approximately $55 million in the first quarter of 18 to $79 million in the first quarter of 19. In other words, in 1 year, the amount of revenue earned per quarter from demurrage has increased by nearly 44%, and it's not gone unnoticed by their stockholders. In April 24th, 2019, a stock note regarding NS issued by Wolf Research, the analyst noted that NS yields were higher than expected for the first quarter of 19. Higher accessorial charges boosted yields by 90 BP, and we expect this tailwind to accelerate in second quarter as NS benefits from a full quarter of charges. While NS says one thing to its regulator, it says another to its shareholders, and the numbers do not lie. NS is only making these changes to increase its revenue at the expense of its customers like Indorama. Alan Shaw, NS Executive Vice President and Chief Marketing Officer, acknowledged during a 2018 Rail Trends Conference the railroad's strategic plan was delivering financially. but not on service reliability and consistency. To be clear, Indorama's position on these tariff and service changes has not changed. They are unreasonable and unfair, and we believe they should be rolled back to mirror the 2017 tariffs. Thank you for your attention today.
Thank you. Bruce?
Good evening, Chairman Begeman, Vice Chair Fuchs, and Member Overman. So my name is Bruce Ridley. I'm Senior Vice President, Environmental Health and Safety and Operational Services for Packaging Corporation of America. I'm also Chairman of the Board of Directors of the National Industrial Transportation League, and joining me is Karen Booth, who I think you all will know. So I have 40 years of experience in transportation and supply chain arena. I was previously a member of the Surface Transportation Board's Oversight Committee. So this testimony today is being provided in my role as the NIT League Chairman. So the League, first of all, wants to thank the Surface Transportation Board for addressing rate reform and for holding this hearing and collecting data from the nation's railroads on their demurrage and accessorial charges. The League and its members have serious concerns about these changes that the Class 1 railroads have implemented in their demurrage and related tariffs, and their effect on rail customer operations and cost, and ultimately the nation's consumers and economy at large. So in announcing this hearing, the board noted that the railroads are required to establish reasonable rates and practices for demurrage and related charges, and that demurrage should be designed to fulfill national rail car hire needs and usage. The board has asked whether the current demurrage and accessorial tariffs are commercially fair, and if they have created a balanced and appropriate incentives for both the customers and the railroads. So NIT League members have been adversely affected by changes in the railroad demurrage rules and accessorial charges in a variety of ways, depending on the options of the shipper or the receiver. However, I'm going to simplify my testimony to highlight some of the most common concerns. First one is free time reductions. So over the past 3 years, all Class 1 carriers have reduced free time for their loading and unloading of railroad-owned cars or for the holding of cars constructively placed on the railroad tracks from 5 days to 2 days and now to 24 hours for railroad cars and 0 days for private cars. The reduction in free time has been particularly difficult and costly for shippers and receivers at closed gate sites and those that do not have 24-hour coverage. The railroads generally make no commitment to meet a shipper or receiver's schedule or service needs, and a missed delivery by the railroad disrupts operations by preventing the customer from timely loading product or receiving materials needed for its production. Under the current restrictive free time rules, a missed delivery by the railroad often results in demurrage or storage charges, since the shipper or receiver cannot immediately rewind its operations or output or easily find additional track capacity to hold loaded cars or empties that may be backed up. It's common for the railroads to have a wide variation in the timeliness of deliveries, and in some cases 24 hours or more. So you might say railroads are consistently inconsistent. And I think that if you listen to a lot of the testimony today, the root cause to a lot of the issues are first mile and last mile consistently inconsistent. They refuse to agree to service performance standards and provide themselves with maximum flexibility, but they impose a rigid one, a size-fits-all, free time window of 24 hours or less for their customers. This is too restrictive and commercially unfair based on the railroad's own service availability. Moreover, given the complexity of the rail customer operations and the time, money, and difficulty involved with constructing new facilities or acquiring additional track capacity, many rail customers have not been able to avoid the substantially increasing demurrage or storage charges due to the reduction in the free time. Allowing free time of at least 2 days or more would be more reasonable rule that's better aligned with the variable operations of both the carriers and their customers. Bunching and demurrage. Amplifying the effect of free time reductions is the issue of bunching. Bunching occurs when cars accumulate in the rail system and then they're all delivered at once at a shipper or receiver's facilities, regardless of its actual delivery, often overwhelming the customer's ability to handle the cars. Bunching can occur for a wide variety of reasons. Virtually none of these reasons are the fault of or in control of the shipper or the receiver. For example, many railroads will charge demurrage when bunching cars occurs on an upstream carrier or when they miss a service call, resulting in cars accumulating in the railroad's yard. For private cars, there is no free time and storage charges begin to accrue after the railroad provides notice that the cars are available and if the receiver is not able to order in all the cars by midnight on the same day. This is true even if the railroad provides notice at 11:59 p.m. So if the railroad-owned cars are involved, the number of cars overwhelm the receiver's ability to handle them, then charges start within 24 hours when the free time is exceeded, even though it was the railroad's actions and not the shipper's or receiver's operations that actually caused the problem. Even if the railroad does provide relief for its own errors, which could encompass bunching, there is no standard across the railroad, and it often bills for the charge and then requires the shipper or receiver to apply the credit or dispute the charge. This process itself can be time-consuming and requires the customer to have the data needed to support its position, which it may not always have. So in 2014 decision in the Ex parte 707 demurrage liability, the board declined a request by NIT League to amend the proposed demurrage rules to account for rail car detention that was caused by rail carrier. In that decision, the board indicated that the receiver could, quote, solve the problem by pursuing a complaint with the board. But the option of filing a complaint to dispute what might be a single charge is not realistic given the time and cost involved with the STB litigation. And also our exempt commodity shippers really don't have access to this process either. It is also not a reasonable solution since the bunching which resulted in the charge was caused by and cannot be prevented by the receiver. So the board should revisit the decision of Ex parte 707 and consider adopting a rule prohibiting the receiver from being charged or requiring extension of free time when that bunching or other railroad conduct prevents the receiver from avoiding the charge. This would be commercially fair and reasonable. Another concern for the NIT League members is the NS congestion charge. Here, NS assesses the consignee $100 per day per car charge for all cars destined to a location that, in the sole judgment of the Norfolk Southern, is an excessive quantity of cars that congest NS facilities, causing material operating problems. NS may assess that charge for cars that exceed 2 times the average number of cars that the consignee has received at that location during the previous 2 weeks. The tariff rule appears arbitrary because its application is solely within the judgment of the railroad. There are no standards for what constitutes a congested facility and material operating problems, and there is no standard for determining whether the exercise of the railroad's sole judgment is rational. Additionally, congestion charge is applied on top of the usual storage charge. So even though the storage charge already includes a penal incentive to encourage the prompt removal of the cars held in the railroad yards, thus the purpose underlying both the congestion and storage charges appear to be the same. And by assessing both charges, the railroad is penalizing the consignee twice to incentivize the same conduct, resulting in double recovery. The league believes that there are legitimate questions as to the reasonableness of this congestion charge. Lastly, I'll talk about the burden of proof. Other challenges involve dispute resolution. Within implementation of PSR, there have been reductions in railroad customer service personnel, which has made disputing railroad invoices even more difficult and time-consuming. Some railroads have failed to include both the date and the time that a car has been constructively placed in their demurrage or storage invoices, which hinders efficient dispute resolution. The board should require the railroads to provide shippers and receivers with the data they need to dispute a charge that they believe has been assessed improperly, and to identify and make available knowledgeable personnel who can help address disputes promptly. The league believes that the board should take several actions to ensure demurrage-related charges are reasonable. They're in my written testimony, so I'm not going to go through them today. I will finish with 2 personal comments, not NIT League comments. These are Bruce Ridley comments. So in the first quarter of this year, finally settled CSX demurrage bill that was from 2017. And about a month ago, I finished one that was for 2018. And one of the big issues there, and Member Overman, you've talked about it, is they talked about the day of placement, but they would not give us the time And as you recognize, the time of placement is very critical to determine when that 24-hour clock starts. So that was a really big, a lot of man hours were put into that because we didn't have the data we needed. The other thing I'll mention, just two other comments. Yard-to-yard efficiency improvements that we're seeing that they're reporting, that's great. Issues are first mile and last mile. So that doesn't take that into account. And then if your efficiency increase is over 2018, my only comment is that's a pretty low bar. So, thank you.
Thank you. Justin?
Thank you. Good evening, Chairman Begeman, Vice Chairman Fuchs, and Commissioner Oberman. My name is Justin Lockheim. I am Director of Government Affairs for the Fertilizer Institute, TFI. TFI is the National Trade Association representing the fertilizer industry, including companies that are engaged in all aspects of the fertilizer supply chain. 50% of crop yields are attributable to commercial fertilizers, feeds the plants that feed the world, which is expected to surpass 9.5 billion people by 2050. Overall, the U.S. fertilizer industry generates approximately $154 billion in economic benefit annually, provides nearly 90,000 direct jobs throughout our nation, including 1,300 in South Dakota, 2,200 in Wisconsin, and 6,100 in Illinois. On behalf of TFI and our members, thank you for holding this hearing and for your oversight of railhead demurrage, storage, and accessorial charges. So a lot of information has been discussed today, being the last to testify today, and thank you for letting me come back on here. I'll largely summarize TFI's written testimony and add a couple additional thoughts. So an additional thought. Beyond demurrage and accessorial charges, the market fairness of them, today's hearing is about implementation of precision scheduled railroading, PSR, and the direction of the rail industry. From TFI's perspective, PSR represents an obsession with operating ratio, which is driven by short-term Wall Street gains over long-term business planning, which would be more beneficial to all stakeholders in the U.S. economy if we had a more long-term outlook. This also reflects a lack of competition in the rail industry. This kind of behavior does not happen in other shipping modes, and we wouldn't be having this conversation if shippers had other options. That said, the disregard for rail customers combined with ever higher rates has resulted in some modal shift from rail to truck for fertilizer. For example, rail rates for ammonia, an essential fertilizer used by farmers, has gone up over 200% over the last 15 years. So more specifically to this hearing and regarding PSR, it often means reductions in crew and power. When the weather gets, one example here would be when the weather gets extremely cold up north, train lengths must be reduced due to the interaction of the cold weather with the brake lines. When this happens, more crews and power are needed to move cars. As I understand and as I'm told, yard crews are often pulled from the yards onto the main lines. This doesn't leave enough people in the yards, however, to move cars, and as a result, operations often get plugged up. Communication is another challenge for our members. The electronic means of communicating where cars are located is great when everything works as intended. However, when cars are missing or there are delays, I'm told that communication is often frustratingly lacking on the first and last mile. In particular, it's not often clear who a shipper can contact to actually resolve a delayed or lost car. So as it relates to this hearing, and back to sort of more of my written testimony now, and this will be much briefer than the written version, the most significant complaint for TFI's members are the reductions to free time for demurrage and storage charges. In most instances, free time is now just 24 hours for demurrage and 0 hours for private car storage. Our members have designed their operations and infrastructure around a standard of 48 hours and have suddenly been forced to redesign everything in less than 45 days' notice in most cases. By far the most significant obstacle to compliance with reduced free time standards is inconsistent rail service, as many have already spoken to. Bunching is the most common reason why a facility cannot receive rail cars upon arrival at a terminal. Bunching can overwhelm our members' limited storage track capacity at their facilities. Bunching also makes compliance with the reduced free time standards more difficult because when cars are bunched, that means a customer is receiving some cars later than they are needed for plant operations. Consequently, TFI members often must keep more rail cars at their plants as buffer capacity that would be needed if railroads provided would be less needed if railroads provided regular and consistent service. So inconsistent rail service is probably the greatest obstacle to compliance with a number of these charges. Rather than targeting inefficient behavior, the free time reductions appear to shift certain costs associated with PSR from railroads to shippers and/or create new revenue streams for railroads. This is a challenging situation that lacks market fairness and reciprocity. TFI members accept that when they are at fault and disrupt rail operations, it is fair that railroads assess charges. However, railroads also should compensate shippers for railroad actions that disrupt shipper operations. TFI urges the board to use this hearing as a stepping stone to provide clarity and guidance for rail and shipper stakeholders alike on appropriate practices. TFI recommends the board issue a policy statement that sets forth standards the board will consider when evaluating the reasonableness of these practices. Key elements of that policy, guided by market fairness and reciprocity, should include the following principles. The benefits of demurrage and storage rules to rail operations must outweigh the costs to consumers of complying with those rules. Demurrage and storage practices are not reasonable if their principal objective or result is to generate revenue. Railroads may not assess charges for problems that arise from their own service deficiencies. Railroads may only charge shippers for behavior that disrupts rail operations if the railroads reciprocally pay comparable charges to shippers for behavior that disrupts shipper operations. The cost to the shipper of actions taken to avoid demurrage and storage charges must be reasonable. Railroads must allow customers a sufficient time to comply with changes to demurrage and storage practices that would subject the customer to such charges in circumstances where they previously did not apply. Finally, TFI asks the board to exercise its authority to investigate railroad practices without complaint, to initiate an investigation into the recent free time reductions by Class 1 railroads, and ultimately to declare these reduced time frames unreasonable. Thank you again. Appreciate the opportunity to be here and your focus and attention to the hearing all day and up to this evening hour.
Jump right in. Justin, you mentioned kind of the biggest issue being free time, along with inconsistent service. And I think, Bruce, one of your suggestions was to declare 0 hours of free time to be unreasonable. We've talked a lot about the credit system and other charges, but just kind of honing in on free time. Is that the only amount of free time that people believe to be unreasonable? In other words, 48 hours preferred, but does anyone believe 24 hours to be unreasonable?
Not as unreasonable as 0. I think 48 hours has worked really well in the past, and people had geared up, a lot of their operations based on that. So yeah, 0 is totally unreasonable. 24 is less, I guess.
And so talk us through how you all think about the reasonableness of free time. Like, what should if the board were to assess it on a situation by situation basis, for example, how should we be thinking about what a reasonableness of free time is?
So if you look at our members, you got a wide variety of operations out there, whether you're shippers or carriers. Some are 24/7, some work weekends. Some, if they know they're going to get a switch on Saturday, they'll bring people in. Some people can't do that. So it goes back to what we were talking about, or you were all talking about earlier. I think you have to look at a lot of this on a case-by-case basis, where the railroad works with the individual customers and says, what makes sense for your facility, and can we do this? So personally, I know one facility at PCA, we were not there on Saturday, but we give them the keys to get in the door, and they do a switch on Saturday, even though we're not there. So we come in Monday morning, we got it there. In the past, we weren't able to do that because we were shut down, but in order to accommodate them. But again, it was a case where the shipper and the carrier got together and worked it out, what made sense.
If I can supplement that, there's a question that hasn't been asked or raised by anyone today, and believe it or not,
Silly 6:30.
Why is the free time for private cars different than the free time for railroad supplied cars in demurrage? The demurrage rules are, the railroads give 24 hours. On the private cars, that's where the 0 free time comes in. But if you think about it, the railroads have a common carrier obligation to provide the rail car. When a shipper provides the private car, though, that relieves the railroad of that obligation to supply that car. If the railroad had supplied the car, there would be no demurrage for 24 hours. But a private car is occupying the railroad's track capacity for the same amount of time as the railroad supplied car. So why should a private car owner pay a storage charge during the time the railroad would not assess a demurrage charge? The logic seems to escape me in that one. I think that's a key part of assessing the reasonableness of the storage.
And Jeff, if I'm not mistaken, there are instances where the private car storage fee
is greater than the demurrage fee, such that by going and investing or leasing private car for the exact same situation, not only would you have a free time difference, you would actually have a rate difference as well.
Yes, you would.
And Bruce, you mentioned first mile, last mile, truly being key. And, we've talked a little bit about ETAs and, so kind of, can you maybe, what are some measures that the board would look at, in terms of evidence when you look at whether or not, last mile was successfully fulfilled? Is it missed switches, or what should we be looking at?
Missed switches is a big part of it. Obviously, the bunching along the way as they build the longer trains. I've seen 140-car trains, believe it or not. So again, it's all of that. And then depending on our customers, a lot of that first mile and last mile now is the short line railroads. And so, you have to get into some of the transparency on the, the electronic side, how to roll the short lines in with the class 1s to keep that metric. So it's a difficult metric to have the railroad say, you need to provide me with that first mile, last mile, because they may or may not have that information.
And you talk about the importance of time, not just day. What is the practice in terms of providing time? Some of the railroads have mentioned in their testimony the idea of kind of mobile entry units and their training staff for some of their services. What is your experience with that, and what visibility do you have in terms of time relative to day?
So when you're doing a quick look in the pipeline, you can usually get an ETA or in times. You can see when it left the yard and all that.
Right.
When they send you your demurrage bill, or even worse, when you get the demurrage bill that has come through the claims department, they'll give you, the car number, and they'll give you the day and all that, but they won't have the time. And so when you try to go back and see, whether I had an issue with my plant personnel not getting it unloaded or not releasing it or not placing it, that time of day is critical.
Is it your view that the time exists and it's not provided, or that the railroads need to do a better job at recording time, or both?
So this was with CSX, so I do not know whether they would not provide it or they could not provide it.
I'd just like to follow up on that, Bruce, and a couple other points. So you don't record the time when you get notified of the placement?
That's.
I mean, you could, right?
Well, we do with the individual, yes, sir, we do record that. But we couldn't match that with the records from CSX because they didn't. So that's how, through many painstakingly hours of research, that's how we were able to agree upon what was our part and what was the carrier's part.
So you had to go through your records to find the time to match up with the car number or whatever was there's some obviously identifying mark on the demurrage bill as to what car they were talking about?
Correct.
A lot of people have used this hypothetical on the no free time about, well, they could deliver the car at 11:59. In the real world, is that happening, 11:59, or what's the range, or is it all over the map?
It depends on the facility, so it depends on the railroad and depending on, which we have some that get very consistent service, especially if there's a short line in between. Usually if there's a short line in between, you get some pretty good service. Class 1 directs, depending on the facility, where you are in the delivery, it's all over the map. Not only from what time of day, but to whether it even gets there that day, because they run out of crew time, and then that crew has to start at the end of the last day instead of beginning the first day and try to make it all up, and it gets out of whack.
So it's not an extreme hypothetical to say that sometimes you do get notice at 11:59. I mean, that actually happens.
That's true.
I want to talk about the NS congestion charge. It's been mentioned a couple of times. I didn't find it in your written testimony, but I think you said there's a threshold that they can only even charge it if they have twice the number of cars that they've delivered to you in the last 2 weeks. Could you define that for me again?
That is exactly why I brought Karen with me.
Okay. Yeah.
I mean, I think the NS could probably describe it best, but we do have it in the written statement, and it basically just
But maybe I missed
regurgitates
it.
the
Yeah.
NS railroad tariff rule on page 6 of the Knit League statement here.
And it's,
But essentially, the tariff allows the NS to charge $100 per car per day for cars destined to a location that the NS would designate as congested. And it does that in its sole discretion, as we understand it. And they determine if there's, I guess, an excess quantity of cars at that yard that has to also cause what's in the tariff material operating problems, which then allows the NS to hold the cars there and charge them or move them at other locations. But they do define the excess quantity of cars to be essentially 2 times the average number of cars that the consignee has received at that location during the previous 2 weeks. So it would be a rolling 2-week average.
all right, so that, in other words, the number of cars exceeding twice the number in the last 2 weeks is a measure of how much they charge you, but not a measure of whether they declare a congestion.
Correct.
And whether they declare a congestion
You'd
is
have to
not
ask
defined.
Folks out there, right? So I think the concern that the league was raising was the arbitrariness, the potential arbitrariness of the rule, and the inability for there to be any standards that the shipper could understand what qualifies as, you know, a congested yard, what qualifies as the material disruption.
In actual practice, since this rule's been in effect, has anybody been able to discern a pattern from NS's actual behavior?
We have $66,000 in invoices, and 55 of them are customer cost congestion.
I understand.
But they've gone
and I
away
was
now.
going to ask you about your particular problem in a minute, but I'm talking about in general, going forward. Do you, or does anybody have an idea?
I would say, like, we've talked, I think I mentioned this, but I'll just reiterate. I mean, if we go through a quiet 2-week period where not many cars are coming, bad for NS and bad for us and our potential business, and then things pick up, by definition, if we go 2 times over 1, so 3 cars, that third car they could define it. And in reality, there'd be no congestion there, because on any given time period, we may get 3 or 4 cars showing up in any given day. Over many days, it's, you know, we would have like 3 to 5 cars that might be showing up and then at their Elkhart yard before they get delivered to us.
So let me follow up with you, Larry, because I had, in reading your statement and what you talked about today, just to try to condense it, you seem to be saying that when NS instituted its new congestion charge, you did have discussions with them, and you had discussions about delaying imposing the charge till you could change your practice. And they, on the face of it, said, yes, we'll do that, and then they didn't do it.
They
Is
said
that in effect what
they
happened?
said they would go to bat for us.
Yeah. Well, go to bat, they're the railroad.
Well, it was
They're
a
going to bat with
salesman.
themselves? I don't understand.
Yeah, and we assumed that, well, they wouldn't have said it at all unless they meant it. Otherwise, they should have just said no.
Because I assume you were here, I asked NS specifically this morning, do you go to a shipper and say, if it's going to take you time to comply, we'll consider not imposing, if you show us you're going to comply, we'll give you some time before we slap the charge on you. Sounds like that was the discussion you had, but they didn't.
Right, but I don't think they answered. I think the other companies answered. I don't think they did, and we're not the shipper.
No, they said they would, they have done it, and they would consider doing it. I asked them specifically about Olin needing a year to.
Missed that.
Yeah, I mean, it was
But we're not
general.
the shipper anyway. We're like some third party.
Yeah,
We're a consignee. We're a nobody.
Do you think that makes the difference?
I think if you're Dow Chemical or Exxon, possibly with options, we have no option. We're NS or bust, or we don't exist.
Well, there are many others that have been here today who are large who didn't have options either. But
Yeah.
I just wanted to make sure I understood what you were saying. I
Right,
thought that's
exactly.
what it was. Getting back to the first mile, last mile, when I asked Matt Brainerd about this, he said that he doesn't have a first mile, last mile problem on the yards that are served by short lines. But nationwide, what we're hearing is that PSR is moving trains fast across the country, but not the first mile, last mile. So, Bruce, you said that you have a lot of service from short lines. Are you still getting inconsistent delivery even where the short lines are taking the last mile?
Usually the answer to that is yes, but lots of times it's short line, it's got trackage, and they will actually store some empties or store your loaded vehicles, cars for you to make up to the train. So even if you miss one switch or don't get a delivery that day, you can. There's some buffer in there, I guess.
They can soften the blow. Sometimes they can soften the blows, what you're saying. But overall, whether there's a short line or not, and Justin, you seem to be saying this, you're not getting good service, but you attribute it to the first mile, last mile problem.
I haven't heard from my members issues with short lines, with the main lines, class ones. It's been, first mile, last mile has been a point of frustration. In a lot of cases, things are okay. It's kind of when something's delayed or missing, the various electronic means to track stuff doesn't really, in a lot of cases, isn't working the way it's intended, perhaps. And people don't locate the car, they don't know when it's going to arrive, and for some facilities, especially rural ones, where they don't have 24/7 staffing.
Well, that's what I was getting at, as to what is it about PSR that makes this first mile, last mile problematic? I think you said, I think somebody earlier today said, but I'd still like to flesh this out if there's anything more to say. Does it mean that the class ones have fewer crews and fewer locomotives running in a yard to make switches, and therefore that's the cause of it?
Yes.
Is it?
Yes.
Is it just that simple?
Maybe more, but like Brunk has a facility in Bloomington, Minnesota, served by a short line, Progressive Rail. We have no issues with Progressive Rail. We're on their track. We have to.
That's because they're progressive.
They're progressive. But in Goshen, Indiana, we're served by the NS, and we're on their rail. So there is no short line to service us. It would almost, in some respects, be better if there was, because we get better service from the short line. And I think PSR means NS and all the other railroads, they just want to take cars from New York to California, from hump yard to hump yard, and not have to deal with customers that are on their line. That's my interpretation.
And the basis of all you saying that, yes, that's the problem. There's just less staffing, whoever, and I think coined it, somebody did less with less and so forth. But how do you know?
What I was told.
Well, it was good turn of a phrase. But so how do we know that, though? How do you document that? Your people are told that by the railroad, saying, well, we don't have a crew, we can't make the switch.
Well,
how does that happen?
Like for us, and I said this, I'll repeat it one more time, we liked getting 3 days a week delivery, Monday, Wednesday, Friday, even if they missed, and Monday became Tuesday, and Wednesday became a double on Friday. And they were bringing us 3 to 5 cars on those 3 days. Now they're claiming it's of value, I don't know to who. They're now coming every day to bring us 1 or 2 cars. It shuts down our production facility. So I don't know why, like when my customers, we negotiate on terms, pricing, delivery, and everything. With NS, there's no negotiation with them around that. We're saying, please just come 3 days a week and bring 3 cars. How could that really cost you more? Does it really change your costs? Come on, I don't believe it.
Thank you.
Barbara, if I could ask you, and it's not strictly directed at you, but I will ask it of you. Shippers and railroads have, a love-hate relationship. You need each other. And I'm curious to know if, what was your, relationship with Anna before have we always had like various complaints and frustrations, or is it just suddenly you're like, what?
Yes and no. We've been dealing with the NS and the railroads for years, And our relationship always has been a little bit love-hate, but by far in the last 2 years, it has exponentially, I would say, gotten worse. We feel helpless, and we are, we're not an enormous company, but we're a good-sized company, and to feel like we don't have any other choice or other negotiating options, it's difficult, and it's when you have continued conversations and you're trying to come up with new ways, and you're even trying to do, we have had many meetings with the NS and the other railroads, giving them market analysis of here's what our market is, and we want to help you understand who we are, what we do, and what we're dealing with. And they'll sit there and they'll nod their heads and say, that's great. And then they go back and then they say, but nothing's changed, and we're not doing anything to help or act like we've made any difference in the way they want to try to help us. It doesn't feel like a partnership at all anymore. Definitely a one-way street.
If I may, just one example, our manufacturing sites require 2 feedstock material in order to make the final product at certain ratio. So the Norfolk Southern changed the way we ordered the rail cars to quantity rail cars. So it doesn't matter if it's this feedstock or empty or the other feedstock. But chemistry doesn't work that way. We need 3 cars of this product and 1 car of this product to make this product. So far, they're still at the quantity ordering. So even though we explain to them in simple terms, when you make a cake, we need some flour, some sugar, some eggs, right? It's not the same ratio. They still don't get that. And speaking of PSR, I think PSR to me is pressure customers' resources in order to make them more efficient.
I know that Kenny had an opportunity to come in and help us understand a few things after his panel tomorrow. NS, if you'd like to come and help us better understand congestion, tariffs. We kind of ran out of time, and I had some questions that I would have liked to ask. But if you don't want to take us up on that opportunity, perhaps for the written comments that are due in 14 days, I struggle to understand how there could be a material operating problem that's being caused to necessitate such a fee, while at the same time you just testified how you've never, and it's true that the metrics show that you are doing better service-wise than you have in several years. So to me, there's sort of like kind of a disconnect in messaging and impact to your customers. Bruce?
The real scary thing about that is if it goes through, we got 6 other railroads that are going to be right behind.
You mean on the congestion pressure?
On the PSR connection as well, I think a witness earlier this morning summed up what I think is part of the problem. The problem is that PSR is doing what it's less with less or more with less. It's still with less. And resiliency was the key issue. When everything's running fine, it may be doing quite well, but a slightest hiccup and suddenly that impacts the entire the network. And if the customers do not have buffer inventory at their facilities, then they're in shutdown or slowdown situations. And these demurrage charges are now penalizing the customer for maintaining that excess inventory.
Would anyone like to make any closing comments? Yes, you have 6 minutes. Actually, you need to be out of the building in 6 minutes. Someone pull the fire alarm.
I just have one thought that's probably may not be SCB's purview, but my one thought, just with the forum, and I know the railroads are listening, is I think a little more carrot, maybe a little less stick, would be a good path forward.
We are hungry, by the way.
That's all.
Thank you. And Larry, I realized you were the person I cut in front of this morning. I apologize. I cut in front of other people as well. They were gracious and just let me through. And thank you, Betty. But Larry, I don't think you knew as far as I knew, you were an ITC person coming to talk. Anyway, thank you for getting over it. All right, thank you all very much. Appreciate your time, and thank everyone for working to juggle the schedules for tomorrow. Greatly appreciated. It's been a long day, and tomorrow will be as well. So thank you. Looking forward to it.
Will there be a follow-up communication with where this is headed, and if the STB is going to look into unfair CCC practices or number of free days that could change? I mean, I'm still sitting on a $66,000 invoice that I don't know what to do.
Okay, I think that our Rail Customer and Public Assistance Office will try to help you with having a conversation with the carrier, just so you get some clarity.
Okay.
And yes, there will be more to come, but it won't be announced today.
Okay. Thank you.
Thank you. We also have another day of testimony to hear from. Maybe we'll be convinced that none of this was true. Just kidding.